endorsement has been given, which has been asked for, sought for the quashing of this, and state trade is the mandate.
Annexure A.
Yes, madam.
So
page number 12, madam. Annexure A. Tahsildar has given an endorsement.
ಪಟ್ಟೆ ಜಮೀನಿನ 3 ಎಕರೆ 16 ಗುಂಟೆ ಪೈಕಿ 23 ಗುಂಟೆ ಜಮೀನನ್ನು ಕಂಪ್ಯೂಟರ್ ಪಹಣಿ ನಮೂದಿಸುವ ಬಗ್ಗೆ.
I'm just coming to the point. Before coming to this endorsement,
they have extracted some
and state trade is the mandate.
Annexure A.
Page number 12. Tahsildar has given an endorsement.
ಪಟ್ಟೆ ಜಮೀನಿನ 3 ಎಕರೆ 16 ಗುಂಟೆ ಪೈಕಿ 24 ಗುಂಟೆ ಜಮೀನನ್ನು ಕಂಪ್ಯೂಟರ್ ಪಹಣಿ ನಮೂದಿಸುವ ಬಗ್ಗೆ.
Before coming to this endorsement,
they have extracted some
and state trade is the mandate.
Annexure A.
Three parts of the case will not see this petitioner is in.
Previously, I filed a writ petition.
Yes, we filed.
Where is that order?
Page number.
Annexure? 40.
Page number 40.
So,
wherein there was a direction to the Tahsildar, and 3 months time was given to.
Non-accomplishment of a khata transfer, arguably on the basis of grant.
And according to this, so we given an application with documents. See, the big fact is not this petitioner is being granted the land, which is paid.
Provided the grant is found to be genuine.
Yes.
After verification.
And subsequently, pursuant of the grant and mutation came to be executed in my name, and my name is changed in the RTC also. Up to 2001, 2002, my name is extracted.
Hey, why are you going back? The orders passed by this court is that they have to verify the grant register, find out whether it is true that the grant was made. If that is so, they enter the name. What has happened now?
According to that, thereafter, to be given the representation and to the Tahsildar.
ಅದಕ್ಕೆ endorsement ಕೊಟ್ಟಿದ್ದಾರೆ.
Given an endorsement.
ಏನಂತ?
And that endorsement.
That there is no such grant found.
No, it is not like that. See, according to the prayer of this annexure A, that is an endorsement. I'm just read out. Page number 14.
ಪೂರ್ತಿ ಓದೋದು ಬೇಕಿಲ್ಲ.
Page number 14. ಅದರಿಂದ ರಾಜ್ಯ ನಿರೀಕ್ಷೆ ವರದಿ ಮತ್ತು ನೀವು ಹೇಳಿಕೆಯಂತೆ ಪ್ರಸ್ತಾವಿತ ಜಮೀನಿನಲ್ಲಿ ನೀವು ಯಾವುದೇ ಕೃಷಿ ಚಟುವಟಿಕೆಗಳಿಗೆ ಯಾವುದೇ ಅನುಭವದಲ್ಲಿ ಇರುವುದಿಲ್ಲ. ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಪ್ರಕರಣ ದಾಖಲಿಸಿಕೊಂಡ ನಂತರ ಜಮೀನುಗಳು ಕಲ್ಲು ಬಂಡವಾಳ ತೆರವುಗೊಳಿಸಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಅಲ್ಲದೆ ನಿಮಗೆ ಮಾನ್ಯ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ರಾಮನಗರ ಪ್ರಕರಣ ತೋರಿಸೋ ರೇಷ್ಮೆ ಇಲಾಖೆ ಜಮೀನು ಮಂಜೂರಾಗಿರುವುದು ಪ್ರಶ್ನಿಸಿ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿದ್ದು ಸದರಿ ಪ್ರಕರಣ ವಿಚಾರಣಾ ಹಂತದ ಬಾಕಿ ಇರುವುದರಿಂದ ನೀವು ಸಲ್ಲಿಸಿದ ಮೂಲ ದಾಖಲೆ ನೈಜವಾಗಿರುವುದರಿಂದ ಹಾಗೆ ಸೋಯಿಸೋ
land has been granted to Sericulture Department.
I am coming to the point that is 6 RA annexure O page number 44. They are referring this order RA that is in annexure O page number 44. Page number 44. An order passed by Assistant Commissioner. It is totally different. It is not concerned with the sericulture. And this is the, because of not made the Pani in my name, I approached the RA.
Yes.
In the last operating portion, I'll just read out next page. Page number 45. Operating portion, the ಪ್ರಸ್ತಾವನೆ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ವಾದಿ ಮೇಲ್ಮನವಿಯನ್ನು ಭಾಗಶಃ ಪುರಸ್ಕರಿಸಿದೆ. ಮಾಗಡಿ ತಾಲೂಕು ಕಿಪ್ಸಂದ್ರ ಹೋಬಳಿ 17 ಸರ್ವೆ ನಂಬರ್ 27 ರಲ್ಲಿ 3 ಎಕರೆ 16 ಗುಂಟೆ ಪೈಕಿ 23 ಗುಂಟೆ ಜಮೀನು ಸಂಬಂಧಿತ ಮಂಜೂರತೆಯ ನೈಜತೆ ಮತ್ತು ಮಂಜೂರತೆಯ ಷರತ್ತಿನ ಉಲ್ಲಂಘನೆ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಿಕೊಂಡು ಕೈಬರ ಪಾಣಿ ಮತ್ತು ಮೂಲ ಮಂಜೂರ ದಾಖಲೆ ಸರ್ವೆ ದಾಖಲೆಗಳನ್ನು ಸ್ವಾಧೀನ ಪರಿಶೀಲಿಸಿಕೊಂಡು ಭೂ ಕಂದಾಯ ಸೂಚಿಸುವ ಪ್ರಕಾರ ಪುನಃ ಪರಿಶೀಲಿಸಿ ನಿಯಮಾನುಸಾರ ಇಂಡೀಕರಿಸುವ ಬಗ್ಗೆ ಸೂಕ್ತ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ತಹಸೀಲ್ದಾರ್ಗೆ ಡೈರೆಕ್ಷನ್ ಮಾಡಿದೆ. This is an order passed, but they given an endorsement. This appeal is pending, and moreover, that is concerned with the sericulture. This is a total opposite to the what they have said in the endorsement. My respectful or sufficient, my lord, even in page number kindly 37, 38, 39, my lord.
ಪಾಣಿಯಲ್ಲಿ ಏನಾದ್ರು ಸೆರಿಕಲ್ಚರ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಬಂದಿದೆಯನ್ರಿ?
Actually, Pani stands in my name, my lord. That is the page number 32.
Then what is the difficulty? What is the difficulty? Your name is standing in the RTC and in difficulty.
Problem, I am cultivating the land. I am producing the 37, 30, 39 photographs I produced, my lord. Because of that endorsement, I could not make that because I am in possession of the property and cultivating that from 40 to 50 years, right from the grant. All the entire document stands in my name up to 2001, 2002. Because of computer RTC was not there, I approached the court. But whatever they given endorsement, that is total opposite to the RA order, which I have read out now. ಈ ಆರ್ಡರ್ಗೆ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಸೆರಿಕಲ್ಚರ್ ಅಂತ ಹೇಳ್ತಾರೆ ಟೋಟಲಿ particular that is what I read out now.
24/5/2023.
Please do.
So this order is part on 24/5/2023. Into the Nimbara on 38/2023.
5/6/2023. What is notice or annexure P?
Annexure B. Annexure B is the grant certificate.
ಸಂಬಂಧಿಸಿದಂತೆ ನಿಮ್ಮಲ್ಲಿ ಇರುವ ಅಧಿಕೃತ ದಾಖಲೆಗಳನ್ನು ನೋಟಿಸ್ ತಲುಪಿದ 1 ವಾರದ ಒಳಗಾಗಿ ಹಾಜರುಪಡಿಸುವಂತೆ ಈ ಮೂಲಕ ತಿಳಿಸಿಕೊಳ್ಳಿ.
Even according to that also, annexure P, they given on one endorsement, you should kindly turn to page 46, my lord. In pursuance of the honorable High Court order, they given a notice to petitioner, page number 46, annexure P. According to this, your lordship, ಇದರಲ್ಲಿ ಎಲ್ಲ ಪೋರ್ಷನ್ ಅಲ್ಲಿ ಬಗನಿಗೆರೆ ಸರ್ವೆ ನಂಬರ್ 27, 23 ಗುಟ್ಟೆ ಜಮೀನಿನ ಮಂಜೂರಾಗಿ ತಿಳಿಸಿದ್ದು ಮಂಜೂರಾತಿ ಸಂಬಂಧಿಸಿದ ನಿಮ್ಮಲ್ಲಿ ಅಧಿಕೃತ ದಾಖಲಾತಿಗಳ ನೋಟಿಸ್ ತಲುಪಿದ 1 ವಾರದ ಹಾಜರುಪಡಿಸುವಂತೆ ಹೇಳಿದೆ. Thereafter, according to thereafter, immediately very next your lordship, annexure Q, page number 48. I given a detailed representation to the Tahsildar. In pursuant to their notice. Annexure Q.
Please come to page number 13.
13.
Second paragraph ಓದಿ.
ಮಾನ್ಯ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ರಾಮನಗರ ಉಪವಿಭಾಗದ ಸೂಚನೆಯಂತೆ ಉಲ್ಲೇಖ 3 ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರು ತಿಪ್ಪಸಂದ್ರ ಹೋಬಳಿ ವರದಿ ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರು ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರು ಮತ್ತು ಸಂಬಂಧಪಟ್ಟ ಗ್ರಾಮಾಡಳಿತ ಆಡಳಿತಾಧಿಕಾರಿಗಳು ಬಗನಿಗೆರೆ ಗ್ರಾಮ ಭೇಟಿ ನೀಡಿ ಸ್ಥಳ ಪರಿಶೀಲನೆಗೆ ಚಿಕ್ಕಸಂದ್ರ ಬಗನಿಗೆರೆ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 27ರಲ್ಲಿ 3 ಎಕರೆ 16 ಗುಂಟೆ ಜಮೀನು ಒಟ್ಟು ವಿಸ್ತೀರ್ಣವಿದ್ದು ಈ ಪೈಕಿ 2 ಎಕರೆ ಭಾಗ್ಯ ಶ್ರೀನಿವಾಸ ಮೂರ್ತಿ ಖಾತೆ ಪಾಣಿ ಆಗಿದ್ದು ಉಳಿಕೆ 1 ಎಕರೆ 16 ಗುಂಟೆ ಸರ್ಕಾರಿ ಗೋಮಾಳ ಕಟ್ಟೆಯಿಂದ ಪಾಣಿ ದಾಖಲಿಸಿರುತ್ತದೆ. ಸದರಿ ಜಮೀನು ಬಗನಿಗೆರೆ ಕಾಲೋನಿಗೆ ಹೊಂದಿಕೊಂಡಿದ್ದು ಯಾರು ಅನುಭವದಲ್ಲಿ ಇರೋದಿಲ್ಲ, ಯಾರು ಉಳಿಮೆಯಿಂದ ಪಾಳು ಬಿದ್ದಿದ್ದು ಮತ್ತು ಸದರಿ ಜಮೀನು ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಆದೇಶ ಸಂಬಂಧಿಸಿದಂತೆ ರೇಷ್ಮೆ ಇಲಾಖೆಗೆ ಮಂಜೂರಾಗಿದ್ದು ಇಂಡೀಕರಣ ಆಗಿರಲಿಲ್ಲ. There is no absolute document regarding the sericulture ಅಂತ stating only. ಹೊಂದಿಕೊಂಡು ಆಗಿರುವುದಿಲ್ಲ. ಸದರಿ ಅರ್ಜಿದಾರರು ನೀವು ನೀಡಿರುವ ದಾಖಲೆ ಸಂಖ್ಯೆ 83ರಂತೆ ನೀವು ಮಂಜೂರಾತಿ ನೈಜವಿಲ್ಲವೆಂದು ದಿನಾಂಕ ನೀವು 19 ವರ್ಷ ವಯಸ್ಸಾಗಿತ್ತು ಮಂಜೂರಿಗೆ ಅರ್ಹ ಇರುವುದಿಲ್ಲ ಎಂದು ಮಾತ್ರ ನೀಡಿರುತ್ತಾರೆ. ಹಾಗೆ ಅರ್ಜಿದಾರರು ನೀವು ಮತ್ತು ರೇಷ್ಮೆ ಇಲಾಖೆಗೆ ಮಂಜೂರಾಗಿದ್ದು ಸರಿಯಷ್ಟೇ, ಆದರೆ ಸದರಿ ಆದೇಶ ಹಿಂದಿಯ ರದ್ದಾಗಿರುತ್ತದೆ, ಅವರು ಅನುಭವದಲ್ಲಿ ಇರುವುದಿಲ್ಲ. ಸದರಿ ಜಮೀನಿನ ನಾನು ಸುಮಾರು ವರ್ಷಗಳಿಂದ ದನ ಕರಗಿಸಿಕೊಂಡು ಬಂದಿದ್ದು ಹಳೆ ಕಲ್ಲುಗಳನ್ನು ತೆಗೆಸಿ ಅಚ್ಚುಕಟ್ಟು ಮಾಡಿ ಅನುಭವದಲ್ಲಿದ್ದೇನೆ. ನನಗೆ ಮಂಜೂರಾತಿ ಆಗಿರುವುದು ನಿಜಾಂಶ. ತಾನು ಹಾಲಿ ಮಾನ್ಯ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಮತ್ತು ಹೈಕೋರ್ಟ್ ಪ್ರಕರಣ ದಾಖಲಿಸಿ ಹೇಳಿದೆ ಗ್ರಾಮಸ್ಥರು. ಈ ಲೋಡ್ಶಿಪ್ ವಾಟ್ ಈಸ್ ಹ್ಯಾಪನ್ಡ್ ಇಸ್ ಎಕ್ಸಾಕ್ಟ್ಲಿ after issuance of the notice by the Tahsildar, we given a reply as per that.
Learned HCGP takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned HCGP. Full stop. Next para. Learned counsel for the petitioner submits that in spite of a specific direction having been given by this court, WP number 15321 of 2022, dated 31st of October 2022, that the respondent authorities are required to verify from the original records regarding the grant said to have been made by the petitioner and if it is found such grant was indeed made, comma, then to proceed to mutate the name of the petitioner in the land records and continue the same in the computerized RTC, comma, the fourth respondent Tahsildar has issued the impugned endorsement at Annexure A, giving unacceptable reasons that the petitioner would have been about 19 years old when the grant was made, and therefore the grant could not have been made. So, Learned Counsel submits that this clearly shows that the Tahsildar is refusing to look into the original grant register. So, it is submitted at this stage. It is not within the competence of the Tahsildar to say the grant could not have been made, comma, without getting the grant cancelled in a manner known to law. Stop. Next paragraph. There is substance in the submission of the Learned Counsel for petitioner. Stop. The respondent Tahsildar, Magdi Taluk, is hereby directed to furnish the original grant register and Saguli issue register and mutation registers on the next date of hearing. Full stop. Release this matter
not to interfere with the position
on
cultivating the position of property
27th of February 2024. Full stop. Next para. Till then, the respondent authorities are directed not to do anything in respect of the land in question. Right. Seventeen and AB. 17. Same person. Same order. You have to appear before the Assistant Commissioner on 20th of March.
Madam, consider my application file under form 50 of to revise my unauthorized application.
When did you file the application?
9192, my lord.
And till date, they have not passed orders.
Your past regularization committee has rejected my application.
Ah.
I approached the assistant commissioner.
Ah.
Assistant commissioner has set aside the order.
Ah.
Subsequently, direction has been given to the Tahsildar to conduct spot inspection and to submit a report before the regularization committee. That has been done by the Tahsildar by Annexure B, my lord. On the direction of the Tahsildar, Charles Surveyor has conducted a spot inspection and prepared a sketch identifying the possession of the petitioner for the subject property at page 16, Annexure B. ಈ ನಕ್ಷೆಯಲ್ಲಿ ಬಣ್ಣದಿಂದ ಮಾಡಿರುವ ಪ್ರದೇಶವನ್ನು ಬೋರೇಗೌಡ ಲೇಕ್ ಬೋರೇಗೌಡ ಇವರು ಬಗರುಕುಂ ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುತ್ತಾರೆ.
When was it made? What is the date when this was made?
Prepared subsequent to order of the assistant commissioner.
How can you say? How can you say? There is no date here. That order was passed by the Assistant Commissioner
The year 2003.
in the year 2004.
In RA number 75 2003-4.
That is 2/10/2004.
8/10/2004.
8 ಅದು Annexure A.
Yes, my lord. Annexure. Annexure 8/10/2004.
ಅದಾದ್ಮೇಲೆ ಏನು ಮಾಡಿಲ್ಲ ಅಂತ.
ಅದಾದ್ಮೇಲೆ ಏನು ಮಾಡಿಲ್ಲ. They prepared a sketch for identifying the possession of the petition. The regulation committee has also at Annexure, my lord. Annexure E, page 32, my lord.
ಎಲ್ಲಿ ಜಾಗ ಇದು? ಮಂಡ್ಯ,
Mandya.
KR-ಪೇಟೆ. Learned HCGP takes notice for all the respondents. Learned counsel for para. Next para. The grievance of the petitioner is that in spite of a specific direction being given by the Assistant Commissioner, Pandavpura subdivision in RA 75 of 2003-2004, by order dated 8 already adu
8 Manoj, in the page 15 in the bottom it's showing 8 Manoj.
8/10/2004. Setting aside the order of rejection passed by the committee and remanding the matter back for reconsideration of the application filed by the petitioner in form number 50 for regularization of unauthorized occupation of 4 acres of land.
Out of 4 acres, 2 acres, 20 guntas.
2 acres and 20 guntas of land in survey number 3 of Uchanahalli, Chilanere Hobli, Keapete Taluk, neither the Tahsildar has placed the application before the committee, nor the committee has passed any orders. Stop. Next para.
Sorry, Manoj. At Annexure E, my lord. Regularization committee. At Annexure E, it's page 32. The regularization committee, my lord. Has taken a note of the order of the Assistant Commissioner. And to consider the same on the elegance, but they have not considered it. Regularization committee munde put up agide. Regularization committee munde put up agide. Page 30.
At this juncture, learned counsel for the petitioner draws the attention of this court to Annexure E and submits that the Committee for Regularization of Unauthorized Occupation has taken note of the directions issued by the Assistant Commissioner. However, nothing further has been done after 7/3/2018. So, next para. Having regard to the undisputed facts noticed herein above, which are supported by documentary evidence, the repetition stands disposed of with a specific direction to the fifth respondent, Committee for Regularization of Unauthorized Occupation, Kearpete Taluk, to afford an opportunity of hearing to the petitioner, and thereafter pass necessary orders on the application filed by the petitioner who has sought for regularization of unauthorized occupation. So, the committee shall pass necessary orders as expeditiously as possible and at any rate within a period of 3 months from the date of receipt of a copy of this order. Full stop. Ordered accordingly.
Not, the petitioner has been granted with 3 acres 20 guntas of land in the year 1990. Thereafter, my lord, in the year 2012, the Tahsildars come up with a report that he was not in possession of the entire acre of 3 acres 20 guntas and cancels the grant. That order has been challenged before the Assistant Commissioner. The Assistant Commissioner confirms the order of the Tahsildar, which has been challenged before the Deputy Commissioner. Deputy Commissioner reminds back to the Assistant Commissioner. Assistant Commissioner, my lord, the page number 55, Annexure N, passes the order directing the Tahsildar to reconduct the survey by giving notice to the petitioner hearing and conduct a survey and passes a necessary order. Lordship will get the Adesha at page number 58.
That was also passed in the year 2019.
19.
You are filing a writ petition now.
Now what has happened without affording an opportunity to me, my lord, revenue records has been changed without issuing notice. Principles of natural justice, my lord, my land has been taken away and the order very specifically states that ಸಾಗುವಳಿ ಚೀಟಿ ನೀಡುವ ಮುನ್ನ ಅರ್ಜಿದಾರರಿಗೆ ನೋಟಿಸ್ ನೀಡಿ ವಿಚಾರಣೆ ನಡೆಸಿ ನೀಡಲು ಸೂಚಿಸಿ. Without notice, my lord, now the mutations has been changed. Lordship will get the mutation at page number 65.
ಅರ್ಜಿದಾರರ ಅರ್ಜಿ ತಿರಸ್ಕರಿಸಿದೆ.
In the sense it is also remanded back. In the sense, my lord, the operative portion is that it has to be sent back to the Tahsildar. ಅರ್ಜಿದಾರರ ಅರ್ಜಿ ತಿರಸ್ಕರಿಸಿ ಆದೇಶಿಸಲಾಯಿತು. ತಹಶೀಲ್ದಾರ್ ಅವರು ಸಲ್ಲಿಸಿದ 108K ಅಡಿಯಲ್ಲಿ ಸಲ್ಲಿಸಿರುವ ಪ್ರಸ್ತಾವನೆ ಪುರಸ್ಕರಿಸಲಾಯಿತು ಹಾಗೂ ನಂತರದ ಎಲ್ಲ ಪ್ರಶ್ನಿತ MR ಗಳನ್ನು ಅರ್ಜಿದಾರರಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ರದ್ದುಪಡಿಸಿ ಆದೇಶ.
Come to page number 57.
57.
Internal page 3 of the order. ಕೆಳಗಡೆ ಇದೆ page number.
3.
Second, third paragraph ಓದಿ.
ಅರ್ಜಿದಾರರ ಅರ್ಜಿ ತಹಶೀಲ್ದಾರ್ ಅವರ ವರದಿ ಹಾಗೂ ಎದುರಾರರ ವಾದಿ ಪರಿಶೀಲಿಸಲಾಯಿತು. ತಹಶೀಲ್ದಾರ್ ಅವರು ಸಲ್ಲಿಸಿರುವ ಭೂ ಮಂಜೂರಾತಿ ರದ್ದುಪಡಿಸಿರುವ ಪ್ರಸ್ತಾವನೆ ಭೂ ಕಂದಾಯ ನಿಯಮ 108K ಅಡಿ ಪರಿಶೀಲಿಸಲಾಯಿತು. ಮೂಲ ಮಂಜೂರಾತಿದಾರರಿಗೆ 2012 ನಡವಳಿಕೆಗಳಂತೆ 3 ಎಕರೆ 20 ಗುಂಟೆ ಮಂಜೂರಾಗಿದ್ದು ಅದರಂತೆ MR ನಂಬರ್ ದಿನಾಂಕ 30/7/2012 ಖಾತೆ ಬದಲಾವಣೆ ಆಗಿರುತ್ತದೆ. ಆದರೆ ಸ್ಥಳ ತನಿಖೆಯಂತೆ ಪರಿಶೀಲಿಸಿದಾಗ ಮಂಜೂರಾತಿ ಆಗಿರೋದಕ್ಕೆ ಜರಿ ಹಬ್ಬ ಬಿನ್ ಭೂ ಬ್ಯಾರಿ ಅವರು ಕೇವಲ 1 ಎಕರೆ 15 ಗುಂಟೆ ಮಾತ್ರ ಸ್ವಾಧೀನದಲ್ಲಿದ್ದು ಉಳಿದಂತೆ ಸ್ಕೆಚ್ ನಲ್ಲಿ ತೋರಿಸಿದಂತೆ ಬೇರೆ ಬೇರೆ ಸ್ವಾಧೀನ ಅನುಭವದಲ್ಲಿರುವ ಬಗ್ಗೆ ತಿಳಿಸಲಾಗಿರುತ್ತದೆ. But my lord, there was no survey conducted. So the assistant commissioner finally comes to the conclusion that after giving notice, my lord, the Tahsildar has to conduct a fresh survey.
See rule 108K.
Cancellation of grant.
Yes, please read.
Any grant of land made under this chapter shall be liable to be cancelled and the land resumed by the assistant commissioner where the grant has been obtained by making false or fraudulent representation or is contrary to these rules, provided that no such cancellation shall be made without giving the grantee an opportunity of being heard. So, my lord, this is where my case stands.
What is their contention now?
Contention, my lord, after this assistant commissioner orders, I have not received any notices.
What is their contention?
Contention is that I am in the occupation of 1 acre 15
Of only 1 acre 15 guntas.
Out of 3 acre 20.
And their rest is?
Rest, according to the Tahsildar's report, my lord, I am not in possession.
Who is in possession?
That the report doesn't say so, my lord, but my case is that I am in possession of 3 acre 20 guntas of land.
Previously, in the order of the deputy commissioner, in the order of the assistant commissioner, there is anything?
Lordship, may kindly see the order of the deputy commissioner, my lord. Type copy you get at page 54.
54. Anything regarding it?
No, my lord, the order of the deputy commissioner is not on the merits. Not on the merits. Case called out advocate for appellant present. Replace statement by assistant commissioner so far not submitted.
Remanded back.
Remanded back. This is the remand order, my lord. There is one more order, Lordship may also see Annexure Q, page 61.
See, going by the plain reading of 108K, there is no case for instituting proceedings for cancellation. They have not said anything that he has given any false information. How could they institute the proceedings under 108K? What is their contention? Please see the first order of the assistant commissioner. Where is the first order of the assistant commissioner?
Annexure L, page 43, my lord.
This is the first one.
Yes, my lord.
The first one.
Yes, my lord. 2016 order.
Huh?
Yes, my lord. 27/2016 order.
They have shown you as the appellant.
I had challenged the order of the Tahsildar, my lord. I had.
Yeah, Tahsildar has no power to cancel it, sir.
Yes, my lord. That is it, my lord. I am.
Where is the order of Tahsildar?
Tahsildar order I have not produced. Prastavane.
What are you challenging before the Assistant Commissioner?
ತೀರ್ಥಹಳ್ಳಿ ತಾಲೂಕು ಅಗ್ರಹಾರ ಹೋಬಳಿ ಕೋಲಿಗೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ಸ್ ಅಲ್ಲಿ ಕೋನಂದೂರು ವಾಸಿಸಿ ಸೋ ಅಂಡ್ ಸೋ ಎಂಬುವರು 3 ಎಕರೆ 20 ಗುಂಟೆ ಜಮೀನನ್ನು ಸಂಬಂಧಿಸಿದ ಬಗೆಹರುಕಂ ಸಕ್ರಮಕರಣದ ಮಂಜೂರು ಮಾಡಿರುವ ಜಮೀನು ರದ್ದುಪಡಿಸಲು ಕೋರಿರುತ್ತಾರೆ.
ಯಾರು? ಯಾರು ಕೋರಿರುತ್ತಾರೆ?
It is a suo motu action by the Tahsildar, my lord.
How can they show you as the appellant?
I have been aggrieved by the order of the Tahsildar.
Huh?
Order.
Where is the order? There is no order of the Tahsildar. ಏನ್ರಿ? Huh? Please clear in your mind. What are you doing?
Kindly see page number 44, my lord.
If proceedings have to be initiated under 108K, it is for the Tahsildar. You cannot become the appellant there. ಯಾರು ಕೋರಿರ್ತಾರೆ? ರದ್ದುಪಡಿಸಲು ಕೋರಿರ್ತಾರೆ. ಯಾರು ಕೋರಿರ್ತಾರೆ?
Some of the villages has represented to the Tahsildar.
Tahsildar has to file an appeal. That is not so.
In fact, in this case, what has happened, my lord, Tahsildar himself has passed the order under 108K.
Where is it?
That I have not produced.
It's not possible. It is not permissible. He has not got the power under 108K. That is why I asked you to read it now. You have read the provision.
Yes,
Is the Assistant Commissioner who got that power?
it's a power of the assistant.
Then?
My lord, this is what the Tahsildar. That is why, my lord, the Assistant Commissioner now finally has remanded back to the Tahsildar by giving an opportunity, according an opportunity to me to dispose of this. Lord, for a moment, kindly see another appeal, another order of the Assistant Commissioner, my lord.
ಅರ್ಜಿದಾರರು ಒಟ್ಟು ಕುಟುಂಬದ ಪರವಾಗಿ ಫಾರಂ 53 ಅಡಿಯಲ್ಲಿ 31/1999 ಬಗೆಹರುಕುಂ ಜಮೀನಿನ ಮಂಜೂರಾತಿಗಾಗಿ ತೀರ್ಥಹಳ್ಳಿ ತಾಲೂಕು ತಹಸೀಲ್ದಾರ್ ಅವರಿಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು, ಸದರಿ ಅರ್ಜಿಯ ಮೇರೆಗೆ ತೀರ್ಥಹಳ್ಳಿ ತಾಲೂಕು ಅವರ ಆದೇಶ 25/6/2012ರಂತೆ ಅರ್ಜಿದಾರರ ಹೆಸರಿಗೆ ಸಾಗುವಳಿ ಚೀಟಿಯನ್ನು ನೀಡಿರುತ್ತಾರೆ. ಪ್ರಸ್ತಾಪಿತ ಸಭೆ ನಂಬರ್ 17ರಲ್ಲಿ ಬಗರ್ ಹುಕುಂ ಸಾಗುವಳಿ ಸಕ್ರಮೀಕರಿಸಲು ಬರುವುದಿಲ್ಲವೆಂದು ಉಪ ಅರಣ್ಯ ಸಂರಕ್ಷಣಾಧಿಕಾರಿಗಳು ಶಿವಮೊಗ್ಗ ವಿಭಾಗ ಪ್ರಯುಕ್ತ ಮೇಲ್ಕಂಡ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಈ ಹಿಂದೆ ಕೋಣಂದೂರು ಗ್ರಾಮದ ವಾಸಿ ಇವರಿಗೆ ಕೋಗಿಲು ಗ್ರಾಮದ 17ರಲ್ಲಿ ತಪ್ಪು ಮಾಹಿತಿಯಿಂದ ಮಂಜೂರಾಗಿರುವ ವಿಸ್ತೀರ್ಣ ಎಕರೆಗೆ ಬದಲಾಗಿ ಅಂದಿನಿಂದ ಇಲ್ಲಿಯವರೆಗೆ ಸ್ವಾಧೀನದಲ್ಲಿರುವ 1 ಎಕರೆ 15 ಎಕರೆ 1 ಎಕರೆ 15 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣಕ್ಕೆ ಸೀಮಿತಗೊಳಿಸಲು
ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ನಿಯಮ 108 ಅಡಿಯಲ್ಲಿ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಕೋರಿರುತ್ತಾರೆ. ಅರ್ಜಿದಾರರು ಮತ್ತು ಪ್ರತಿವಾದಿಗಳ ವಾದವನ್ನು ಪರಿಶೀಲಿಸಿ ಈ ಕೆಳಗಿನ ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಿ
ಏನಂದ್ರೆ ಬರ್ದ್ಬಿಡ್ತಾರಲ್ರಿ. ಸಡನ್ ಆಗಿ ಎಲ್ಲೋ ಅರಣ್ಯ ಸಂರಕ್ಷಣಾಧಿಕಾರಿಗಳು ಬಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಈಸ್ ನಾಟ್ ಇವನ್ ಎ ಪಾರ್ಟಿ ಹಿಯರ್. ಏನಾದ್ರು ಬರೀತಾರಲ್ರಿ, ಇಷ್ಟ ಬಂದಂಗೆ ಬರೀತಾರಲ್ರಿ. we will set aside the entire proceedings because there is no appeal filed by the Tahsildar. There is no information as to what ground the appeal is filed. He simply has to say, I know you are only in possession of 1 acre 15 guntas, so we'll confirm only that one. Under which provision? 108K doesn't give scope for all those arguments. Okay. Learned HCDP takes notice for all the respondents. Next para. The petitioner's father,
Petitioner's father,
Cheriyabba, was admittedly granted three acres and 20 guntas of land in survey number 17 of Holige village. Holige village. Agrahara Hobli, Tirthalli Taluk. In consideration of the application filed for regularization of unauthorized occupation. The committee had passed an order on 21/6/1991. Allah, 31/1999. Correct, Andre? 31/1999.
that is the date or certified copy.
No.
The date of the application, 30th
ಫಾರ್ಮ್ ನಂಬರ್ 53 ಅಡಿಯಲ್ಲಿ ದಿನಾಂಕ 30/1/1999 ತಗರೂಪಂ ಜಮೀನಿನ ಮಂಜೂರಾತಿಗಾಗಿ ತೀರ್ಥಹಳ್ಳಿ ತಾಲೂಕು ತಹಸೀಲ್ದಾರ್ ಅವರಿಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದರು. Then what is this 1991? 21/6/1991 ಏನಂಗಾದ್ರೆ ಅದು ಫಾರ್ಮ್ ನಂಬರ್ 50, ಫಾರ್ಮ್ ನಂಬರ್ 53. When did the committee pass the order?
That information, my lord, I don't have.
The committee had passed an order on 31.
ಅಲ್ಲ ತೆಗೆದಾಕ್ಬಿಡಿ ಏನಂತ ಬಂದ್ ಸೆಂಟೆನ್ಸ್ ಓದಿ.
Father Cheriyabba was admittedly granted 3 acres and 20 guntas of land in survey number 17 of Holige village, Agrahara Hobli, Tirthalli Taluk, in consideration of the application filed by the regularization of unauthorized occupation.
In consideration of application filed before the committee for regularization of unauthorized occupation. Full stop. The Tahsildar, by order dated 25/6/2012, he issued Sagoli chit in favor of Shri Cheriyabba. And thereafter, the name of the grantee was entered in the land records in terms of mutation order MR number H2/2012-13. However, it appears that the Tahsildar, Tirthalli Taluk, thereafter sought to cancel the grant made in favor of the petitioner's father on the ground that the petitioner was in occupation of only 1 acre 15 guntas of land. Full stop. from the material available on record, it can be seen that the Assistant Commissioner, Shumaga subdivision has passed orders in proceedings bearing number LND CR 69 of 2012-13 on 2/7/2016 cancelling the grant order while directing the committee to reconsider the application filed by Sri Cheriyappa. Full stop. The grantee approached the Deputy Commissioner in REA number 5 of 2016-17 and the said appeal was allowed by a cryptic order on 22/9/2016. Remanding the matter back for fresh consideration in accordance with law by conducting spot inspection. Full stop. There is no clarity in the said order passed by the Deputy Commissioner as to whether the matter was remanded back to the Assistant Commissioner or to the committee. Full stop. Nevertheless, the Assistant Commissioner passed one more order on 6/8/2019 stating that the appeal filed by the appellant is dismissed. Stop. The proposal made by the Tahsildar under Rule 108K is said to have been upheld. Consequently, setting aside all the mutation entries. Stop. ಏನಾಯ್ತು ಇದಾದ್ಮೇಲೆ?
This is the order on the caveat I filed. Similar order has been passed in Annexure Q page 61. ಆದೇಶಕ್ಕಿಂತ ಮೇಲ್ಗಡೆ ಒಂಥರ ಪ್ರಕರಣ ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ಸರದಿ ಪ್ರಕರಣದ ಬಗ್ಗೆ ಇದೇ ನ್ಯಾಯಾಲಯದಲ್ಲಿ PDA 91 of 2014-15 ದಿನಾಂಕ 6/19 ಆದೇಶವಾಗಿದ್ದು ಅರ್ಜಿದಾರರು ಈ ಪ್ರಕರಣದ ಮೇಲ್ಮನವಿದಾರರಾಗಿದ್ದು ಎದುರಾರರು ಕೆಲವು ಗ್ರಾಮಸ್ಥರು
ಏನ್ರಿ ವಾಟ್ ಆರ್ಡರ್ಸ್ ಆರ್ ದಿಸ್? ಏನು ಎರಡೆರಡು ಸರಿ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ದಾರೆ?
Same order, it has been linked with that earlier.
However, learned counsel has pointed out to Annexure Q, which is one more order passed by the Assistant Commissioner on 4/1/2020. Stating that the appeal is partly allowed. So, partly allowed, while directing the Tahsildar to verify from the records and then pass orders. Amele
Annexure S and T, my lord, where the mutation has been made, stating that it is as Danagala Muppatu.
ಆಯ್ತು. ಆಮೇಲೆ
that is where I have agreed.
learned counsel submits that consequent to the orders passed by the Assistant Commissioner, mutation entries have been made. Reducing the extent,
The entire extent has been shown as 3 acre 20 guntas has been shown.
showing the entire extent of 3 acres 20 guntas as
Danagala Muppattu, Gomala.
As Gomala. Stop. Next para. Rule 108K of the Karnataka Land Revenue Rules empowers the Assistant Commissioner to cancel the grant and resume the lands where the grant has been obtained by making false or fraudulent representation or is contrary to the rules relating to grant in terms of section 94 capital A of the Karnataka Land Revenue Act and the rules thereunder. So, having perused the material available on record, it is clear that no proceedings were initiated by the Tahsildar before the Assistant Commissioner invoking Rule 108K. Stop. On the other hand, it is clear from the material available on record that the petitioner approached the Assistant Commissioner, the grantee approached the Assistant Commissioner, and the Tahsildar is shown as the respondent. Stop. The further orders passed by the Tahsildar and the Deputy Commissioner are also equally bad in the eye of law, since there is no application of mind, the Assistant Commissioner and the Deputy Commissioner have not considered whether there were any valid grounds to seek cancellation of the grant. Stop. Moreover, no appeal has been filed by the Tahsildar invoking Rule 108K before the Assistant Commissioner. Stop. That being the position, the entire proceedings initiated before the Assistant Commissioner and the Deputy Commissioner is without authority of law. Stop. Next para. For the reasons stated above, this court is of the considered opinion that the impugned orders passed by the Assistant Commissioner are without any force of law, and therefore they cannot be sustained. Stop. Consequently, the writ petition is allowed while setting aside all the impugned orders passed by the Assistant Commissioner, commencing from the first one.
Annexure L.
Annexure
L.
Amele.
Deputy Commissioner order Annexure M1, Annexure N, and Annexure Q, and also the RTC and mutation Annexure R and
ಅಲ್ಲೇ ನಾನು ಲೈನ್ ಆಗಿ ಹೇಳಿದ್ದೀನಲ್ಲಮ್ಮ, ಎಲ್ಲ ಪೂರ್ತಿ ಬರ್ಕೊಂಬಿಡು. ಸ್ಟಾರ್ಟಿಂಗ್ ಇಂದ ಹೇಳ್ಕೊಂಡ್ ಬಂದಿದ್ದೀನಲ್ಲ, ಫಸ್ಟ್ ಆರ್ಡರ್ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್, ಆಮೇಲೆ ಡೆಪ್ಟಿ ಕಮಿಷನರ್, ಮತ್ತೆ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ 2 ಸರಿ ಎಲ್ಲ ಲಿಸ್ಟ್ ಮಾಡ್ಬಿಡು. The fourth respondent, Tahsildar, Tirthalli Taluk, is hereby directed to restore
G1.
the name of the original grantee in the land records to the in respect of the entire extent of 3 acres and 20 guntas in terms of the grant. Full stop. Further, comma, if an application is made by the legal heirs of the original grantee, comma, the Tahsildar shall consider the same in accordance with law and enter the name of the legal heirs in the land records. Yes. The name of the original grantee shall be restored in the record of rights as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of a copy of this order. Yes. Huh? ಎಲ್ಲ ಒಂದು ಲಿಸ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು ಒಂದು ಸಪರೇಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಹಾಕ್ಸ್ರಿ. I think there are many matters we will consider. Yes. 17. Yes.
Page number 69. The notice initiating the proceedings by the ADLR to make an inquiry and spot inspection with respect to the property bearing serial number 99/3 and 4. For the same issue, if civil suits are pending between the parties, this proceedings has been initiated on the instance of the application filed by the respondent number 6, who is the adjacent landowner of the petitioner. With respect of the same property, civil suits are pending between the parties. The annexure A, my lordship. Page number 17. ADLR initiated proceedings to conduct this party inspection in Issa Podi, my lordship, Badrubastu. Upon the same issue, civil suits are pending. Injunction was granted by the trial court. Filed by the petition against the respondent hearing.
You are challenging the notice.
My lord. Because this proceeding cannot be maintainable in the eye of law, because on the same subject matter, the same issue upon the same property, the civil suits are filed by the petitioner in vice number 184/2023 and interim order of temporary injunctions granted against the respondent number 6 and others. It's in annexure page number 17 and interim order in annexure D, my lordship, page number 34.
34.
Interim order in page number 49, my lord. For the very same server number of 90/3, my lord. Suit for seeking permanent injunction and declaration. Respondent hearing on the most instance, the proceeding has been initiated. He has also filed another suit against the present petitioner. Same is also pending for adjudication.
423.
423, which was filed by the respondent number 6 hearing. And
file ಮಾಡಿದ್ದಾರೆ suit.
184 is filed by the petitioner hearing against the respondent, my lord. Where the injunction was granted against the respondent, all the respondent.
ಬರ್ಕೊಳ್ಳಿ. Why they should do it now when they are doing the pendency of the suit? Are they at the instance of that other person? ಅವ್ರು ಕೇಳೋದಿಲ್ಲ.
ಅವ್ರು ಕೇಳೋದು ನೋಡಿಲ್ಲ, ರಿಪ್ಲೈನ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಅಲ್ಲ ಆಯ್ತು, ಡ್ಯೂರಿಂಗ್ ದಿ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ದಿ ಸೂಟ್ why should they conduct the survey? Why should they conduct this survey? That is the grievance. If there is any requirement, let them file the application before the civil court. Learned AGA takes notice for response number 1 to 5. Issue notice to response number 6 to 9. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. We'll stop. Next part. Learned counsel for the petitioner submits that the petitioner herein has filed OS number 184 of 2023 on the file of the Principal Senior Civil Judge and CJM, Chikmagalur. And the trial court has passed an interim order granting temporary injunction restraining the defendants from trespassing into plain A schedule property or making any construction over plain A suit schedule property. So, the contesting respondents respondent number 6 has also filed one more suit in OS number 423 of 2023 before the civil judge, junior division at Chikmagalur against the first petitioner herein. So, learned counsel submits that during the pendency of the suit, the contesting respondents appear to have approached the Assistant Director of Land Records seeking OD and duress, and consequently the impugned notices have been issued to the petitioners. So, learned counsel submits that the survey authorities should not be permitted to interfere in the matter during the pendency of the suits. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned notice dated 4/12/2023 and all further proceedings thereto till the next date appearing.
Ambitious.
Petitioner is challenging the order passed by the respondent number 1 and 2 with annexure A and Z, my lord. My lord, the land in dispute originally ancestor property of petitioner. All the revenue records are standing in the name of great grandfather Muneppa bin Kureshappa. Page number annexure G may kindly peruse. Muneppa bin Kureshappa.
What is this annexure A?
Annexure A is the order passed by the deputy commissioner. Set aside the order passed by the assistant commissioner. Assistant commissioner passed an order to include my name also as a khatedar in the revenue records because it's an ancestor property.
136 proceedings.
Yes.
Who approached the assistant commissioner?
Petitioner approached the assistant commissioner initially. Assistant commissioner passed an order.
RA 128 of 2020.
Yes, madam. Yes, madam.
What did you seek?
We have seeking to include my name as one of the joint khatedar along with the respondent number 13 and 14 because it is an ancestor property, my lord. Originally, this land is standing in the name of my great grandfather Muneppa bin Kureshappa.
Where is the genealogical tree?
My lord, annexure C may kindly peruse. Page number 25.
25 or 27 now?
ಇವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಅನ್ನು ಹಾಕ್ಬಿಟ್ಟು ಅವ್ರ ಹೆಸರು ಮಾತ್ರ ಮಾಡಿಸ್ಕೊಳ್ಳಕ್ಕೆ ಪ್ರಯತ್ನ ಪಡ್ತಿದ್ದಾರೆ ಅನೆಕ್ಷರ್ ಡೀನ್ ಬಟ್ ದಿಸ್ ಅನೆಕ್ಷರ್ 25 ಇಸ್ ದ ಕರೆಕ್ಟ್ ಜಿನಿಯಾಲಜಿಕಲ್ ಟ್ರೀ ಮೇಡಮ್
Annexure?
ಜಿ ಸಾರಿ ಸಿ ಇವ್ರ ಹೆಸರಲ್ಲೇ ರೆಕಾರ್ಡ್ ಇರೋದು ಒರಿಜಿನಲಿ ಮುನಿಯಪ್ಪ ಬಿನ್ ಕುರೇಶಪ್ಪ ಅನ್ನೋ ಹೆಸರಲ್ಲಿ ಈಗ ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ ಇದ್ದಿದ್ದು ಸೊ ತಾವು ಅನೆಕ್ಷರ್ ಜಿ ಮೇ ಕೈಂಡ್ಲಿ ಪೆರೋಸ್ ದಟ್ ಪೇಜ್ ನಂಬರ್ 41
ಅದು ನಿಮ್ಮ ತಾತ?
ಹೌದು ಸರ್, ತಾತ ಅವ್ರ ಹೆಸರಲ್ಲಿ ಇದ್ದಂತಹ ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್
ಇವಾಗ ಯಾರ ಹೆಸರಲ್ಲಿ ಇದೆ?
ಈಗ ನನ್ನ ಹೆಸರು ಇದೆ, ರೆಸ್ಪಾಂಡೆಂಟ್
ಅದಕ್ಕೆ ಮುಂಚೆ
ಅವ್ರ ಹೆಸರಲ್ಲಿ ಇದೆ.
ಯಾರು?
ಇದು ಒರಿಜಿನಲಿ ಮುನಿಯಪ್ಪ ಬಿನ್ ಕುರೇಶಪ್ಪ ತುಂಬಾ ವರ್ಷದಿಂದ ಬರ್ತಾ ಇದೆ.
ಆದ್ಮೇಲ್ರಿ
ಅದಾದ್ಮೇಲೆ ಈ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 13 and 14 as well as petitioner number petitioner name also reflected in RTC
from the
from 2022, my lord.
From page number 25, please point out the names.
My lord. ಇದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 25 ಅಲ್ಲಿ ಯಲ್ಲಪ್ಪ ಬಿನ್ ಮುನಿಯಪ್ಪ ಅಂತ ತಾವು ಗಮನಿಸ್ಬೇಕು.
ಯಲ್ಲಪ್ಪ ಫಸ್ಟ್ ನೇಮ್,
ಮಗ
ಫಸ್ಟ್ ನೇಮ್. ಹಾ,
ನೆಕ್ಸ್ಟ್ ನಾಗಮ್ಮ ಸನ್ ಆಫ್ ಕೋಮ್ ಲೇಟ್ ಇಟ್ಟಪ್ಪ ಎರಡನೇ
ನಾಗಮ್ಮ.
ಅದಾದ ನಂತರ ಮುನಿರತ್ನಮ್ಮ ಕೋಮ್ ಅವ್ರ ಹೆಸರಿದೆ ಸ್ವಾಮಿ. ಕೃಷ್ಣಪ್ಪ ಅವ್ರ ಹೆಸರಿದೆ. ಟಾಪ್ ಅಲ್ಲಿ ತಾವು ಗಮನಿಸಬಹುದು ನಾಗೇಶ ಬಿನ್ ವೆಂಕಟರಮಣಪ್ಪ ಇಸ್ ದ ಪಿಟಿಷನರ್. ಯಲ್ಲಪ್ಪನ ಕುಟುಂಬದಲ್ಲಿ ಬರ್ತಾರೆ ಸ್ವಾಮಿ.
ಸೊ ಈ ಬ್ರಾಂಚ್ ಅವ್ರದ್ದು ಯಾರ್ದು ಹೆಸರಿಲ್ಲ?
ಇಲ್ಲ, ಇವ್ರ ಹೆಸರು ಈ ಎರಡನೇ ಮಗನ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ನನ್ನ ಹೆಸರು ಮಾತ್ರ ಈಗ ಕೂಡಿಸಿದ್ದಾರೆ.
ರೀ, ಅದಕ್ ಮುಂಚೆ ಆ ಬ್ರಾಂಚ್ ಅವ್ರದ್ದು ಮಾತ್ರ ಹೆಸರು
ಯಾರ್ದು ಇರ್ಲಿಲ್ಲ ಸರ್, ಯಾರ ಹೆಸರು ಇರ್ಲಿಲ್ಲ.
ನೀವೇ ಹೇಳಿದ್ರಲ್ಲ,
ಸ್ಟ್ಯಾಂಡಿಂಗ್
ಯಲ್ಲಪ್ಪ, ನಾಗಮ್ಮ, ಮುನಿರತ್ನ, ಕೃಷ್ಣಪ್ಪ ಇವ್ರ ಹೆಸರಲ್ಲಿ ಇತ್ತು ಮುಂಚೆ.
ಮೊದಲಿದ್ದು ಫಸ್ಟ್ ಮುನಿಯಪ್ಪ.
ಅದ್ ಗೊತ್ತಾಯ್ತ್ರಿ. ಆದ್ಮೇಲೆ ಪ್ರಾಬಲಿ ದೇರ್ ವಾಸ್ ಎ ಪಾರ್ಟಿಷನ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ದೆಮ್ ಅಂಡ್ ದಿ ಲ್ಯಾಂಡ್ ಹಸ್ ಫಾಲೋನ್ ಟು ದೇರ್ ಶೇರ್ ದಟ್ ಬ್ರಾಂಚ್. ದಟ್ ಇಸ್ ವೈ ದೇರ್ ನೇಮ್ಸ್ ವರ್ ಎಂಟರ್ಡ್. ಹೌದು.
ಮ್ಯೂಟೇಷನ್
ಯಾವಾಗ ಆಗಿರೋದು? ಯಾವ್ದು ಮ್ಯೂಟೇಷನ್? ಇದು
2013-14 ಅಲ್ಲಿ ಆಗುತ್ತೆ ಸ್ವಾಮಿ ಅವರಿಗೆ. 2013-14 ಅಲ್ಲಿ ಅವ್ರ ಹೆಸರು.
ನೌ ಲೆಟ್ ಅಸ್ ಸಿ ದಿ ಆರ್ಡರ್ ಆಫ್ ದಿ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್.
Annexure may kindly.
Yes. What is the finding?
Finding is ಇವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ?
What were you challenging?
ನಾವು ಈ annexure
MR challenging orders of mutation in MR H-61 of 2011-12.
ಅವ್ರ ಹೆಸರಿಗೆ ಏನು 4 ಜನದ ಹೆಸರು ಕುಂಡಿಸ್ಕೊಂಡಿದ್ರು, ಆ ಆರ್ಡರ್ ನಾವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ.
Yes.
ಸೊ ಈ ಆರ್ಡರ್ ಪ್ರಕಾರ ಇವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ?
That is after 10 years. After 10 years of the mutation order, you challenged it.
Yes, because it is a family property ಆಗಿದ್ರಿಂದ ಇವರು ನಮಗೆ ಗೊತ್ತಿಲ್ಲದೆ ಅವ್ರ ಹೆಸರು ಮಾಡಿಸ್ಕೊಂಡಿದ್ರು ಸ್ವಾಮಿ. Due to that reason we have challenged the same before the assistant commissioner. The assistant commissioner holding that it's a ancestor property.
OS number 479 of 2013.
Yes.
Is filed by whom?
Filed by the second son family. ಅಂದ್ರೆ ಯಲ್ಲಪ್ಪನ ಕುಟುಂಬದವರು ಮುನಿಯಪ್ಪನ ಕುಟುಂಬದ ಮೇಲೆ ಹಾಕಿರೋದು. ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 4 to 14 ಏನಿದ್ದಾರೆ ಅವರು ವಿರುದ್ಧ ಹಾಕಿರೋಂತ
partition
case in respect of same property.
Where is that plaint
is
one more
annexure
995 of 2018. One more suit
73 of 2013 avoid annexure F may kindly peruse 33 page number. ನಾವು ಈ ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಇದ್ದಿದ್ದಕ್ಕೆ ನಾವೇನು ಕ್ರಮ ತಗೊಂಡಿಲ್ಲ ಸ್ವಾಮಿ. ಇನಿಷಿಯಲಿ ಇವ್ರು ನಮಗ್ ಗೊತ್ತಿದ್ದ ಇವ್ರ ಹೆಸರು ಮಾಡಿಸ್ಕೊಬಿಟ್ಟಿದ್ದಾರೆ. ಸೊ ಅದಕ್ಕೆ ನಾವು ಇವ್ರು ಪದೇ ಸೇಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ಎಲ್ಲ ಪ್ರಯತ್ನ ಪಡ್ತಾ ಇದ್ದಿದ್ದು. ವಿ ಮೇಡ್ ಅನ್ ಅಟೆಂಪ್ಟ್ ಟು ಗೆಟ್ ಅವರ್ ನೇಮ್ ಇನ್ಕ್ಲೂಡೆಡ್ ಇನ್ ದ RTC by way of getting an order from the assistant commissioner. Now my name is also reflected in the RTC void annexure H may kindly peruse madam.
ನಿಮ್ ಬ್ರಾಂಚ್ ಅವರೇ ಫೈಲ್ ಮಾಡಿರೋದು.
ಹೌದು. ಹೌದು.
ಸೀಕಿಂಗ್ ಪಾರ್ಟಿಷನ್.
ಹೌದು. ಸೊ ಈಗ ಇವರು ಈ ಆರ್ಡರ್ ನ ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ ಅವ್ರ ಮುಂದೆ ಚಾಲೆಂಜ್
ನಾಟ್ obtained any interim orders in your favor directing them not to alienate.
ಅಲ್ಲ, that I have to check it out. ನನಗೆ ಗೊತ್ತಿಲ್ಲ, because I am not a party in that case. Totally I am not a party.
ನಿಮ್ ಬ್ರಾಂಚ್ ಅವ್ರು ಹಾಕಿರೋದ್ರಿ?
ನಮ್ ಬ್ರಾಂಚ್ ಅವ್ರು ಹಾಕಿದ್ದಾರೆ, but I am not a party in that case. RTC ಅಲ್ಲಿ
subsequently
also reflected.
ಮುನಿಯಪ್ಪ, ವೆಂಕಟಮ್ಮ, ವೆಂಕಟರಮಣಪ್ಪ. ಮುನಿಯಪ್ಪ, ವೆಂಕಟರಮಣಪ್ಪ, ವೆಂಕಟಮ್ಮ, ವೆಂಕಟರಮಣಪ್ಪ. So all the that generation people have filed, including your father. Your father is the petitioner, the plaintiff. ನನ್ನ ಹೆಸರಿಲ್ಲ ಅಂದ್ರೆ ಅರ್ಥ ಏನ್ರಿ?
ಅಲ್ಲ, ನಮ್ಮ ತಂದೆ ಮತ್ತೆ
ಅರ್ಥ ಏನ್ರಿ? ನನ್ನ ಹೆಸರಿಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ಮ ಅಪ್ಪ ಫೈಲ್ ಮಾಡಿರೋದು.
Because ನನ್ನನ್ನು ಇದ್ರಲ್ಲಿ ಪಾರ್ಟಿಯಾಗಿ ಮಾಡಿ.
Why did you approach the assistant commissioner?
Because ನನ್ನ ಹೆಸರು because it is an ancestor property and
so
I have made an application.
The suit should not be decided.
ಅಲ್ಲ, that has to be decided.
Then ಮಧ್ಯದಲ್ಲಿ ಹೋಗ್ಬಿಡೋದು, ಮತ್ತೆ ಏನೋ ಒಂದು ಎಂಟ್ರಿ ಮಾಡ್ಬಿಡಿ ಅಂತ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದು ಏನಂತಂದ್ರೆ ಇವರು ಅನ್ನೆಸೆಸರಿ ಡಾಕ್ಯುಮೆಂಟ್ ಮಾಡಿಸ್ಕೊಂಡು ಅವ್ರ ಹೆಸರಿಗೆ ಸೇಲ್ ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ ನೋಡ್ತಿದ್ದಾರೆ.
No, no.
ತಾವು Annexure G may kindly peruse. Annexure G may kindly peruse.
Assistant Commissioner has allowed your application and your name is entered.
Yes, ma'am.
The Deputy Commissioner has rightly held to remove it.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್
Let the suit be decided.
ಪೇಜ್ ನಂಬರ್ 15 may kindly peruse.
No.
ಪೇಜ್ ನಂಬರ್ 15 may kindly.
No, no, no.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಅಬ್ಸರ್ವೇಷನ್ ಅವ್ರದ್ದು ಏನ್ ಕಂಟೆನ್ಷನ್ ಅಂತ
No, sir.
ಈ ತರ ಹೇಳ್ತಾರೆ. ಪೇಜ್ ನಂಬರ್ 15 may kindly.
Learned AGA takes notice for response number 1 to 3. Issue notice to response number 4 to 14. Learned counsel for petitioner is direct to serve a copy of the petition along with annexures from the learned AGA.
Not to change the revenue documents. Entry matter maybe.
No, no.
Madhu H.T. Madhu.
Endorsement dated 12/8/2023 at Annexure D, my lord, page 28. There is request, my lord, for making a change in the revenue interest, my lord, switcher take. Annexure D, page 28, my lord, is the endorsement. But the relevant portion is the bottom 4 line, my lord. ಖಾತಾ ಬದಲಾವಣೆ ಮಾಡದಂತೆ ಶ್ರೀಮತಿ ರಂಗಮ್ಮ ಕೋ ಮರಳು ಸಿದ್ದಪ್ಪ, ಕುರುಬರಳ್ಳಿ ಗ್ರಾಮ, ಜಬಗಾಲ್ ಹೋಬಳಿ, ಅರಸೀಕೆರೆ ತಾಲೂಕಿಯವರು ಖಾತೆ ಮಾಡದಂತೆ ತಕರಾರು ಸಲ್ಲಿಸುವುದರಿಂದ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ಖಾತೆ ಮಾಡಲು ಕೋರಿರುವ ಅರ್ಜಿಯನ್ನು ವಿಲೇಗೊಳಿಸಲಾಗಿದೆ. I sought for change in the revenue interest, my lord, in view of the judgment and decree passed in OS 341 of 2022, which is at Annexure B, my lord.
ಅವರ ಅದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಹಾಕಿಲ್ವಾ?
ಇದು ಹಾಕ್ಲ ಅಲ್ಲ, ಇದು ಪಾರ್ಟಿನೇ ಅಲ್ಲ ಅದರಲ್ಲಿ. Stranger, kindly see the next page, my lord, page 29, the objection copy.
OS number 341, where is the judgment and decree?
It is at Annexure B, my lord, page 15.
Ah.
My lord, kindly see the objections given by the
Mallikarjuna KM,
please.
plaintiff.
Out.
ಮರಳ ಸಿದ್ದಪ್ಪ, ರಾಮೇಗೌಡ, ಶಾರದಮ್ಮ, ಲಕ್ಷ್ಮಮ್ಮ.
Please. My lord, kindly come to page 29. Objection copy now. Our Vashira's objection.
For declaration and permanent injunction.
Please. Page 25 is the operative code.
ರಾಮಮ್ಮ.
Doctor, kindly come to page 29. The objections given to my requisition for change of revenue.
Declare that the plaintiff is the owner and possessor of
Survey number 5, my lord, 4 acres.
are permanently restrained from causing interference.
No, my lord, kindly come to page 29. Our objection. Page 29, my lord. Typed copy is done. Page 30. She says, ಅರಸೀಕೆರೆ ತಾಲೂಕು ಜವಗಲ್ ಹೋಬಳಿ ಕುರುಬರಳ್ಳಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 5ರಲ್ಲಿ 4 ಎಕರೆ 3 ಗುಂಟೆ ಜಮೀನಿತ್ತು. ಈ ಪೈಕಿ 1 ಎಕರೆ ಜಮೀನನ್ನು ನನ್ನ ತಂದೆ ರಂಗೇಗೌಡರು ಕ್ರಯಕ್ಕೆ 2003ರಲ್ಲಿ ಖರೀದಿ ಮಾಡಿರುತ್ತಾರೆ. ಖರೀದಿ ಮಾಡಿದ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆಗಳು ಇರುವುದಿಲ್ಲ. ಕೇವಲ ಬಾಯಿ ಮಾತಿನಿಂದ ಖರೀದಿ ಮಾಡಿಕೊಂಡಿರುತ್ತೇವೆ. ಆದ್ದರಿಂದ OS ನಂಬರ್ 341 of 22 ರಂತೆ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಬಾರದೆಂದು ಈ ತಕರ. She is not a stranger to the property.
ಅಲ್ಲ, ಹೌದಾ? ಏನ್ರಿ?
Verified.
Huh?
I verified. This is what a copy had given it to me. Petition I filed it before this court. There's a seal of the Tahsildar and the next year representative.
Correct. ಕೈಯಲ್ಲಿ ಬರ್ದಿರೋದು 18/6. He says it is a Sunday.
Verified.
Huh?
Verified the petition.
So he is saying that he has not issued the endorsement. Huh? So if application is given by the petitioner, if he now gives a application, it will be considered in accordance with law. Other side ಪ್ರಶ್ನೆನೇ ಇಲ್ವಲ್ಲ ಈಗ ಅಷ್ಟೇ only to find out. All right. Barkal. We will dispose of the matter. Learned AGA takes notice for both the respondents. Next para. Learned counsel for the petitioner submits that consequent to the judgment and decree passed by the additional civil judge and JMFC, Arsikere in OS number 341 of 2022, decreeing the suit filed by the petitioner herein and declaring that the plaintiff is the owner and possessor of suit property and the defendants are permanently restrained from causing interference in the peaceful possession and enjoyment of the suit schedule property. The petitioner filed an application before the Tahsildar on 28/6/2023 to enter the name of the petitioner in the record of rights in terms of the judgment and decree passed by the civil court. However, the Tahsildar has issued the impugned endorsement dated 12/8/2023 stating that one Srimati Rangamma, wife of Marula Siddhaya, has filed an objection stating that her father Sri Rangegowda had purchased 1 acre of land out of 4 acres and 3 guntas in survey number 5 of Kuruvarahalli village, Javgal Hobli, Arsikere Taluk. And therefore, the application filed by the petitioner should not be entertained. Stop. Next para. Learned AGA, however, submits on instructions that the Tahsildar has stated that he has not issued the impugned endorsement and no application has been received from the petitioner as seen at Annexure A, since the date found along with the seal is 18/6/2023 and the said date is a Sunday. Stop. Next para. Having regard to the submissions made by the learned counsel for the petitioner, the learned AGA, and on perusing the petition papers, this court is with the considered opinion that the petitioner is required to file a fresh application to the Tahsildar seeking entry of his name in terms of the judgment and decree passed by the civil court. Stop. The Tahsildar shall issue notice to the defendants in OS number so and so to find out whether an appeal has been preferred by them in respect of the judgment and decree passed by the trial court and whether there is any interim order of stay passed by the appellate court. Full stop. Thereafter, the Tahsildar may proceed to consider the application in accordance with law. Full stop. Ordered accordingly.
That's the petitioner. That's the grant was re-granted about 1 acre 35 guntas of land. That is survey number 128 of Kollarli village. That's under
Service inam.
service now.
Ah.
The village officers abolition act.
Ah.
But the total extent of land that was 3 acre 32 guntas. There were two applications. One is by Srimati Pujamma and another application is by Srimati Yellamma.
Ah.
For 1 acre 35 guntas each.
Ah.
And the application for re-grant has been considered, but the order has been passed as per Annexure B, page 30. But the typographical is at page 34, and the relevant portion is at page 35. That is at the bottom, paragraph number 8. I therefore, in exercise of the power conferred on me under section 5 of the KOA Act 1961, re-grant the Salwari and Nilganti service inam lands of Kollarli village to the applicants and other sector as per the genealogical tree as here and there. But we are concerned with Roman 2 minutes. Srimati Pujamma wife of Yeligaya. But on the right hand side, survey number, there were 3 survey numbers which she has claimed. And the subject matter of this writ petition is 128, 1 acre 35 guntas. But similarly, in favor of Srimati Yellamma, at the bottom, 128, that 1 acre 35 guntas. That this was the position. That the father of the respondent number 4 to 6 hearing claimed that even prior to the order of re-grant, he has purchased 2 acre 30 guntas out of 3 acre 30 guntas from a portion of the land from husband of Yellamma. That's husband of Yellamma and his brothers under 3 different sailings. That he claimed that he was in possession of the land even before re-grant. But while passing the re-grant order, the Tahsildar has made an observation in para 5. Kindly see page 34 once again, page 34 at the bottom. Re-grant order. Para 5. Since the Salwari service inam land to an extent of 2 acre 30 guntas was alienated by some of the Hakdar and same was in possession of one Sri Gopal, he was evicted from the same as per the court, as per this court order of even number dated 21/9/1984, and the possession of the said land has been taken over to the government. Therefore, the rights of the re-grantee is only in respect of 1 acre 35 guntas by Yellamma and Pujamma. As per this order, mutation was effected, page 37 Annexure C, in terms of this re-grant order, 1 acre 35 guntas each. The RTC was continued in the name of Pujamma and Yellamma. But Pujamma died in the year 2000, in the year 1992. Her legal representative did not approach the revenue authorities immediately. The Kata was continued in the name of Srimati Pujamma. But in 2004, the legal representatives of Srimati Pujamma, that is the petitioner's hearing, approached the revenue authorities for transfer of Kata. Now, at that junction, one of the sons opposed for transfer of Kata in the joint name. One of the son of Pujamma opposed the recording of the Kata in the joint name. He claimed that the entire land is to be shown in his name. Therefore, the Tahsildar has conducted the proceedings. Page Annexure F, page 55. Tahsildar has directed the entry of the names of all the 3 children of Pujamma jointly. Page 59. Page 59, operative portion of the order. Joint Kadam. Pursuant to this order, Annexure G, page 60. Mutation was effected in the name of the petitioner's hearing for 1 acre 35 guntas. This interim continued up to 2016-17. In 2017, the respondents number 4 to 6 hearing, who claims to be the legal representatives of the purchaser, approached the revenue authorities contending that they have the right in respect of 2 acre 30 guntas and Pujamma's name should be continued only in respect of one acre. Their contention is They earlier said it prevail over the regrant order. Now, that is not the correct position of law. Now, the assistant commissioner accepted their plea and ordered for the deletion of the name of Yellas of Pujam in respect of 35 untas and ordered for continuation of the Kata in respect of only 1 acre. This was challenged before the deputy commissioner. The deputy commissioner also confirmed the order of the assistant commissioner, holding that the purchaser is entitled to be registered as the purchaser of the land is entitled for continuation of Kata for 2 acres 30 gunta. They rely upon one order to say that it's annexure R page 122.
What is annexure M? Annexure M, additional deputy commissioner.
Annexure M.
Your revision petition.
My revision petition. But now kindly come to annexure R, page 122. The regrant order is dated 18/3/1985. But annexure R, page 122 is an application stated to have been filed by Sri S.V. Gopal, seeking for regularization of his purchase of 2 acre 30 guntas by this Tahsildar. It is unheard of. There is no such provision for regularizing the sale deed which was executed prior to the regrant order.
Before the Tahsildar.
Tahsildar, direct page 123. The revenue inspector accordingly directed to effect the change of Kata in survey number 128, extent of 2 acre 30 guntas in favor of the purchaser Sri S.V. Gopal of.
Anyway, that was an order passed on 14/5/1985.
This is dated 85.
1985.
85. Right, this order never seen the light of the day till 2017-18.
Anyway, the tribunal itself has passed an order.
Order for granting 1 acre. My request is only this.
Taking note of the sale deed and setting aside.
That is impermissible. Therefore, my request is, my prayer is, Pujamma's legal representatives are entitled for 1 acre 35 guntas in terms of the regrant order. But the orders of assistant commissioner and deputy commissioner are wholly erroneous, not contrary to several judgments of this honorable.
The revision petition is also dismissed.
Yes.
Learned AGA takes notice for response number 1 to 3. Issue notice to response number 4 to 11. Learned counsel for the petitioners is directed to serve a copy of the petition along with annexures on the learned AGA. Stop. Next para. Learned counsel for the petitioners submits that the land tribunal considered the applications filed by Sri Hanumaya Sri Chennappa bracket alli after his death Srimati his wife Srimati Yellamma bracket allotment and Srimati Pujamma for regrant of lands in 3 survey numbers, 3 or 4 3 survey numbers. 3 survey numbers. 3 survey numbers. Comma, in terms of the provisions contained in the Karnataka Village Officers Abolition Act, 1961. So, the tribunal passed an order on 18/3/1985 granting, regranting the lands in favor of all the three applicants. Stop. However, the subject matter of this writ petition is survey number 128 of Vallahalli village, wherein an extent of 3 acres and 35 guntas each were re-granted in favor of Srimati Pujamma and Srimati Yellamma. 1 acre 35 each. Full stop. At this juncture, learned counsel draws the attention of this court to paragraph number 5 of the order of the land tribunal, wherein it is clearly stated that since the Talavari service inam land to an extent of 3 acres, 2 acres and 30 guntas were alienated by some of the Hakdars, and the same was in possession of one Sri Gopal, he was evicted as per the order of the court on 21/9/1984, and the possession of the said land has been taken over to the government. So, learned counsel submits that in terms of the orders passed by the land tribunal, mutation entries were carried out showing 1 acre 35 guntas each in favor of Srimati Pujamma and Srimati Yellamma. Full stop. The petitioners herein are claiming through Srimati Pujamma. Full stop. Learned counsel submits that after the death of Srimati Pujamma, the petitioners approached the Tahsildar to enter their names on the basis of inheritance. Stop. Accordingly, their names were entered in terms of their names were entered jointly in terms of the orders passed by the Tahsildar, Assistant Commissioner.
Tahsildar.
Tahsildar,
Annexure F, page number 55. 59 is the relevant.
In terms of the orders passed by the Tahsildar on 26/12/2002 in proceedings bearing number RRT dispute 25 of 2002 to 2003. So, there the names of the 3 children of Srimati Pujamma continued in the RTC till 2017-18. However, the private respondents herein private respondents number 4 to 6, 4 to 6 filed an appeal before the Assistant Commissioner invoking section 136(2) of the Karnataka Land Revenue Act of 1964, challenging the mutation entry in MR number 6 of 2004-2005 dated 10/10/2004, wherein the mutation entries were made in favor of the petitioners. Full stop. The private respondents, more particularly respondents number 4 to 6, claim to be the children of Sri Gopal, who had contended that he had purchased 2 acres and 30 guntas of land and that fact had been taken note of by the land tribunal, and an order was passed evicting the said person and handing over the possession to the government. And thereafter, the lands were re-granted in favor of Srimati Yellamma and Srimati Pujamma. Full stop. The assistant commissioner did not understand the facts properly and gave into the claim made by the appellants therein and passed the impugned order directing the entry of the names of the appellants therein in respect of
35 guttas.
huh?
35 guttas, over and above 1 acre 35. Page 91.
35 guntas. Full stop. The revision petition filed before the deputy commissioner, additional deputy commissioner, was also dismissed. Full stop. Etc. Consequently, there shall be an ad interim order stay of the impugned orders at annexures J and M till the next date of hearing.
The petitioner will not writ of mandament. I have given the representations will have to change the mutation entries as per court decree. Court decree minutes is annexure A in page number 12. Representation given to Tahsildar minutes is annexure B, page number 23 minutes. For 23, annexure B.
ಯಾವ ಕೊಟ್ಟಿದ್ದೀರಾ?
Representation dated 8/2/2024.
ಏನ್ರಿ? What do you think? Huh?
Earlier minutes I have given several representation minutes. They have not been considered.
ಎಲ್ಲಿದೆ? Where is that?
I don't have acknowledgement from such minutes. That's the problem. Acknowledgements illa.
They need some time. They have to issue notice, call for objections. ನೀವು 8ನೇ ತಾರೀಕು ಹಾಕ್ಬಿಟ್ಟು you are already before the court.
Earlier put is
It is
acknowledgement.
premature. Your writ petition is premature. We will dismiss it only on that ground. You'll have to give some time for them.
As per court decree.
ಬರ್ಕೊಳ್ಳಿ. ಹೌದ್ರಿ, he has to issue notice to the other persons
ಮುಂಚೆ ಕೊಟ್ಟಿದೆ ಸ್ವಾಮಿ representation. ಅದಕ್ಕೆ
that you are not brought before this court. We cannot accept that contention.
I have said it in petition.
ನೀವ್ ಹೇಳಿದ್ರಿ ಏನೋ ಬಂತು.
Acknowledgement ಇಲ್ಲ.
ಈಲ್ ಕಮೆಂಟ್ಸ್ ನಾನು ಇವಾಗ್ಲೇ ಬಂದಿರೋ ಸ್ವಾಮಿ ನನಗೆ ಫೆಬ್ರವರಿ 8ನೇ ತಾರೀಕು ಐ ವಾಂಟ್ ಸಮ್ ಟೈಮ್ ಅಂತ ಹೇಳ್ತಾರೆ.
ಟೈಮ್ ಒಂದು ಫಿಕ್ಸ್ ಮಾಡ್ಬಿಡ್ತದೆ. As per court decree, Sinakji has prayer.
ಹೌದ್ರಿ, I have not gone through the judgment. He is required to go through the judgment. Whether the judgment has been passed in favor of one party in the suit
I produced.
and whether the other party has taken it up on an appeal.
No, not appeal.
Adanne he has to find out all that.
I have produced the other.
Alla. You're not able to understand. The Tahsildar has to follow all this procedure. Learned AGA takes notice for all the respondents. Stop. Learned AGA raises a preliminary objection that the petitioner appears to have given an application on 8/2/2024 to the respondent Tahsildar, Yelahanka Taluks, seeking mutation entry in terms of the judgmental decree passed by the principal senior civil judge and JMFC in OS number 1043 of 2021. Stop. Learned AGA submits that the Tahsildar will have to issue notice to all concerned and thereafter pass orders in accordance with law. And for the said purpose, the Tahsildar will require reasonable time. Full stop. The learned AGA therefore submits that the petition is premature and therefore it should be dismissed. Stop. Next para. Having regard to the admitted fact that the application was given by the petitioner on 8/2/2024, there is substance in the submission of the learned AGA. Full stop. Next para. Consequently, the writ petition stands disposed of, directing the Tahsildar to issue notice to all concerned and pass orders after following the due process of law, as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of a copy of this order.
Annexure B1 ADLR for 11 is given. Annexure B1.
Huh?
11 is given. For ADLR B1. Page number 25. Annexure B1. As per court.
Annexure?
Annexure B1, my lord, page number 25.
This is going to take even a longer time. Okay. This is going to take more time then. The Tahsildar can do it only after the 11 sketch is given by the ADLR. ಇನ್ನೊಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಸೇರ್ತೀವಿ AG ಅವರದು ಇದು ಸಬ್ಮಿಷನ್ ಅಲ್ಲಿ. Further, it is pointed out that the petitioner has also given a representation to the Assistant Director of Land Records, Yalanka, seeking 11 sketch to enable the mutation entries in terms of the judgment and decree passed by the trial court. So, iga idra last alli ಏನು ಹೇಳ್ತಾರೆ ಲಾಸ್ಟ್ ಅಲ್ಲಿ?
Consequently, the petition is disposed of by directing the Tahsildar,
by directing the Assistant Director of Land Records, Yalanka Taluk, to consider the representation given by the petitioner for preparation of 11 sketch. So, ಅದಕ್ಕೆ ಅಲ್ಲ ಆನ್ಲೈನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕಾ? ಆಗೋದಿಲ್ಲ ಅಲ್ಲಿ ಅಲ್ಲ AG ಅವ್ರದ್ದು ಸಬ್ಮಿಷನ್. Learned AGA further submits that the petitioner is required to file online application for preparation and furnishing 11 sketch, and the representation given at Annexure B1 cannot be accepted. So, next para. Consequently, the writ petition stands disposed of, permitting the petitioner to file online application before the Assistant Director of Land Records for furnishing 11 sketch in terms of the judgment and decree passed by the trial court. Stop. After the petitioner obtains 11 sketch at the hands of the ADLR, thereafter he may approach the Tahsildar to mutate the names in the land records. Yes. Online application ni file ಮಾಡಬೇಕು, that is a time frame ಕೊಟ್ಟಿದ್ದಾರೆ ಅದರಲ್ಲಿ.
From the production of the copy.
No.
No matter. In similar matter, my lords.
No.
Please, my lordships.
No. Yes.
Within 3 months ಆದ್ರೂ ಮಾಡಿ. ಇಲ್ಲ otherwise my lord Tahsildar ಮಾಡಲ್ಲ.
No. Tahsildar ಅಲ್ಲ ADLR.
ADLR ತಗೊಂಡು
ಫಸ್ಟ್ ಅದು ತಗೊಂಡು ಕೊಡಿ, ಆಮೇಲೆ ನೋಡೋಣ.
Tahsildar ಮಾಡಲ್ಲ ಸುಮ್ಮನೆ. Please my lord.
No.
No, time mind my lords. Please my lords. I request my lords. Please, my lords.
ನೀವು ಈ ತರ ಎಲ್ಲ ಪ್ರಿಮೇಚರ್ ಪಿಟಿಷನ್ ಹಾಕೊಂಡು ಆರ್ಡರ್ಗಳು ತಗೊಂಡು ಯು ಆರ್ ಟ್ರೈಂಗ್ ಟು ಡೂ ಸಮಥಿಂಗ್.
Within 3 months ಆದ್ರೂ ಮಾಡಿ.
No.
Please, my lords.
Yes,
Please, my lords.
no.
Correspondent number 93
Huh?
9 to 19 madam.
ಹಾ,
Yeah.
ಸರಿ.
It is value.
For what? What is the urgency?
Now he is served, my lord, the land has been developed, converted and layout has been formed. Now, my lord, after lapse of 10 years, my lord, they have approached the city surveyor of land records to change the code and duras. That was ordered, that was rejected. Thereafter, my lord, they have approached the joint director of land records under section 50. The appeal, the division under section 50 was also rejected by the joint director. Now, my lord, the second appeal was filed. Second appeal was filed before the additional director of land records. By way of an impugned order, my lord, it quashes the entries and he directs the additional assistant director of land records to resurvey the entire land subject to the result of original suits which are pending, my lord. My lord, original suits are filed in the year 2013 itself. I
Who
have
was filed?
the other side, my lord, respondent. In those writ petition, original suits, my lord, there is no interim orders. And now, my lord, after lapse of 10 years,
You are not related to each other.
we are related. I have purchased the land from them. They are my wife's brothers. And thereafter, my lord, I have purchased 1 acre 39 guntas. Out of that, there was a partition. After partition, my lord, the partition took place in the year 2010, my lord. Subsequently, my lord, the land purchased by me was divided in my family and 3 portions were ordered in the year 2010. And subsequently, in the year 2018, my lord, the conversion order was issued by the deputy commissioner of 2018, my lord. That was challenged before the K80. And the appeal is pending and there is no interim orders before the K80. One after the other suits were filed by different respondents who are there before this in this petition, my lord.
And now they are seeking.
Now they have not succeeded in all those proceedings. Now they have approached the additional director of land records and they have obtained some orders stating that all these courts will be subject to the result of original suits. My lord, I have surrendered the lands, that is this civic community sites, roads and the park is already surrendered to the Muda and layout has been formed. I have taken advances from the prospective buyers. At this stage, my lord, this order came to be passed, my lord. There is an urgency because the developmental work of the layout has been.
I made submission.
Yes.
Now it is ready. 160. Since my lord, that politicians has been involved, my property has been demolished. Kindly 116, my lieutenant has submitted that we have filed suit as against them. Kindly 160 suit which they have filed for declaration after lapse of 25 years to declare them as owners. Then they have entered joint development agreement. Thereafterwards, my property has been demolished by adjust ADLR and survey. None property our property regular property subsequent to that, we have filed appeal before the ADLR. Then it is transferred to the survey officer Nazirabad. Then he has dismissed. Then after deputy commissioner revision has been filed, that is transferred to the ADLR. Then he dismissed. Then ultimately invoked 156. 160 for a debate pending term. This relationship which they have filed for declaration, I have filed injunction of date. Then they have challenged before this honorable court. I point out that this honorable court has said the injunction to be vacated after completion of time, and their petition came to be rejected.
Where is that order?
First we do 160. This is Central. And
now they have filed objections, my lord. Now they have filed objections, my lord. This copy was not given. It was not served on me. Now, just now they have served this copy. It may be taken up tomorrow.
Tomorrow, Friday. Because in all cases, the original should sign declaration declaring that survey boundary which is fixed 82 to be corrected ಅಂತ ಹಾಕ್ತಾರೆ. ಅದು came to be rejected.
Learned
ಹಾಕ್ತಾರೆ.
AGA takes notice for response number 1 to 6. Learned counsel Sri Ganapati Bhatt
9 to 90.
has entered appearance for response number 9 to 19 by filing a caveat petition. Two persons are left. 7 and 8. 7 and 8.
7 and 8. Since we have filed a petition.
Issue notice to response number 7 and 8. Learned counsel for the petitioners is direct to serve a copy of the writ petition along with annexures on the learned AGA. Full stop. Next para. Learned counsel Sri Ganapati Bhatt has filed seeks to file statement of objections and a copy is served on the learned counsel for petitioners. So, learned counsel for the contesting respondents is directed to file the objections in the office. Release this matter. Nadida?
Guruvar.
Shukruvara agadilla. Guruvara. Shukruvara, it will be half day. It will be difficult. We'll have it on Thursday. Release this matter on 22nd of February for preliminary hearing.
But 2 acres of land belong. It's survey number 179 of Marginalized blood was granted to me in the year 1986. The original grant certificate I produced. Not thereafter, blood. The revenue authorities have decided the revenue records in my name. But I have paid the land revenue to the government. All those documents I have produced. But I have been residing there along with a residential house with the power supply, everything. That also I have produced. Now what happened is the government intended to
2 acres only you only put a house.
Yes, house as well as it is some trees are grown because so therefore it is a Karab land which was granted. So therefore, Lord, first of all, I have no money to invest and develop. Cultivation cannot be done. But in any event, Lord, the trees are grown. That I have produced the photographs also. Lord, now what happened is, now this the government intended to start a project, Lord, for housing. Lord, therefore, Lord, without referring to my grant and the earlier proceedings before this honorable court, and without having any regard to the orders passed by this honorable court, Lord, they have all of a sudden, Lord, started doing the earthwork, Lord, in my land without cancelling the grant. No opportunity, no inquiry. Lord, even the orders, the sketch prepared by the but it is the sketch prepared by the survey department before.
Where is this order passed in WP 48460?
Yes, Lord. That is that annex, Lord. Annex J in page 90.
This is filed by Chikkanna.
Chikkanna.
Huh?
Chikkanna.
Chinnakanna. Oh, Urena. Ure.
Lord, the deputy commissioner, Lord, earlier initiates proceedings under section 136(3). After examination of my
To order passed at annexure A by which the second respondent, special deputy commissioner, on dropping the proceedings under section 136(3), directed Tahsildar concerned to take action to reflect the name of the petitioner herein in the concerned revenue record by assigning new survey number and to update the survey record and take up code work.
Lord, this they have not done, and instead, Lord, despite all these records, Lord, without cancelling the grant, Lord, they are not supposed to disturb my grant and the possession. It is a constitutional right, Lord. 300 days, blatant violation of Article 300 days. If the government wants my land, Lord, they have to acquire it and take it.
What is the prayer in the writ petition?
Lord, my prayer is, Lord, to quash the annexure A and B in so far as the petitioner's land is concerned.
A and B.
And
What is A and B?
annexure A, my Lord, is the order passed by the deputy commissioner for granting the land to the Rajiv Gandhi that Nigama for the purpose of housing. It is at in page 15. My land is at
Unauthorized survey number 179.
179. My name, Lord, my land is at serial number 13 at in page 16.
Your name is entered in the land record.
Yes, Lord. From 1985, 86.
Consequent to the orders passed by this court,
Yes, Lord.
your name was entered.
My name is entered, Lord.
Where is the RTC?
Yes, RTC, Lord. At annexure E1 in page 38. That is the manual RTC, earlier RTC from the year 1985-86.
Abdullah, sir.
There
was a direction given by this court
yes,
in the order that I just read out now.
Yes, Lord.
Because the learned HCGP had submitted that your name will be entered.
Yes,
ಏನಾಯ್ತು ಅದಾದ್ಮೇಲೆ?
enter ಮಾಡಿದ್ದಾರೆ. That my Lord may kindly peruse in page 68.
68.
In page 68. ಅವರು ಅದರಲ್ಲಿ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಸೊ ಆನ್ ದಟ್ ಬೇಸಿಸ್ ಮೈ ನೇಮ್ ವಾಸ್ ಎಂಟರ್ಡ್. ಅವತ್ತಲ್ಲಿ 6(3) ಏನ್ ಆರ್ಡರ್ ಮಾಡಿದ್ರು ಆ ಆರ್ಡರ್ ಪ್ರಕಾರ ರೆಫರೆನ್ಸ್ ಹಾಕಿ ಮಾಡಿದ್ರು.
What is annexure B?
Annexure B, Lord, the Tahsildar, without conducting even a merger and
has handed over possession.
Handing over. It is all possession and over is only on paper. Even now I am.
Learned HCGP takes notice for response number 123. Learned Counsel Miss Shilpa Rani. Shilpa Rani is requested to take notice for response number 4. Learned Counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. So next para. And learned counsel for response number 4.
Yes.
Next para. Learned counsel for the petitioner submits that in terms of the directions issued by this court, in WP number 48460 of 2017, dated 9th of March 2023, the name of the petitioner has been entered in the record of rights, showing 2 acres of land in the name of the petitioner in survey number 179 of Unauthorized, Jala Hobli, Yalanka Taluk. However, At Annexure A, an order has been passed by the Deputy Commissioner reserving
5 acres of land.
a total extent of 383 acres
ಅಲ್ಲ ಅದನ್ನೆಲ್ಲ
in various survey numbers, including 5 acres in survey number 179 of Unsamaranahalli in favor of the fourth respondent, Rajiv Gandhi Rural Housing Corporation Limited. Stop. Learned Council submits that since the land belongs to 2 acres of land,
Yes.
in the said survey number belongs to the petitioner, comma, it was impermissible for the Deputy Commissioner to have passed such an order granting lands in favor of the fourth respondent, which would overlap the lands belonging to the petitioner. Stop. Annexure B is a document showing that the lands that were granted in favor of the fourth respondent corporation, and more particularly 5 acres in survey number 179 of Unsamaranahalli being handed over to the fourth respondent corporation. So, next order. There shall be an ad interim order of stay
Annexure A and B.
of annexures A and B insofar as 2 acres of land in survey number 179 of Unsamaranahalli village is concerned, which belongs to the petitioner, and all further proceedings thereto, come out till the next date of hearing.
Yes.
Hearing for petitioner. Because this petition has been filed before this honorable court, which has the execute order at annexure S1. The execute order at annexure S passed by respondent number 1 and 2 is permitting for installation of statue of former Union Minister Anand Kumar. The petitioners are the people belonging to SC/ST community, my lord. They are downtrodden people, homeless, even being deprived of basic facilities of life. They have made a representation before respondent number 3 in the year 2007 itself, that the subject property has to be allotted to them by forming residential layout and putting up houses accordingly. The representation, another representation was made in the year 2013 before respondent number 3, as well as other respondents, that is Tahsildar and the assistant commissioner, my lord. Though 9 years lapsed, in the year 2016, my lord, only when they approached a local leader by name, Mr. Basuraju, who was the member of Gram Panchayat, he helped them and he made a recommendation letter. Based upon the recommendation letter, the Gram Panchayat considered the grievances of the petitioners and then considered and it referred the same to revenue authorities, where revenue inspector also made his report that this land is capable of being granted based upon the boundaries. On which, my lord, kindly peruse annexure.
You are seeking to quash annexure S.
Annexure S, my lord. So the resolution also came to be passed, my lord. At page number 62, serial number 16, the resolution was passed by Gram Panchayat stating that this land is capable of being granted, wherein there can be residential layout put up, houses can be constructed, and even other facilities such as hospitals, temples, and other facilities which would be providing good betterment of livelihood to the petitioners. Based upon this representation, the only thing what was still pending, my lord, is the allotment of this land in favor of the petitioners by forming the residential layout and other facilities. To the shock and surprise of the petitioner, the wife of Union Minister Anand Kumar, that is Tejaswini Anand Kumar, she approaches directly the office of Honorable Chief Minister, stating that this land, knowing very well it has to be given to the depressed class of the society, that it has to be allotted for the institution of statue of late Anand Kumar. Chief Minister office, through its head of Principal Secretary, creates all the procedures what are required within just span of 3 months, my lord. the file gets moved from secretary to AC, AC to DC, Tahsildar, and the impugned order gets passed. It is the sufferance of the petitioner from the year 2007 till 2019 till the resolution was passed. But respondent number 9, hand in glove with all the other respondents, gets the impugned order passed by the authorities. My lord.
The problem is that you have not made applications in accordance with law.
My lord, we have made,
Under which provision have you sought for allotment?
my lord, the representation, the resolution itself speaks, my lord,
Given to whom?
given to the deputy commissioner.
Deputy Commissioner. Under which provision?
My lord, the provisions are law.
That is the problem, sir. There is provision only under section 94A seeking regularization of unauthorized occupation or under the land grant rules.
My lord,
You have done neither.
but the procedures were conducted and.
Nothing can be done, sir. This kind of directions cannot be given.
But in fact, even the.
You have no vested right.
Inquiry, my lord.
You have no vested right in the land.
Lord,
Your grievance cannot be considered.
Past 20 years, they have been staying, my lord. They are-
You have not made an application in accordance with law. What can we do?
My lord, but representations have been time and again given to all the authorities concerned.
See, if you have given a representation, please understand. If you have given a representation, you should have a right under a particular provision to seek allotment and a duty cast on the officer to consider your application.
Applications were considered, the deputy.
By whom,
commissioner-
sir?
The deputy
Under which
commissioner
provision, sir?
Considered, my lord.
Under which provision?
They have not specified.
That is the problem.
It has been considered.
ಏನು ಪ್ರಯೋಜನ ಆಗೋದಿಲ್ಲ. No direction can be given to the deputy commissioner.
Whatever representations were considered, whatever proceedings were conducted, they have
It will
suppressed it
become
and they have.
illegal, sir. Such an action on the part of the deputy commissioner will become illegal.
My lord, in fact, that being the case, even they have not inculcated any provision. They have made a direct representation to the chief.
Yes.
Minister's office.
They have stated the provisions. These are lands now within the limits of BBMP probably. ಎಲ್ಲಿದೆ ಈ ಜಾಗ ಇದು?
My lord, Devnalli, sir.
Huh?
Devnalli.
ದೇವನಹಳ್ಳಿ.
But since 2007 till 2019, all the inquiries were conducted. Revenue report was made by the revenue inspector. Tahsildar also considered.
ಏನು ಪ್ರಯೋಜನ ಆಗೋದಿಲ್ಲ. ಏನು ಪ್ರಯೋಜನ ಆಗೋದಿಲ್ಲ.
Deputy commissioner has considered, my lord, in the letter.
Sir, your claim cannot be considered
My lord, one more
because
technical aspect.
no application has been made in accordance with law.
My lord, there is a technical aspect. At the time of making the first representation before the chief minister office, they seek for land of 3 guntas. And at the time of passing the final order, that is the impugned order, they make 3 guntas to 3 acres. They have not even followed the procedural aspects of.
What right do you have to challenge all this? This is
Lord,
not
we
a
have
public
been-
interest litigation.
My lord, this.
You want to file a public interest litigation? Go there.
Yes, my lord, but definitely this land is identified for the ground road.
We are only concerned with the provisions of the Karnataka Land Revenue Act. All the land grant rules. You have not made any application in accordance with law. You have no grievance.
My lord, the grievance.
If it is a, if you are trying to espouse a public cause, then public interest litigation.
No, my lord, the petitioner themselves.
ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು ಯಾವ ಪ್ರಾವಿಷನ್ ಗಳಿಗೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀರಾ? Can this court issue any direction?
My lord, they are in fact trying to dispose.
There has to be a right vested in you to say, in terms of this provision, I have made the application and my application has to be considered.
My lord, but all this while it was considered, my lord, since 2007 till 2019.
No use, sir. Learned AGA takes notice for response number 1 to 5 and 7. Notice to response number 6, 8 and 9 is not necessary for the following reasons. Next paragraph. The petitioners contend that they are persons belonging to the marginalized section and they have made applications seeking grant of lands, sites.
Land, my lord, but after development.
Huh?
After development of the land forming residential sites, they have to be.
You wanted sites,
Yes,
you
allotment.
wanted sites. Seeking allotment of sites
Sites.
since they are homeless.
And accordingly to construct houses, my lord, that is the.
Of course, ಅದು grant ಆದ್ಮೇಲೆ ತಾನೇ ಮನೆ ಕಟ್ಟೋದು. So, however, to their shock and surprise, the lands which they were seeking for allotment, namely 3 acres and 10 guntas in survey numbers 105, 106, 107 and 20 of Hegganahalli, Kundana Hobli, Devanhalli Taluk, Bangalore Rural District has been granted in favor of
Respondent number 9.
respondent number 9 herein for erecting a statue of late Sri Anant Kumar, former member of the parliament and former minister in the central government. Stop. Next para. Learned AGA, however, raises an objection that the petitioners have not made any application in accordance with law. Stop. Learned AGA submits that provision is made in the Karnataka Land Revenue Act for regularization of unauthorized occupation of agricultural lands belonging to the government, in terms of section 94 capital A. So, provisions are made in the same chapter that is chapter 8. For grant of land in case of construction of dwelling houses in occupied land in terms of section 94 capital C. Making provision for grant of land if such person satisfies that he or she is in unauthorized occupation of the land belonging to government and has constructed a dwelling house on such land prior to the first day of January 2015 and such lands can be regularized. Stop. However, admittedly, the petitioners have not made such an application. Stop. Their claim is that they have sought for allotment of sites at the hands of the Panchayat Development Officer, Jalige Gram Panchayat of Devanhalli Taluk. So, the learned AGA would therefore submit that the petitioners have no vested right in raising a challenge to the impugned order passed by the government. Government or Deputy Commissioner?
Government. Respondent one end.
Passed by the government. Stop. Then AGA submits that if the petitioners are seeking allotment of sites through the concerned Gram Panchayat, then as and when the Gram Panchayat is permitted to form a layout and distribute sites to the local villagers, the petitioners may make application in accordance with law, and the same will be considered having regard to the provisions contained in the Karnataka Gram Swaraj and Panchayat Raj Act and not under the provisions of the Karnataka Land Revenue Act. Stop. Next paragraph. There is substance in the submissions made by the learned AGA. Full stop. The petitioners have no locus standing to question the impugned order passed by the government, providing lands for erection of a statue of a political leader. Full stop. The grievance of the petitioners can be redressed only if they have filed application in accordance with law. Full stop. Next paragraph. With these observations, the writ petition stands dismissed.
Not the liberty might be given to file.
ಅದೇ ಹೇಳ್ತಾರದು ಹಾಕಿ ಹೇಳಿದಿರಲ್ಲ. If you file necessary application in accordance with law, can be considered.
No, liberty might be given to file the public interest.
Needless to observe that if necessary applications are filed by the petitioners, the concerned authority shall consider the same in accordance with law. Yes.
The application filed by impleading application for the responding to has been dismissed. ಅವ್ರು ಹಾಕಿದ ಅಪ್ಲಿಕೇಶನ್ ರೆಸ್ಪಾಂಡಿಂಗ್ ಟು ಮುಂದೆ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಅದ್ಮೇಲೆ ಅದನ್ನ ಕ್ವಶನ್ ಮಾಡ್ಕೊಂಡು ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕ್ಬೇಕು ಹೊರತು ಮತ್ತೆ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ kindly state annexure case impugn order, madam, which is question before lordship, madam. In page number 42, madam, annexure case. That is the question of questioning before lordship by filing this writ petition, madam.
You are challenging annexure K.
Madam. Para 46, madam. In page number 46, para 5, madam. Where is the impleading application, madam? Para 5 later. B.N. Bacharayappa led being Naranappa ಎಂಬುವರು ಅವರನ್ನು ಪ್ರಕರಣದಲ್ಲಿ 6ನೇ ಎದುರುದಾರನಾಗಿ ಸೇರ್ಪಡೆ ಮಾಡಿಕೊಳ್ಳಬೇಕೆಂದು ಕೋರಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಡಿವಿಷನ್ ಅರ್ಜಿದಾರರ ಪರ ವಕೀಲರು ಸೇರ್ಪಡೆ ಎದುರುದಾರನಾಗಿ ಸೇರ್ಪಡೆ ಮಾಡಬೇಕೆಂದು ಸಲ್ಲಿಸಿರುವ ಅರ್ಜಿಗೆ ತಕರಾರು ಸಲ್ಲಿಸಿ ಸೇರ್ಪಡೆ ಅರ್ಜಿಯನ್ನು ತಿರಸ್ಕರಿಸಬೇಕೆಂದು ಕೋರಿರುತ್ತಾರೆ. ಸೇರ್ಪಡೆ ಅರ್ಜಿದಾರರಿಗೆ ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಲು ಸಾಕಷ್ಟು ಕಾಲಾವಕಾಶ ನೀಡಿದ್ದು ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಿರುವುದರಿಂದ ಸೇರ್ಪಡೆ ಅರ್ಜಿಯನ್ನು ತಿರಸ್ಕರಿಸಲಾಗಿದೆ. ಈಗ ಮತ್ತೆ ಇಂಪ್ಲೀಡಿಂಗ್ ಹಾಕೊಳ್ಳೋಕೆ ಬರೋದಿಲ್ಲ. ನಾವು ಮಿಲಾಡ subject matter of the petition is Malada. Land clearing survey number 20 of Gudiyalli village, Malada, measuring 3 acres 15 guntas, Malada, has been granted in favor of the petitioner's father, Malada, on 14/4/1976, Malada. Annexure A is the grant certificate. Followed by an August, kindly annexure B, Malada. In the year 19, Malada, 8081 August has also been fixed in respect of those lands. The respondent 6, Malada. Annexure B is the August, Malada. ದುರಸ್ತು ಮಾಡಿರೋದು ಅದ್ರದ್ದು ಟೇಪ್ಡ್ ಕಾಪಿ ಹಾಕಿದೆ. 1881 ಅಲ್ಲೇ ದುರಸ್ತು ಮಾಡಿದ್ದಾರೆ. ಸಪೋರ್ಟೆಡ್ ಬೈ ದಟ್ ಲ್ಯಾಂಡ್ ಸರ್ಟಿಫಿಕೇಟ್. ಬೇಸ್ಡ್ ಆನ್ ದಟ್ RTC has been entered in my name. Annexure C. ಸರ್ವೆ ನಂಬರ್ 170 ಮಾಡಿದ್ದಾರೆ. ಟೇಪ್ಡ್ ಕಾಪಿ ಹಾಕಿದೆ. 8081 ದುರಸ್ತು ಫಿಕ್ಸ್ ಮಾಡಿದೆ. ಇದು ದುರಸ್ತು ಫಿಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ. ಅದಾದ್ಮೇಲೆ ಈ ರೆಸ್ಪಾಂಡೆಂಟ್ 6 ಮೇಲೆ ಕ್ಲೇಮಿಂಗ್ ಟು ಬಿ as grantee in Malada in land clearing survey number 20, new survey number 183 in the year 1993. 93 ಅವರು ಗ್ರಾಂಟ್ ಆಗಿದೆ. ಅನ್ಫಾರ್ಚುನೇಟ್ಲಿ Malada
ಏನ್ ಗ್ರಾಂಟ್ ಆಗಿದೆ?
ಅದೇ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ಆಗಿದೆ. Annexure in same survey number.
How can it be granted?
Like claiming to be grant ಮೇಲೆ ಅವ್ರು ಹೇಳ್ತಿರೋದು. ಅದ್ರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ, ಮೆಲಡ್ then ಮೆಲಡ್ I made an application before the Tahsildar ಮೆಲಡ್. ಏನಕ್ಕೆ ಅಂದ್ರೆ ಅವ್ರು ಗ್ರಾಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡಿ ನಮ್ಗೆ, ನಾವು ಕೇಳ್ತೀವಿ. ಅವ್ರ ಲ್ಯಾಂಡ್ ಸಂಬಂಧಪಟ್ಟಂಗೆ ಗ್ರಾಂಟು ಇದೆಲ್ಲ ಆಫೀಸ್ ಇದೆ ಕೊಡಿ ಅಂತ ಕೇಳ್ತೀವಿ. ಫಾರ್ ದಟ್ ಮೆಲಡ್ Tahsildar has been given endorsement for kind of annexure J ಮೆಲಡ್ in page number 41. In page number 41 annexure J ಮೆಲಡ್ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ 41. The endorsement is the custodian of the grant certificate. ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಶಿಡ್ಲಘಟ್ಟ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಗುಡಿಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 20 ಹೊಸ ಸರ್ವೆ ನಂಬರ್ 183 ಬಾಕ್ಸು ಸೋ ಅಂಡ್ ಸೋ ಕೆ ಮುನಿವೇಂದ್ರ ಸ್ವಾಮಿ ರೆಸ್ಪಾಂಡೆಂಟ್ 6 ಮಿನಿಟ್
ಅದೇ ಅವ್ರ ಗ್ರಾಂಟ್ ಆಗಿಲ್ಲ ಅಂತ
ಕೊಟ್ಟಿದ್ದಾರೆ. ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಕ್ರಿಯೇಟ್ ಆಗಿದೆ. ರೆಸ್ಪಾಂಡೆಂಟ್ 2 ಏನ್ ಮಾಡ್ತಾರೆ ಈಗ ನಮ್ಮ ಹೆಸರಾಗಿ ಓವರ್ಲ್ಯಾಪ್ ಆಗಿದೆ ಅಂತ ನಮ್ಮ ಗ್ರಾಂಟ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ರೀಜೋರ್ಸ್ಗೆ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ನೆಕ್ಸ್ಟ್ ಕೇಸ್ ದಟ್ ಈಸ್ ದಿ ಆರ್ಡರ್. Annexure K ಮೆಲಡ್.
Who is respondent number 6?
Respondent 6 claiming to be another granting ಮೆಲಡ್.
Huh?
Easy. Respondent number 6 ಮುನಿವೇಂದ್ರ ಸ್ವಾಮಿ.
ಅಲ್ಲ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಯಾರು ಹಾಕ್ತಾರೆ ಇವಾಗ?
ಅವರು ಸ್ಟ್ರೇಂಜರ್. ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಅಲ್ಲೇ.
ಅದು ಯಾವ ಓದಿದ್ರಲ್ಲ ಅದು?
ಹೌದು. ಟೋಟಲ್ ಸ್ಟ್ರೇಂಜರ್ ಟು ದಿಸ್. Now dispute between the petitioner and the respondent 6. Impleading applicant is a total stranger to this.
He approached.
He is opposing my.
No. His name was never entered in the land records.
ಯಾರು
ಇವ್ರದ್ದು ಮುನಿವೆಂಕಟಪ್ಪ
ಬಂದಿದೆ ಅವರು. ಸರ್ವೆ ನಂಬರ್ 183. ಸರ್ವೆ ನಂಬರ್ 183 ಬಂದಿದೆ.
ಹೆಂಗ್ ಬರುತ್ತೆ?
ಮಾಡಿದ್ದಾರೆ ಮ್ಯಾನೇಜ್.
ಅಲ್ರಿ, it is not possible that in the same RTC two names are there.
ಸಪರೇಟ್ ವಾಸ್ಟ್ ಎಕ್ಸ್ಟೆಂಟ್ ಇದೆ ತಮ್ಮ ಸರ್ವೆ ನಂಬರ್ 20 ರಲ್ಲಿ.
ಅದೆಲ್ಲ
ಅವ್ರು ಸಪರೇಟ್ RTC ಅದು ಕ್ರಿಯೇಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
So you cannot contend that it was not granted to them at all. It may have been granted if there is larger extent. It may have been granted also. We do not know. It may be genuine also. It may not be genuine also. ಆಯ್ತು.
ಅಲ್ಲಿ ಏನಾಯ್ತು when there is a dispute regarding that, I made an application before the DDL to fix ADL to fix an adverse in my ಅವಾಗ ಏನ್ ಮಾಡ್ತಾರೆ ADL ಅವರು ಅವ್ರ ಲ್ಯಾಂಡ್ ನಮ್ದ ಮೇಲೆ ಓವರ್ಲ್ಯಾಪ್ ಆಗಿದೆ ಅಂತ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟು ನಿಮ್ಗೆ ಅಡ್ವರ್ಸ್ ಮಾಡೋಕೆ ಬರೋದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಕೈಲಿ ಸಿ ಅನ್ನೆಕ್ಚರ್ H ಮೆಲಡ್ annexure H ಕೈಲಿ annexure H in page number 40. That is the dispute ಅಲ್ಲೇ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ. ನೋಡಿ ಅಲ್ಲಿ 4ನೇ ಪೇಜ್ ನಾವು ಫ್ರಮ್ ದಿ 4th ಲೈನ್ ನೋಡಿ. ಸರ್ಕಾರಿ ಭೂಮಾಪಕರ ಅಳತೆಗಾಗಿ ದಿನಾಂಕ 23/4/21 ತಿಳಿಪಡಿಸಿ ಅರ್ಜಿದಾರರಿಗೆ ಮತ್ತು ಬಾಡಿದಾರರಿಗೆ ಮುಂಚಿತವಾಗಿ ತಿಳುವಳಿಕೆ ನೋಟಿಸ್ ನೀಡಿ
ಜಾರಿ ಮಾಡಿ ಸರ್ವೆ ದಾಖಲೆಗಳೊಂದಿಗೆ ಜಂಟಿ ನಕ್ಷೆ ತಯಾರಿಸಿಕೊಂಡು ಸ್ಥಳಕ್ಕೆ ಹಾಜರಾಗಿ ಪರಿಶೀಲಿಸಿ ಅಳತೆ ಮಾಡಿದಂತೆ ಸರ್ವೆ ನಂಬರ್ 179
ಮೇಲೆ ನಮ್ದು ಸಮೇತ 179 ನಮ್ದು ಲಾಗು 183 ಅತಿವ್ಯಾಪ್ತಿ ಆಗಿರೋದಾಗಿ ಅಳತೆ ಸಮಯದಲ್ಲಿ ಹಾಜರಿದ್ದೆ. ಅವ್ರು ಹೋಗ್ಲೇ ತಿಳುವಳಿಕೆ ನೀಡಿ ಸದರಿ ಅರ್ಜಿಯನ್ನು ಅಳತೆ ಮಾಡಲು ರಾವಿರುವುದನ್ನು ತಿಳಿಸಿ ಅರ್ಜಿಯನ್ನು ವಿಲೆ ಇಡಲು ಕಚೇರಿಗೆ ನಿಗದಿ ಮಾಡಿರುತ್ತಾರೆ. ಭೂಮಾಪಕರ ವರದಿಯಂತೆ ಹದ್ದುಬಸ್ತು ಕಡತವನ್ನು ಕಚೇರಿಯಲ್ಲಿ ವಿಲೆ ಇಡಲಾಗಿದೆ. ಇದ್ರ ಮೇಲೆ ನಾನು ಅನ್ನೆಕ್ಚರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಮುಂದೆ ರಿವಿಷನ್ ಹಾಕೊಂಡಿದ್ದೆ. ದಟ್ ಈಸ್ ಆರ್ಡರ್ ಪಾಸ್ ಬೈ ಅನ್ನೆಕ್ಚರ್ ಕೇಳಿ ನಾವು ರೆಸ್ಪಾಂಡೆಂಟು ನಮ್ದು ಎಲ್ಲ ಸೇರಿಕೆ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ಬಿಟ್ಟು ಇದು ಅದ್ಭುತ ಇದು ಮಾಡಿ ಮತ್ತೆ ಇದು ಮಾಡಿದೆ. ಆಕ್ಚುಲಿ ಅವ್ರು ಗ್ರಾಂಟೇ ಆಗಿಲ್ಲ. ದಟ್ ಈಸ್ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಗಿವನ್ ಬೈ ತಹಸೀಲ್ದಾರ್.
After the endorsement will have no consequence.
No, that is we have produced before the respondent.
Their names have been entered in the land records.
No, nothing. RTC
ಹೇಳ್ತಾ ಇದ್ರಲ್ರಿ. Otherwise how can they give this kind of an endorsement?
Well, that is suspicious. Kindly see annexure C parliament. So annexure D1 side ನೋಡಿ. Our grant certificate from OTJ. Annexure D in page number 24.
But anyway, what was granted to you was in survey number 179.
Movement man kindly. Annexure
What was granted to you was in 179.
One is
you claim ಮಾಡ್ತಾ ಇರೋದು it goes into survey number 183.
ಅವ್ರು ನಮ್ಮ ಮೇಲೆ ಬಂದಿದ್ದಾರೆ ಅಂತ ನಮ್ದು ಹೋಗೋದಿಲ್ಲ. ಅವ್ರು ಓವರ್ಲ್ಯಾಪ್ ಆಗಿದ್ದಾರೆ.
ನೀವು ಕೇಳ್ತಾ ಇರೋದು ಇವಾಗ ಅದ್ಭುತ ಮಾಡ್ಕೊಡಿ ಅನ್ನೋದು ಜಾಗ
179.
It will overlap into 183.
ಅವ್ರು ನಮ್ಮ ಮೇಲೆ ಬಂದಿದ್ದಾರೆ.
ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡ್ರದ್ರಿ
ಪ್ಲೀಸ್ ನಂದು 14 ಫಿಕ್ಸ್ ಮಾಡಿ ಅಂತ
ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ಅವ್ರು ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ರು.
ಅವ್ರು ಓವರ್ಲ್ಯಾಪ್ ಆಗಿದ್ದಾರೆ.
ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡು ನೀವು ಇವೆಂಟ್ ಬಿಫೋರ್ ದಿ ರೀಜನಲ್ ಜಾಯಿಂಟ್ ಡೈರೆಕ್ಟರ್. ವಾಟ್ ಇಸ್ ಇಸ್ ಒಪಿನಿಯನ್?
ಮೈ ಓಕೆ ಅವ್ರು ಗ್ರಾಂಟೇ ಇಲ್ಲ, ನಂದು ಒರಿಜಿನಲ್ ನಮ್ದು ಅಲ್ಲೇ 1976 ಅಲ್ಲಿ ಆಗುತ್ತೆ. ಮೈ ಗ್ರಾಂಟ್ ಇದು ಆಫ್ 1976, ಅವ್ರದ್ದು 1993 ಎಲ್ಲ ಆಗಿದೆ. That's why I'm kind of look into the annexure D for a moment.
Who has filed the suit? Who has filed the suit?
My father has filed it.
Against whom?
Against the impleading applicant's father. ಅದು ಡಿಗ್ರಿ ಆಗಿದೆ 85 ಹಾಕಿದ್ರೆ ಅದು ಡಿಗ್ರಿ ಆಗಿದೆ. ಡಿಕ್ಲರೇಷನ್ ಅದು ಡಿಗ್ರಿ ಆಗಿದೆ.
ಅವರು ನಿಮ್ ಬ್ರದರ್
ಅಲ್ಲ, ದೊಡ್ಡಪ್ಪ ಮಗ ಬ್ರದರ್ ಡಿಗ್ರಿ ಆಗಿದೆ.
ದಟ್ ಇಸ್ ಫಾರ್ ಓನ್ಲಿ ಪರ್ಮನೆಂಟ್ ಇಂಜಂಕ್ಷನ್.
ಫಾರ್ ಡಿಕ್ಲರೇಷನ್.
ಡಿಕ್ಲರೇಷನ್. ಡಿಕ್ಲರೇಷನ್
ಇವ್ರೇನ್ ಮಾಡ್ತಾರೆ ಈಗ ಅನೆಕ್ಷರ್ ಕಿಯಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಮೈಲಾಟ್ ಸೈಡ್ ರಿಸಿ ಅಬ್ಸರ್ವೇಟರ್ ಸೈಡ್ 48 ರಿವಿಷನ್ದಾರರ ತಂದೆಯವರ ಇದು ದಾಖಲಾದ OS 58/86 ವಜಾಗೊಳಿಸಿರುತ್ತಾರೆ. ವಜಾಗೊಳಿಸಿಲ್ಲ, ಡಿಗ್ರಿ ಆಗಿದೆ. ಈಸ್ ರಾಂಗ್ ಪುಟಿಂಗ್ ಮೇಲೆ ಹೋಗಿದ್ದಾರೆ ರೆಸ್ಪಾಂಡೆಂಟ್. ಅದು ಡಿಗ್ರಿ ಆಗಿರೋದು ನಮ್ಮ ಫೇವರ್. ನಮ್ಮ ಫಾದರ್ ಆಕ್ಟಿವ್ 1985 3/16 ಗಂಟೆಗೆ ನಮ್ದು ಏನ್ ಗ್ರಾಂಟ್ ಆಗುತ್ತೋ ಅದು ಡಿಗ್ರಿ ಆಗಿದೆ. ಡಿಕ್ಲರೇಷನ್
ಆಕ್ಚುಲಿ ಡಿಗ್ರಿ
ಆಕ್ಚುಲಿ ಡಿಗ್ರಿ ಅವ್ರು ರಾಂಗ್ ಪುಟಿಂಗ್ ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ಅದರಿಂದ ಇದು ಬರೋದಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ಬೋದು ರೆಸ್ಪಾಂಡೆಂಟ್. ಇವ್ರು ಸಮೇತ ಅನೆಕ್ಷರ್ ಡಿಸ್ ಫಾರ್ ಮೂಮೆಂಟ್ ಮೈಲಿ ಕೈಲಿ ಸಿಮಿಲರ್ 93 ಅವ್ರು ಗ್ರಾಂಟ್ ಆಗೋದು, ನಮ್ದು 76ನೇ ಇಸ್ವಿನಲ್ಲಿ ಗ್ರಾಂಟ್ ಆಗೋದು. ಮತ್ತೆ ಗ್ರಾಂಟ್ ಆಗೋಕ್ ಮೊದಲೇ ಅವ್ರಿಗೆ ಕೋಡಿ ಮಾಡ್ತಾರೆ.
ಅಲ್ಲಿ ಡ್ಯೂರಿಂಗ್ ದಿ ಪ್ರೊಸೀಡಿಂಗ್ ಬಿಫೋರ್ ದಿ appellate court, an application was filed and the ADLR was directed to conduct the survey. ಓದಿ ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲೇ ಅದೇ ಪೇಜ್ ನಂಬರ್ 48 ಅಲ್ಲಿ ಇವಾಗ ಓದಿದ್ರಲ್ಲ ನೀವು, ವಜಾಗೊಳಿಸಿರುತ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್
ಎದುರುದಾರರಾಗಿ ಡಿಗ್ರಿ ಆಗಿರುತ್ತೆ ತಪ್ಪು. OS 58/86 ತೀರ್ಪಿನಿಂದ ಬಾಧಿತರಾಗಿ ರಿವಿಷನ್ದಾರರ ತಂದೆಯವರು ಇದು ಬಾಧಿತರು ನಾವು ಆಗೋದೇ ಇಲ್ಲ, ನಮ್ಮ ಫೇವರಾಗಿ
ಯಾರಾದ್ರೂ ಆಗ್ಲಿ ರೀ, ಹೋಗಿದ್ದಾರೆ ಅಪೀಲ್ ಹೋಗಿದ್ದಾರೆ,
ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಅವ್ರದ್ದು.
ಓದಿ ಪ್ಲೀಸ್ ರೀಡ್ ಇಟ್.
ನಿಯಮಿತ ಮೇಲ್ಮನವಿ 6/9/98 ದಾಖಲಿಸಿದ್ದು ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಆಗಿ ADLR ಅನ್ನು ನೇಮಕ ಮಾಡಲು ಕೋರಿ ಮಧ್ಯಂತರ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಘನ ಸೀನಿಯರ್ ಸಿವಿಲ್ ಜಡ್ಜ್ ಪ್ರಕರಣವನ್ನು ಕೆಳನ್ಯಾಯಾಲಯಕ್ಕೆ ಕೌಂಟರ್ ಸೂಟ್ನೊಂದಿಗೆ ರಿಮ್ಯಾಂಡ್ ಬ್ಯಾಕ್ ಮಾಡಿರುತ್ತಾರೆ. ಪ್ರಕರಣಗಳು ರಿಮ್ಯಾಂಡ್ ಆದ ನಂತರ ಘನ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯ ಜಡ್ಜ್ ಅವರು 6/9/1990 ಗಮನಿಸಲಾದಂತೆ ಸಿವಿಲ್ ಜಡ್ಜ್ ಕೋರ್ಟ್ ಶಿಡ್ಲಘಟ್ಟರ್ ಅವರು ADLR ಅವರನ್ನು ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಆಗಿ ನೇಮಕ ಮಾಡಿರುತ್ತಾರೆ. ಸದರಿ ಕೋರ್ಟ್ ಕಮಿಷನರ್ ADLR ಅವರು ಸರ್ವೆ ನಂಬರ್ 189ರಲ್ಲಿ ರಿವಿಷನ್ ಕುಟುಂಬದವರ ಸ್ವಾಧೀನ ಸ್ಥಳವನ್ನು ಗುರುತಿಸಿ ಮಾರ್ಕ್ ಮಾಡಿರುತ್ತಾರೆ. ಇದು 2 ಎಕರೆ 30 ಗುಂಟೆ ಇರುತ್ತದೆ. ಈ ಸಿವಿಲ್ ಜಡ್ಜ್ ರವರಿಗೆ ADLR ಅವರು 1993ರ ಹಿಸ್ಟ್ರಿಯಲ್ಲಿ ಕೊಟ್ಟಿರುವ ವರದಿಯ ಈ ತಕರಾರಿನ ಪ್ಯಾರಾದಲ್ಲಿ ನಮೂದಾಗಿರುವ ಚೆಕ್ಕುಬಂದಿಗಳನ್ನು ಪ್ರತಿಬಿಂಬಿಸುತ್ತದೆ. ಡಿವಿಷನ್ದಾರ್ ಅವರು ಈಗ ಕೋರಿಕೊಂಡಿರುವುದಕ್ಕೂ ADLR ಅವರು ಕೋರ್ಟ್ ಕಮಿಷನರ್ ವರದಿಗೂ ಹಾಲಿ DDLR ವರದಿಗೂ ಒಂದಕ್ಕೊಂದು ಸಾಮರಸ್ಯವಿರುವುದಿಲ್ಲ. ಡಿಗ್ರಿ has been granted in 3 acres.
ಹೌದ್ರಿ, at your instance the ADLR was appointed as a court commissioner and he has submitted a report to the court. ಅಲ್ಲಿ ಏನ್ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರು ನಿಮ್ಮ ಹೇಳಿಕೆ ಪ್ರಕಾರ 2 acres 30 ಗುಂಟಾಸ್ ಏನ್ ಮಾರ್ಕ್ ಮಾಡಿ ತೋರಿಸಿದ್ರು ಅದನ್ನು ಇವಾಗ ನೀವು ತೋರಿಸ್ತಾ ಇರೋದಕ್ಕೂ ವ್ಯತ್ಯಾಸ ಇದೆ ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ.
ನಾನು ಇರುವಂತದ್ದು 3 ಎಕರೆ 16 ಗುಂಟೆ ಇದೆ. ಅದು ಇದರಲ್ಲೂ ಆಗಿದೆ, ಡಿಗ್ರಿ ಆಗಿದೆ. ಸಿವಿಲ್ ಕೋರ್ಟ್ has been granted same day shoot ಮೇಲೆ ಡಿಗ್ರಿ has been granted kindly.
ಡಿಗ್ರಿ has been granted no doubt. ಬಟ್ ಅಲ್ಲಿ ಆ ಟೈಮ್ ಅಲ್ಲಿ ಏನ್ ಮಾರ್ಕ್ ಮಾಡಿದ್ದಾರೆ ಸರ್ವೆ ಅಥಾರಿಟೀಸ್, ಅದಕ್ಕೂ ಇವಾಗ ನೀವು ಕೇಳ್ತಾ ಇರೋದಕ್ಕೂ ವ್ಯತ್ಯಾಸ ಇದೆ ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ. ತಾಳೆ ಆಗ್ತಾ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಒರಿಜಿನಲ್ ಗ್ರಾಂಟ್ ನಂದು ಏನಿದೆ,
ಸೊ ಇಫ್ ಯು ರೆಸ್ಟ್ರಿಕ್ಟ್ ಇಟ್ ಟು ದಿ ಕ್ಲೇಮ್ ಆಸ್ ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ದಿ ಸ್ಕೆಚ್ ಪ್ರಿಪೇರ್ಡ್ ಡ್ಯೂರಿಂಗ್ ದಿ process of that appeal, then there is no difficulty. Otherwise not possible. Can't now seek change.
No, not seeking, my lord. What I am claiming on my original grant. Nandu ಏನು original grant ಏನಾಗಿದೆ ಅದು ಪ್ರಕಾರ ಲಗ್ಗೋ ಲಿಸ್ಟ್ ಮಾಡಿ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಅಷ್ಟೇ. 3 ಎಕರೆ
can be restricted in terms of the sketch that was prepared during the RA.
ಆರ್ಯದಲ್ಲಿ ನಮ್ಗೆ ಎಷ್ಟು ಪೋರ್ಷನ್ ಇದೆ ಅಂತ ಸ್ಕೆಚ್ ಪ್ರಿಪೇರ್ ಮಾಡಿದ್ದಾರೆ.
ಹಾಕಿದಾರಲ್ಲ 2 acres 13 ಗುಂಟಾಸ್
ಅದು ಅದೇ
ಅಷ್ಟೇ.
ಅವ್ರು ಓವರ್ಲ್ಯಾಪ್ ಇದ್ದಾರೆ ಅಂತ ನಾನು ಅದ್ಭುತ ಫಿಕ್ಸ್ ಮಾಡಿ ಮತ್ತೆ ಕೇಳಿದ್ದೆ.
ಅದೇ
ಅದರಿಂದ
ನೀವ್ ಇವಾಗ ತೋರಿಸ್ತಾರ ಚೆಕ್ ಬಂದಿ ಬೇರೆ.
ಗ್ರಾಂಟ್ ಏನಾಗಿದೆ ಅದ್ರ ಪ್ರಕಾರ ಕೊಡಿ ಅಂತ ನಾನು ಕೇಳ್ತಿದ್ದೀನಿ ಅಷ್ಟೇ.
Then it can be restricted in terms of the sketch prepared as it stated in that paragraph.
ನನ್ನ ಮೇಲೆ ಓವರ್ಲ್ಯಾಪ್ ಆಗಿದ್ದಾರೆ ಅಂತ.
ಇಲ್ಲ, you have to restrict your claim as was done before the appellate court. If that is done, then there is no difficulty. ಅವ್ರದೇ ಬೇರೆ ನಿಂದೆ ಬೇರೆ.
ಅವ್ರು ಗ್ರಾಂಟ್ ಆಗಿಲ್ಲ ಅಂತ ಕೇಳ್ತೀನಿ.
You are not concerned with their grant. You are only concerned with your grant.
Yes, I am concerned with my.
Therefore, that property that was granted to you has been identified in the presence of the appellate court.
My grant
ಅದನ್ನೇ ಹೇಳ್ತಾರದು.
ಅನೆಕ್ಷನ್ ದಯವಿಟ್ಟು ಒಂದ್ಸಲ 3 ಎಕರೆ 16 ಗುಂಟೆ ನನಗೆ ಗ್ರಾಂಟ್ ಆಗಿರೋದು. 3 ಎಕರೆ 16 ಗುಂಟೆ.
Please go through the order properly, and if you restrict your claim in terms that survey sketch prepared during the pendency of the regular appeal, then there is no difficulty. There is no question of overlap. ಅದನ್ನ ಬಿಟ್ಟು ನೀವು ಇವಾಗ ಬೇರೆ ತೋರಿಸ್ತಾ ಇದ್ರೆ
ಬೇರೆ ನಾನು ಬೇರೆ ಏನು ತೋರಿಸ್ತಿಲ್ಲ ಸರ್, ನಾನು ಗ್ರಾಂಟ್ ಪ್ರಕಾರ.
then you restrict your claim in terms of that order.
In respect of annexure A per kailis, annexure ನಾನು 76ನೇ ಇಸ್ವಿಯಲ್ಲಿ 3 ಎಕರೆ
ಬರ್ಕೊಳ್ಳಿ.
annexure A per.
I am not disposing of the matter. You please go through the order properly, and if you are satisfied, yes, at that point of time survey has been conducted and report has been submitted to the appellate court, and according to that the decree has been passed. You restrict your claim to the property that was identified before the appellate court, then all the problem will be solved.
ಗ್ರಾಂಟ್ ಆಗಿಲ್ಲ ಅಂತ.
You are not concerned with their grant. We are only concerned with your grant.
Yes, I am concerned.
It has been identified. So it will be restricted only to that.
Then what about the grant? 3 ಎಕರೆ 3 ಎಕರೆ 16 ಗುಂಟೆ ಗ್ರಾಂಟ್ ಆಗಿದೆ.
We do not know. You have accepted that finding.
No, I am not accepting it. That's why I made an application before the.
ಅದಲ್ರಿ appellate court ಮುಂದೆ. That judgment has attained finality.
It mean my favor.
ಹೌದು.
3 ಎಕರೆ 16.
ಎಲ್ಲಿದೆ? Where is that judgment of the appellate court? Yes. So if it is restricted in terms of the decree passed by the civil court, then there is no difficulty.
The suit of the plaintiff is measurement decree ಮಾಡ್ತಾರೆ. measurement decree ಮಾಡುವ. Is decreed in OS 58 of 86 is again if the defendant is.
ಯಾವ್ದು ಓದ್ತಾ ಇದ್ದೀರಾ ನೀವು ಇವಾಗ?
OS ಅದು ಈಗ 85 ಅಲ್ಲಿ ಆಗಿರುವಂತದ್ದು.
ಇದು ಒರಿಜಿನಲ್ ಜಡ್ಜ್ಮೆಂಟ್.
ಪ್ಲೀಸ್ ಮೇಡಮ್.
ಅದಾದ್ಮೇಲೆ
ರಿಮ್ಯಾಂಡ್ ಆದ್ಮೇಲೆ ಆಗಿದೆ ತಪ್ಪು. ಅವ್ರಿಗೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ತಪ್ಪು, ಅದೇ ರಾಂಗ್ ಅಂತ ನಾವು ಅಪೀಲ್ ಅಲ್ಲಿ ಆಗಿಲ್ಲ. ವಯಸ್ಸಲ್ಲಿ ಆಗೋದು
ರಿಮಾಂಡ್ ಆದ್ಮೇಲೆ. Please read that portion regarding the ADLR's report.
ಅವರೇ ಜಡ್ಜ್ಮೆಂಟ್
ಇವಾಗ ಕೈಯಲ್ಲಿ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ಅದಲ್ರಿ. ADLR ರಿಪೋರ್ಟ್ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ ಈ ತರ ವೇರ್ ಇಸ್ ಇಟ್? ಪ್ಲೀಸ್ ಪಾಯಿಂಟ್ ಔಟ್.
ಡಿಕ್ರೀಡ್ ಅಂಡ್ ಇಟ್ ಈಸ್ ಡಿಕ್ಲೇರ್ಡ್ ದಟ್ ಪ್ಲೇಂಟಿಫ್.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ADLRದು ರಿಪೋರ್ಟ್ ಅದ್ರ ಬಗ್ಗೆ ಹೇಳಿದೆ. ಪ್ಲೀಸ್ ಪಾಯಿಂಟ್ ಔಟ್.
ಅದರಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳಿಲ್ಲ.
ಹೌ ಕ್ಯಾನ್ ಇಟ್ ಬಿ?
ಹೇಳಿಲ್ಲ.
ಮತ್ತೆ ಎಲ್ಲಿ ಬಂತು ಆಲ್ ದಿಸ್ ಇನ್ಫಾರ್ಮೇಶನ್? This information that you just read out now, the appointment of the ADLR as court commissioner and his report submitted before the court, where is all this? 23 of ಈ judgment ಅಲ್ಲಿ internal page 23. Yes. ಇದಲ್ಲ ಪೇಜ್ ನಂಬರ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 20 ಓದ್ರಿ.
In this case, in this suit, the application of the plaintiff under order 2829 of CPC, the ADLR Tippalapur was appointed as court commissioner and visited the spot by giving notices to the both parties. Court commissioner has measured the land by defendants in their presence and submitted his report, exhibit C1 and C2.
along with sketch as per exhibit C1 and C2.
C2.
On seeing the sketch of the commissioner, it is clear
Clear that
that the plaintiff has been granted 3 acres of land
in survey number
20
20.
of good,
Gudiyal village.
ah,
Gudiyal village.
and the
And the-
commissioner has shown the land of the plaintiff which is in his possession,
Question,
measuring 2 acres 30 kuntas
30 kuntas.
in green
See.
and yellow color is in exhibit C1
C1.
sketch.
Yes.
And he has also shown the area of the grape garden in green color measuring 1 acre 16 guntas. And the commissioner has shown another 7 guntas of land abutting 2 acres and 30 guntas of land, and which according to the defendant, it does not belong to belong to him. The court commissioner has further stated in his sketch that the defendant's land is situated towards the western side of the grape garden of the plaintiff's land measuring 1 acre 38 guntas, and it was in possession of the defendants. Therefore, now a question would arise whether the boundaries given by the plaintiffs are correct or not, has to be looked into. According to the plaintiff, he has given the schedule of his land towards east government Vanke and Muni Venkatappa's land, west land of Narsamma,
Assam.
and north land of Dodda Narayanappa, and south land of Muni Venkatappa and another. But on the other hand, the commissioner has given the boundaries of the suit schedule property towards east Muni Venkatappa's land and Vanke,
Respondent.
west the land of defendant, north land of Dodda Narayanappa, and south Muni Venkatappa's land, and therefore there is dispute with regarding the boundaries of the suit schedule property. On careful scrutiny of the records and the sketch of the commissioner has shown the land of the plaintiff, which is in his possession, extend 2 acres and 30 guntas in green and yellow color, and 7 guntas abutting to the land in between south and west corner. And in the evidence, PW1 plaintiff has not stated about the 7 guntas of land to whom it belongs. Simply, he has stated that the commissioner has submitted his report wrongly, and if we have taken into consideration the land which is in possession of the plaintiffs, 2 acres 30 guntas plus 7 guntas, it would be 2 acres 37 guntas. And in the sketch, the commissioner has stated that the plaintiff was in possession of land measuring 2 acres 30 guntas, and defendants are in possession and cultivating the lands measuring 1 acre 8 guntas. And the said 1 acre 8 guntas of land is situated in between the land of the plaintiff and the land of Narsamma. If we take into consideration those portions of land, 2 acres 30 guntas plus 1 acre 8 guntas, it would be 3 acres 38 guntas. And therefore, I am of the opinion that the plaintiff has given wrong boundaries of the suit schedule property towards western side in the plain schedule, and the plaintiff has given the western boundary of Narsamma's land.
Final order. ತ್ರೀ ಎಕರ್ಸ್ ಗೆ ಓನರ್ ಡಿಕ್ಲೇರ್ ಮಾಡಿದ್ದಾರೆ. ಮತ್ತೆ ಈಗ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೆಂಟ್ ಏನಿದ್ದಾರೆ ಅವ್ರ ಕಡೆಯಿಂದ 3 ಗುಂಟೆ ಅವರು ತಗೊಂಡಿದ್ದಾರೆ, ಇನ್ನು 3 ಗಂಟೆ ಟೋಟಲ್ 3 ಎಕರ್ 3 ಗುಂಟಾಸ್ಗೆ ಡಿಕ್ಲರೇಷನ್.
And it is further ordered and decreed that the land of the defendants is situated an extent of about 1 acre 25 guntas in between the land of the plaintiff, that is the suit schedule property, and the land of Narsamma. And the plaintiff is entitled to claim 3 guntas of land which is in possession of the defendants towards the western side of his
ಟೋಟಲ್
grape garden. And the defendants, their agents, are restrained from interfering with the lawful possession and enjoyment of the social property.
ಟೋಟಲ್ 3 ಎಕರ್ 3 ಗುಂಟಾಸ್ಗೆ ನಂದಿದಾವೆ. One sir, unauthorized cultivation is land on.
This order certain a finality,
Please, madam.
you have not questioned it. Huh? So you cannot say now our grant ಆಗಿಲ್ಲ ಅವ್ರ ಜಾಗನೇ ಇಲ್ಲ ಅದೆಲ್ಲ ಏನು ಹೇಳಕ್ ಬರಲ್ಲ ನೀವು.
ಅಲ್ಲ,
Even as per this decree, the defendant, he is the defendant. You are the defendant. Aura.
ಅವ್ರು ಡಿಫೆಂಡ್.
ಹಾ
ಇವ್ರ ಪಾರ್ಟಿ ಅಲ್ಲ ಅವ್ರು.
ಹಾ
ಇವ್ರ ಪಾರ್ಟಿ ಅಲ್ಲ.
ಹಾ ನಿಮ್ದು ಯಾವ್ದು ಜಾಗ? ಹಾ ಹಾ ಎಸ್ ಹಾ ನೀವಾ?
And granted to in my favor. I am assessing order of the petitioner.
Commissioner has given boundaries of the social property towards east Munivenkatappa's land. Munivenkateswamy, ನೀವಾ? So towards the east of their property is your property. Then it is an admitted fact then. It is an admitted fact.
ಅವರು they are in position of east ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ.
ಹೌದು.
Annexure D ತಗೋದು ದಯವಿಟ್ಟು ಒಂದ್ಸಲ. Annexure D ತಗೋತಾರೆ.
Why should I go to any other document now?
ಅವರು ಡಾಕ್ಯುಮೆಂಟ್.
If you have accepted this,
ಪ್ಲೀಸ್.
then there is a property of theirs towards the eastern side of your property.
ಪ್ಲೀಸ್ ಮೇಡಮ್.
ಹೌದು.
ನಂಗೆ 3 ಎಕರೆ 3 ಗಂಟೆಗೆ ಡಿಗ್ರಿ ಆದ್ರೆ ಅವ್ರು ತಗೊಳ್ಳಿ ನಮ್ದೇನು ಅಬ್ಜೆಕ್ಷನ್. 3 ಎಕರೆ 3 ಗುಂಟಾಸ್ ನನಗೆ ಡಿಗ್ರಿ ಆಗಿದೆ ಅದಕ್ಕೆ ನನ್ಗೆ ಅಡ್ವಾನ್ಸ್ ಫಿಕ್ಸ್ ಮಾಡ್ಕೊಟ್ಟು ನಮ್ದೇನು ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಏನು ತಗೊಳ್ಳಿ ಏನೋ ಬಿಕಾಸ್ ನಾನು 1976 ಅಲ್ಲಿ ನನ್ಗೆ ಗ್ರಾಂಟ್ ಆಗುತ್ತೆ, 93 ಎಸ್ಪಿಲ್ ಅವ್ರಿಗೆ ಗ್ರಾಂಟ್ ಆಗುತ್ತೆ.
ಏನ್ ಮಾಡಿದಾರೆ ಈ ಆರ್ಡರ್ ಅಲ್ಲಿ?
ಇಬ್ಬರಿಗೂ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ಕೊಂಡು ರೀಯೂಸ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಮಾಡಿ
ರೀಸರ್ವೆ ಮಾಡಿ ಅಂತಾರೆ.
ಮಾಡಿ ಇನ್ ಅಕಾರ್ಡೆನ್ಸ್ ವಿತ್ ದಿಸ್ ಡಿಗ್ರಿ.
ಅಲ್ಲ ದಯವಿಟ್ಟು ಸ್ವಾಮಿ Annexure D ಫಾರ್ Annexure D ಸರ್. Annexure D ಟೇಪ್ಡ್ ಕಾಪಿ ಆಫ್ ಇದಾಕಿದ್ದೀನಿ ನಾವು ಗ್ರಾಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇನ್ ಪೇಜ್ ನಂಬರ್ 32 ಸರ್.
See, we will make it clear that your land should be identified in terms of this decree.
Please.
And towards east of your property is the property belonging to this respondent.
179 ನಮ್ದು ಸರ್, ಅವ್ರದ್ದು 183 ಅವ್ರು. ಫಸ್ಟ್ ನಮ್ದು ಸರ್ವೆ ಮಾಡಿ 3 ಎಕರೆಗೆ 3 ಎಕರೆ 3 ಗಂಟೆಗೆ ಬೌಂಡ್ರಿ ಫಿಕ್ಸ್ ಮಾಡ್ಬಿಟ್ಟು ಆಮೇಲೆ
ಅದೇ ಮೋಸ್ಟ್ಲಿ ಅದೇ ತರ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲ ಆ ತರ ಮಾಡಿದ್ದಾರೆ. ತಾವು Annexure D ಫಾರ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಕೈಂಡ್ಲಿ ಸಿ. ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ನಾನು ಯಾಕೆ ಸಸ್ಪೆಕ್ಟ್
read the operative portion. ಮೇಲಿನ ಖಂಡಿಕೆಗಳಲ್ಲಿ ವಿವರಿಸಿದಂತೆ
ಇರುವಂತೆ ಶಿಡ್ಲಘಟ್ಟ ತಾಲೂಕು ಕಸ್ಬಾ ಹೋಬಳಿ ಗುಡ್ಡಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 179 ನಮ್ದು ಸರ್ ಸರ್ವೆ ನಂಬರ್ 183 ಸರ್ವೆ ದಾಖಲೆಗಳನ್ನು ರದ್ದುಪಡಿಸಿದೆ. ರದ್ದುಪಡಿಸಲಾದ ಸರ್ವೆ ನಂಬರ್ 179 ಮತ್ತು 183 ವಿಸ್ತೀರ್ಣವನ್ನು ಈ ಮೊದಲಿನಂತೆ ಸರ್ವೆ ನಂಬರ್ 20ಕ್ಕೆ ಸೇರಿಸಿಕೊಂಡು ಸ್ಥಳದಂತೆ ಪರಿಶೀಲಿಸಿ ಭೂ ಮಂಜೂರಾತಿ ಪ್ರಕರಣಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ಕಾಯ್ದೆ ನಿಯಮಾನುಗಳನ್ವಯ ಹಾಗೂ ಸರ್ಕಾರದಿಂದ ಹಾಗೂ ಆಯುಕ್ತರು ಭೂಮಾಪನ ಕಂದಾಯ ವ್ಯವಸ್ಥೆ ಹಾಗೂ ಭೂ ದಾಖಲೆಗಳ ಇಲಾಖೆಯವರಿಂದ ಹೊರಡಿಸಲಾದ ಸುತ್ತೋಲೆಗಳನ್ನು ಅನುಸರಿಸಿಕೊಂಡು ಪ್ರಕರಣವನ್ನು ಇತ್ಯರ್ಥಪಡಿಸಲು ಭೂ ದಾಖಲೆಗಳ ಉಪ ನಿರ್ದೇಶಕರು ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಜಿಲ್ಲೆ ಹಾಗೂ ಭೂ ದಾಖಲೆಗಳ ಸಹಾಯಕ ನಿರ್ದೇಶಕರು ಶಿಡ್ಲಘಟ್ಟ ತಾಲೂಕಿಗೆ ಸೂಚಿಸಿದರು.
It can be done only in terms of the judgment and decree, not with reference to any other circular. ಹಂಗಲ್ಲ ಆಗೋದಿಲ್ಲ.
ನಾನು 3 ಎಕರೆ 3 ಗಂಟೆಗೆ ಬಸ್ ಫಿಕ್ಸ್ ಮಾಡಿ ಆಮೇಲೆ ಇದ್ದ ತಗೊಳ್ಳಿ, ನಂದೇನು ಅಬ್ಜೆಕ್ಷನ್. ಅಲ್ಲಿ ಏನಾಗುತ್ತೆ ಸ್ವಾಮಿ, ತಾವು ಯಾಕೆ ನಾನು ಸಸ್ಪಿಷಿಯಸ್ ನಮ್ಮ ಮುಂದೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅಂದ್ರೆ 93 ಗ್ರಾಂಟ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ. ಅದು ಆ ಗ್ರಾಂಟ್ ಆಗ ಮೊದಲೇ ಆಕಾರ ಬಂದು ಫಿಕ್ಸ್ ಮಾಡಿ
ಹಂಗಾಗಲ್ಲ ರೀ. ಇವಾಗ we can't go back on all that.
ಯಾವ ತರ
Even in terms of that decree, towards the east of your property is the property belonging to this person.
ಅದು ಸರ್ವೆ ನಂಬರ್ 183.
Where is that sketch? our furnish tender ಮಾಡಿದ sketch ಅಲ್ಲಿ ಇದೆ, which is the basis for this judgment. Where is the sketch?
85 ಅಲ್ಲಿ ಆಗಿರೋದು. ಪ್ರೊಡ್ಯೂಸ್ ಇಟ್ ಮೇಡಮ್. I'll place it. I'll place it. ಈಗ ಅವ್ರು ಬೇಕಾ ಈಸ್ಟರ್ನ್ ಸೈಡ್ ಏನ್ ಹೇಳ್ತಿದ್ದಾರೆ ನೀವು ಅದು ಬೇರೆ ಸರ್ವೆ ನಂಬರ್, ಸದರ್ನ್ ಸೈಡ್ ಅವ್ರು ಬರೋದು ಆ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ. ಸರ್ವೆ ನಂಬರ್ 20 ಸದರ್ನ್ ಸೈಡ್ ಏನ್ ತೋರಿಸ್ತಾರೆ ಅದು ಈಸ್ಟರ್ನ್ ಸೈಡ್ ಬೇರೆ ಸರ್ವೆ ನಂಬರ್.
Where is that?
ಬೇರೆ ಸರ್ವೆ ಅವ್ರದ್ದೇ ಬೇರೆ ಸರ್ವೆ.
Where is that judgment and decree we read out just now?
ಅದನ್ನ ಹಾಕಿಲ್ಲ ಸರ್. ಈಗ ಅವ್ರು ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಬಂದಿದ್ದು ನಾವು ಹಾಕೋದು. ಈಗ ಅವ್ರ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಬಂದಿದ್ರಿಂದ ಅದನ್ನ ನಾವೀಗ ಫೇಸ್ ಮಾಡ್ತೀವಿ.
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ? ಯಾರ ಹತ್ರ ಇದೆ ಇದು?
ಚೀಚ್ ನಮ್ಮ ಹತ್ರ ಕೊಟ್ಟಿದ್ದೀಯಾ?
Please get it.
Please.
Then we will allow the application, let them come on record. Because he is the defendant in that suit.
Yes, he is.
He is the defendant in that suit and he will become necessary party because all these are neighboring properties. Without the presence of one of them, if we pass any orders, his rights will be affected because there is a decree in his favor also.
Our favor again.
In that decree that was passed in your favor, his also is a neighboring property. So therefore, it cannot be done without the presence of this person.
Actually,
They have to be there.
ಅಲ್ಲ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ಅನಾಥರೈಸ್ಡ್ ಕಲ್ಟಿವೇಷನ್ ಇನ್ನು ಅವ್ರು ಕನ್ಫರ್ಮ್ ಆಗಿಲ್ಲ.
ಯಾವುದು?
ಅವ್ರದ್ದೇ ಇಂಪ್ಲೀಡಿಂಗ್
ಅದೆಲ್ಲ ಬೇಕಾಗಲ್ಲ. We will not go into all those aspects.
Claiming that I am unauthorized.
We are only concerned with the application filed for setting aside the previous body. And you are saying no, you don't want that body to be set aside.
Yes, because
Are you asking for a fresh body?
no, I want to.
Yes.
Fresh. ನಮ್ದು ಏನಿದೆ 3 ಎಕರೆ 3 ಗಂಟೆಗೆ ಅದು ಬಸ್ ಫಿಕ್ಸ್ ಮಾಡಿ.
This matter is coming up for preliminary hearing, is it? It is coming up for preliminary hearing.
Please, madam. Actually, so now impleading ಅಪ್ಲಿಕೇಶನ್ ಡಿಸ್ಮಿಸ್ ಆದ್ರೆ ಅವ್ರು ಇಟ್ಟು ಹಾಕೊಂಡ್ಬರ್ಬೇಕು ಮತ್ತೆ.
No, not necessary. Learned AGA takes notice for response number 1 to 5. Learned counsel Sri Murli M has entered appearance for response number 6 by filing a caveat petition. Learned counsel for petitioner is directed to serve a copy of the petition along the annexures on the learned AGA. Full stop. Next para. IA number 1 of 2024 has been filed by Sri Pacharayappa N, seeking to come on record. So, learned counsel for the impleading applicant has filed a memo along with copy of the judgment and decree passed in OS number 58 of 1986, clubbed with OS number 78 of 1986. So, learned counsel submits that the impleading applicant herein was the defendant in the suit.
Father of the impleading.
The father of the petition applicant.
The father of the applicant, impleading applicant is the particular.
That the impleading applicant's father,
Dodnarayana.
Sri Doddanarayanappa, was the defendant in OS number 58 of 1986 and plaintiff. ಇಬ್ರು ಇದಾರ. ಏನ್ ಹೇಳ್ದೆ?
Doddanarayanappa was defendant in OS number.
Was defendant number 1 and the applicant is defendant number 2 in OS number 58 of 1986, while the petitioner applicant along with his father Sri Doddanarayanappa were the plaintiffs in OS number 78 of 1986. Full stop. Learned counsel would therefore submit that any change in the fixation of boundaries would affect his rights, and therefore he would become a necessary party to these proceedings. Full stop. Next para. Although the learned counsel for the petitioner has pointed out from the impugned order that such an impleading application filed at the hands of the applicant herein was rejected by the joint regional
Director for.
Joint Director of Land Records, this court is of the considered opinion that the presence of the impleading applicant would be necessary to decide this case. Full stop. Accordingly, the application is allowed. The impleading applicant is directed to be made a party respondent to these proceedings. Full stop. Learned counsel for the petitioners shall carry out the amendment in the cost title and furnish amended cost title within a period of 1 week from today. Full stop. Next para. Having gone through the judgment and decree passed in OS number 58 of 86 and 78 of 86, this court finds that during the course of the proceedings, the ADLR was appointed as a commissioner and he submitted a report before the court. Full stop. This court would like to go through the said report, and therefore the learned counsels are requested to furnish a copy of the said report submitted by the ADLR before the trial court in OS number so and so so and.
Submission, my lord. Till that take, my lord. Otherwise, they are proceeded by the matter.
ಏನ್ ಮಾಡ್ತಾರೆ
ಅಲ್ಲಿ ಮಾಡಕ್ ರೆಡಿ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಏನ್ ಮಾಡ್ತಾರೆ
ಮತ್ತೆ ಸರ್ವೆ ಈಗ ಮಾಡೋದೇ ಸರ್ವೆ.
ಏನ್ ಮಾಡ್ತಾರೆ
ಸರ್ವೆ ಮಾಡಕ್ ಇದು ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಏನ್ ಮಾಡ್ತಾರ್ರಿ
ಹಳೆ ಸರ್ವೆ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಈಗ ಮಾಡಕ್ ರೆಡಿ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. Because of pressuring on the politicians.
Next para. During the pendency of these writ proceedings, nothing further shall be done by the survey authorities without specific orders being passed by this court.
Please, once ಅವ್ರಿಗೆ grant the copy ಕೊಡಕ್ಕೆ.
We are not going to all those aspects. That is why I said that has been recorded in the decree that his property is towards east of your property.
He's in position ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ. He's in position ಅಂತ ಹೇಳ್ತಾರೆ. ಅವ್ರಿಗೆ ಏನು grant
How can you challenge it now?
ನಾನು ಚಾಲೆಂಜ್ ಮಾಡ್ತಿಲ್ಲ.
You cannot go beyond what was allotted to you in terms of the decree. So we will maintain only that much.
Please.
You will not have any other claim.
I only influence in respect of 3 Good of the son.
Yes. 79 AP.
Here on behalf of the petition.
ಏನ್ರಿ ಹೇಳಿ No, this petitioner is not the person against whom proceedings were initiated.
The erstwhile owners are not made as a party. That is the office now.
Where is the order passed by the Assistant Commissioner?
Next, sir, my lord.
Proceedings were initiated against Ratnamma, Usha Trishur,
They are my vendors.
P. Siddheshwara Swami.
The petitioner.
They had sold it to him.
Yes.
Angadre, he is the aggrieved person. He is the aggrieved person. In 2005.
Yes, madam.
Then you didn't go before the.
I have approached the tribunal, madam. Kindly see page number 45, madam.
After 2020. After 2020. Same orders. Same orders. 79 AB though. Yadado 3271. 3271 of 2022. Same orders. You appear before the Assistant Commissioner on 20th of March.
Right.
Yes.
Non-compliance of resolution, serial number 17, order passed, serial number 80. Mamta Yamma.
2 weeks for compliance of office objections. Hmm. 79 AP. Huh? 15. Then disposed of. Office objections are overruled. Disposed of. Are they same? 3 to 7.
SR is not here in the issued order.
Huh?
SR, LRF, SR, 83, 846 for 2007 and 2008. SR.
Huh?
Only mentioned in the prayer.
In a proceedings bearing number LRF bracket 83, another bracket AK, ಆಮೇಲೆ 46 for 2007 2008 ಈ ತರ ಬರಲಿ. To appear on 20th.
So office objections are minor, my lords, are really given because it is applied. There's some urgency in this matter, my lords. So erstwhile landowner has got the RTC in his name after the acquisition, my lords, and now there's a threat he may alienate the property. The lodgement will file the land in question. It's survey number 165/2 measuring 29 Guptas in Kodigehalli village, Yelhanka, Hooghly. So 4-1 notification is an annexure D. 6-1 is that annexure E. There is a consent award in 1989. 16-2 is also passed. There is an office memorandum handing over possession to society in 1992. RT3 was standing in the name of the society. Resolution for layout plan is also passed. Respondent number 4, who's the erstwhile landowner, he filed writ petition questioning the acquisition, which was dismissed. Writ of being also dismissed. Thereafter, my lord, when the khata was made in the society's name, again it was questioned, but he withdrew it. Then, my lord, certain allottees approached this honorable court because there was a representation made by some landowner to drop this land from acquisition, and it was acted upon. Thereafter, there was an order recalling the order dropping it. That has been challenged by allottees, my lord. In that, there was one order where they said that without hearing the landowners, the order restoring the land to the society came to be passed. Now, my lords, in that order, it has now been recalled in the order passed with regard to the allotting. Now, relying on that order, where it had been set aside for non-hearing of the landowners, on that basis, my lords, the respondent number 1 DC said that the society has not taken any action regarding the dropping of acquisition, and therefore the RTC's order to be changed, my lords. Can you see, my lords, in the issued order at page 25? Page 25, point number 3, reliance is placed only on the order WP 32641 of 2002. Lords, that order has now been recalled, my lords, at annexure U.
That was not brought to the notice of the Deputy Commissioner?
Lord, it was brought to the notice of the Deputy Commissioner, but nevertheless, this order has come to be passed, my lord.
Where is that order?
But the lordship will find annexure U at page number 84. The operative portion is at page 108. Para 25. Through the above discussion, this court is of the considered opinion that order dated 6/7/2009, passed in WP number 32641 of 2002, is required to be recalled and is accordingly recalled. WP 32641/2002 is restored to 5. List so for hearing next week.
What happened after that?
Because after that, it was not come up for notes. And the logic to see and the improved order, the only reliance that is placed is on this petition order of 6/30/2009.
Learned, HCP takes notice for response number 1 to 3. Issue notice to respond number 4. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on the learned HCP. Full stop. Next para. Learned counsel for the petitioner, House Building Cooperative Society, submits that despite the fact that the challenge raised by the fourth respondent, landlord, to the acquisition proceedings being negative, nevertheless, on the basis of an order passed in WP number 32641 of 2002, dated 6th of July 2009, the impugned order has been passed by the Deputy Commissioner at Annexure A, directing re-entry of the name of the fourth respondent in the land records. So, learned counsel submits that the said order dated 6th of July 2009 was in fact recalled by a subsequent order dated 25th of July 2019 in WP number 29555-29570 of 2010. And therefore, it is impermissible for entering the name of the fourth respondent in the land records, since the society, petitioner society, has formed a layout and has distributed sites to its members. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order at Annexure A till the next date of hearing. Full stop. Next para. In the meanwhile, office objection shall be completed. Annexure A.
Petitioner
Office objection is overruled. Really?
Hello, the petitioner's father purchased the property in year 1952-63 is 7 number 73/1 to an extent of 1 acre 23 acres. In his lifetime, he is enjoyed. Thereafter, his petitioners are enjoyed. In the meanwhile, since they have got some other property other than the property what the land in question, they shifted their family to the Uttanandi of Devanandi. Now, the one Srinivasaya, the sons of Srinivasaya.
Ninth respondents filed the OS.
Eighth and ninth respondents filed a suit for declaration.
Who are they?
They are strangers to the property in question.
They are not related to you.
They are not related.
Huh?
They are claiming that they are the sons of Dodubapaya. Dodubapaya is the Dodubapaya son is.
What happened to the suit? What happened to the suit?
Suit was partly decreed in the trial court.
Huh? Where is it? Where is that judgment?
Those, annexure. 34 is the regular appeal. YS is 123.
Who filed this suit?
The.
You filed this suit.
The 8th and 9th, 8th and 9th respondent.
Respond number 8 and 9.
Yes.
Narayan Swamy and Ramakrishna.
Yes. Wherein the petitioner are not the parties. They filed a suit.
You are not a party.
I am not the party. They filed a suit only. Just, I will complete my. My lord, we are not the parties in this said suit. The suit filed by Srinivasa's children, Narayan Swamy and Ramakrishna, against one Lakshmi Narayan Swami. Lakshmi Narayan. After his demise, his wife and his children brought on record. Nagalakshma and others. In the said suit, the RTC stands in the name of Lakshmi Narayan Rao. RTC stands in the name of Lakshmi Narayan Rao. However, the property purchased by the petitioner's father in the year 1962-63.
He didn't get his name entered. He didn't get his name entered.
He has not approached the revenue authorities, and Lakshmi Narayan Rao continued as a.
He had purchased it from Lakshmi Narayan Rao.
No. He is purchased from other person.
Then how is that Lakshmi Narayan Rao came into the picture?
Rao said to be the Purohit of that temple. The temple, said the father of the petitioner was the trustee. So he purchased the property and he allowed the Lakshmi Narayan Rao to cultivate the same. He was continuing cultivating. However, the Srinivasa's children, Chettupu, the Doddapapaya's son, they filed a suit against Lakshmi Narayan Rao. The said suit came to be partly decreed, wherein Lakshmi Narayan Rao failed to prove adverse possession.
They claimed adverse possession.
Adverse possession. He is a tenant. They claimed that they are in adverse possession. However, the court holds in trial court that the possessory right is with Lakshmi Narayan Rao. Therefore, the title is not given to the Lakshmi Narayan Rao. The plaintiffs failed to prove their case. Therefore, suit was partly decreed. Against which both of
Partly decreed.
Partly decreed.
Yenanta?
Declaration.
So it was, the trial court declared that the indemnities were the owners, but the second one was rejected by the trial.
Yes.
To the extent that they are not in possession of property.
Yes.
And they conclude that these people are in possession of property. But
I will complete. Next, my
But,
lord.
what was the basis of their claim?
but
They were only on the basis of RTC.
Huh?
Only their names are appeared in the RTC. The court holds that they are in possession. Title is with the Srinivasa's children. And the possession is with Lakshmi Narayan Rao. Therefore, the suit is partly decreed.
Is it a fact that this Srinivasa's was the earlier owner?
No, he is not the earlier owner.
Then you purchased from whom?
I purchased from. Yes. Lakshmi Narayan Rao is father or not is not the owner. Lakshmi Narayan Rao is not the owner. The petitioner's father purchased
Venkataramanappa.
Venkataramanappa. So he is continued as a tenant under petitioner's father.
Anyway, there is a judgment.
There is a judgment
Declaring that he is the owner.
Subsequently,
RA.
thereafter, both, thereafter,
and this title has been set aside.
so since adverse possession was, though the trial court has not given proper this thing that he is in adverse possession, anyway he is in possession.
Right.
Both of them challenged by filing two regular appeals. In the said regular appeal, the first appeal,
Second appeal.
no, first appeal,
Ah,
RA.
ah,
In the said RA, the RA filed by the plaintiffs came to be rejected.
yes.
And the RA filed by the tenants, that is Lakshman Rao's illegal act,
Allowed,
that was allowed.
even that declaration that you are the owner of the property
Yes.
also was taken
No,
away.
that was goes.
Yes,
Now they preferred RSA, it is pending.
yes.
Now, without, this said fact was not known by the either the petitioner's father or the petitioners.
Ah.
So they learned from the records
Ah.
that they are not, their names are not entered in RTC
Ah,
and mutation.
ah,
They filed an appeal before the assistant commissioner.
hmm.
Assistant commissioner, after issuing notice, they filed all these proceedings.
Where is that, where is the order of the assistant commissioner?
Assistant commissioner order is 120, 127.
Who are the respondents there? Gopal, son of Lakshminarayan Rao.
Yes, they are the,
No, son of Lakshminarayan Rao.
they are
Girija,
these same Ramakrishna and Srinivasappa preferred the petitioner's fathers, the Ramakrishnappa and Srinivasappa preferred
you left out,
because their names are appeared in the articles. This Lakshman of Ella's names are appeared in the article. Therefore, they made as parties in the RA, the revenue appeal. The said appeal, they
that was rejected.
produced all the
Appeal was rejected.
appeal was rejected.
Ah,
Against which he preferred a review petition.
you.
Yes, the petitioners.
Ah,
That also came to be rejected by confirming the order of the assistant commissioner. Since there is a civil court judgment is that, therefore it was rejected.
correct.
Against which I prefer it.
Yes.
The RSA which is filed by the 8th and 9th respondent is still pending before the sample. In that case, I have filed an impleading application. That has to be yet to.
A tirman agli.
A tirman agli.
Your name cannot be entered.
I will come to the point. In the meanwhile, the Lakshmi Randra's Ellas sold the property in favor of one Srimati Padma. Padma now he is making attempts to put up a compound wall throughout the land in question.
Yes.
Now I saw that I have not, because recently that came to know that Padma purchased the property. So therefore,
We will pass orders at 2:30. We will dismiss the writ petition. 2:30, not now.
Yes.
You walk the car in straight.
Court officer? Court officer? Court officer?
Yes, madam.
ಲಿಸ್ಟ್ ಯಾವಾಗ ತಗೊಳ್ತಾರೆ ಸಾಹೇಬ್ರು?
ಲಿಸ್ಟ್ ಮಧ್ಯಾಹ್ನ ತಗೊಂತೇವೆ ಮೇಡಮ್.
2:30
2:30.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
appeal.
My lords, one submission, my lords. In serial number 13, I request for hand delivery of the Tribunal. There is some urgency.
Humble submission, one case, my lord. That my lordship, chief secretary, my lord, because of we are going to be under the process, my lord, it's initiated because of this assembly and with the budget preparation, my lord. It will not be, and time is not permitted, my lord. Within a short time, we will be compliant, my lord. Serial number 30, my lord. One accommodation may be 1 or 2 weeks, my lord.
Please wait, we'll come to it. We can't take it up like this. I'm in the midst of another ordered matter. Please wait till the matter reaches.
No, we had come, my lord, to the Supreme Court, some nice matter, my lord. It's going important. Will lordship permit me, and we will make submission. Otherwise, have it tomorrow, my lord. Will personally come there.
All right, let us see. Yes.
21 continuation. I'm moving in.
Sir, the bench of the Honorable Court has clearly decided on the basis of revenue entries, rate you cannot cross.
Correct.
So now the respondents, that is the Miscellaneous LRs, are not entitled to claim any title. However, after getting degree in their favor, they sold the property in favor of seventh respondent. Now the seventh respondent is making attempt to cut compound wall.
Yes.
So the AC and DC has rejected my plea because of civil court decision.
Yes.
In those two civil cases, the petitioners were not the party.
Sorry.
However, the property in question belongs to their father. After the demise of their father,
So therefore, it's a disputed question of law, sir. Who has to decide it? Only civil court can decide it.
Now my
How can we accept your contention and enter your names now?
now my
Not possible.
I am not seeking any entrance. Till disposal of that RSA, what they filed, till disposal of that RSA, the seventh respondent should not take any concern.
Those kind of an order cannot be passed in this writ petition, sir. We are only concerned with the revenue entries. Whatever submission you want to make, you go and make before the court considering the RSA. Such directions can be given by them. Not possible in this writ petition. Burkle. The petitioners are aggrieved of the impugned orders passed by the Assistant Commissioner at Annexure E and order of the Deputy Commissioner at Annexure F. Stop. First time ಬರ್ತಾರೋದಾ ಇದು? First time
Subjection is there.
Learned AGA takes notice for response number 1 to 3. Learned Counsel Sri Venkatesh Prasad has entered appearance for response number 5. So, response number 5. Where is that impugned order?
It's Annexure. And yeah.
Who was the contesting respondent before the Assistant Commissioner as well as the Deputy Commissioner. Full stop. Notice to the other respondents is not necessary for the following reasons. Next para. ಇವಾಗ ಅದನ್ನ ಹಾಕೊಳ್ಳಿ. are aggrieved of so and so, so and so. It was contended. The petitioners approached the Assistant Commissioner in RA bracket Ching close 296 of 2014-15, invoking section 136 bracket 2 of the Karnataka Land Revenue Act, challenging mutation orders passed in MR number 96-36 of 1994-95, semicolon MR 96-41 bar 95-96 and MR 15 of 2008-2009. So it was contended of the petitioners that their grandfather,
Petitioner's father.
ವೆಂಕಟಶ್ಯಾಮಪ್ಪ ಅಂತಿದೆ.
Petitioner's father is
ದೊಡ್ಡ ಪಾಪಯ್ಯ ಅಲ್ವಾ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದು ನಿಮ್ ಪ್ರಕಾರ?
ಅಲ್ಲಲ್ಲ. The petitioner father himself.
Petitioner's father is ವೆಂಕಟೇಶಪ್ಪ ಅಂತ ಬರ್ದಿದ್ದೀರಾ ನೀವಿಲ್ಲಿ?
ವೆಂಕಟೇಶಮಪ್ಪ. ವೆಂಕಟೇಶಮಪ್ಪ got the name.
No. In synopsis ಅಲ್ಲಿ ದೊಡ್ಡ ಪಾಪಯ್ಯ.
Grandfather of petitioner. But the sale deed executed in favor of Venkateshamappa, not Doddu Papa.
What is this, sir? Please see your synopsis.
Doddu Papa. Sorry.
Andre grandfather.
Grandfather.
That their grandfather Sri Doddu Papaya had purchased 1 acre 23 guntas in survey number 71/3 of Attur village, Kaivara Hobli, Chintamani Taluk, under registered sale deed dated 16/7/1962. However, his name was never entered in the revenue records. In the meanwhile, it appears that there were claim and counterclaim between the 8th and 9th respondents herein on the one hand and the other private respondents on the other hand. So, respondents number 8 and 9 filed OS number 23 of 2000 seeking declaration and consequential reliefs that they were the lawful owners of the land in question. The suit was partially decreed, declaring that although the plaintiffs therein were the owners of the property, nevertheless, the defendants have proved that they are in possession of the lands in question. In the regular appeal in RA 69 of 2004, ನೀವು ಇನ್ನೊಂದು ಹಾಕ್ತಾರ ಎರಡು ಹಾಕಿದ್ರ ಒಂದೇ ಅವಾಗ್ಲೇ ಈ ವಾಸ್ ಸೇಯಿಂಗ್ ದೇರ್ ವರ್ ಟು ವೇರ್ ಇಸ್ ದಟ್ ವಿಚ್ ಇಸ್ ದಟ್ RA
RA 69 and 74.
Where is that? Yes.
Page number
ಏನು ಹೇಳಿದೆ?
The suit was partially declaring that although the plaintiffs therein were owners of the property, nevertheless the defendants have proved that they are in possession of the land in question. In the regular appeal in RA number 16 in 2004,
Page number.
The plaintiffs challenge the portion of the order, portion of the judgment where the possession was denied. At the same time, some of the other defendants also filed RA 74 of 2004 in respect of the declaration made in favor of the plaintiff. Full stop. The two appeals were clubbed, heard together, and were disposed of by a common judgment by the appellate court. Dismissing the suit of the dismissing the appeal of the plaintiffs while allowing the appeal filed by the defendants, and thereby the declaration made by the trial court in favor of the plaintiff was also set aside. Full stop. Learned counsel for the petitioner submits that the original plaintiff have filed a regular second appeal in RSA
2135 for 2011 and 2136 for 2011.
which are pending consideration before this court.
Yes.
Full stop. Learned counsel further submits that the petitioners herein who are not aware of all these proceedings have filed an application to implead themselves in the regular second appeal. Full stop. In the meanwhile, the petitioners approached the Assistant Commissioner seeking entry of their names on the strength of the sale deed got executed by their grandfather Sri Doddapapaya. Full stop. The Assistant Commissioner noticed the judgment and decree passed by the civil court in OS number 23 of 2000 and the subsequent orders passed by the first appellate court, and dismissed the appeal filed by the petitioners, stating
Not petitioners. They are not the petitioners. They are the appellants.
ಅದೇ
ಅಲ್ಲ ನಾವು
ನೀವೇ ಹಾಕಿರೋದು
ಹಾಕಿದ್ದಲ್ಲ ಅದು appeal.
ಇನ್ಯಾರು ಹಾಕಿದ್ರು
All the parties in the said suit. ದೇಶಿ ಮುಂದೆ
ಇದು I'm talking about this. ಏನ್ ಹೇಳಿದೆ?
Assistant Commissioner noticed that the judgment and decree passed by the civil court in OS number 23 of 2000 and subsequent orders passed by the first appellate court and dismissed the appeal filed by the petitioner.
Petitioners herein, while stating that the mutation entries were in accordance with law, which have been affirmed by the judgment and decree passed by the civil court. Full stop. The revision petition filed by the petitioners was also dismissed by the deputy commissioner. Full stop. Next para. Learned counsel for the petitioners submits that the petitioners herein who are never aware of the suit and the fact that the name of their grandfather was never entered in the land revenue records had a right to seek the mutation entry of the name of the purchaser in terms of section 128 of the Karnataka Land Revenue Act of 1964. Full stop. Moreover, it is submitted that the petitioners have now filed an impleading application before this court in the regular second appeal, and it is possible that after hearing the petitioners, this court will pass appropriate orders or judgment in favor of the petitioners herein. Full stop. Next para. Having heard the learned counsel for the petitioners, the learned counsel for the contesting respondents, and on perusing the petition papers, this court is of the considered opinion that no infirmity can be found in the impugned orders passed by the Assistant Commissioner and the Deputy Commissioner. Full stop. Both the authorities have rightly held that the mutation entries commencing from the year 1994-95 have stood in the name of the contesting respondents herein. So, their right in respect of the lands in question have been upheld by the competent civil court, and therefore the authorities will not be able to appreciate the contention of the petitioners that their grandfather had purchased the property in question way back in the year 1962, and therefore their names have to be entered in the land records. Full stop. Needless to observe that if the petitioners succeed in getting a declaration in their names, they will be entitled to have their names entered in the land records. Full stop. Next para. Consequently, the writ petition stands dismissed.
This time is case, a week's time maybe even to comply with the office objections. Non-compliant, week's time maybe.
Finally, a week's time is granted at the request of learned counsel for petitioner for compliance of the office objections.
53, PM. 53.
Petitioner. Hello, there's only one remaining objection with regard to furnishing a better copy of the necessary page 37 and 30. Office objection may be overruled and the matter may be taken up next week.
Office objections are overruled. Is this matter for preliminary hearing? On 27th of February.
Matter number 55. Further hearing advocacy matter. Yes.
Last date of hearing two questions would goes to me. Honorable Court. Whether the revenue entries can prevail over whatever oral evidence which could have been recorded by the tribunal. What is the
There is any judgment?
Yes. You place the record. We placed on record the judgment.
Yes.
Then next question was about the remand. In the facts and circumstances of the case, whether this honorable court is it appropriate for this honorable court to exercise the power of remand. On both the questions, I have the latest case law on the point.
Yes.
Before I move to the facts of the case, I'll take my lot to the relevant portion of the judgment of the Supreme Court on point number 1 with regard to the nature of revenue.
Yes, yes.
And may I pass on a copy because we couldn't lay our hands to the reported copy of the judgment. We have the printed copy. I will tell you a lot to the similar and identical question arose before the Supreme Court on the issue. In short, the question was whether a Geni Patra can make a difference insofar as establishing the tenancy when there is a stellar material with regard to the RTC entries. The RTC entries no doubt, carry a presumptive value. It could be reported by reading oral evidence as per the scheme of the land. But what is the need then the question in this present case, the RTC, it is not the case that it's an admitted position that they did not show a single scrap of document to establish that the so-called tenancy. Whatever some statements were recorded, and those statements, what came in those statements were taken out by virtue of the cross-examination conducted. No doubt, my lord may not go into that aspect, but to establish that the revenue entries has remained, and it is not an easy situation to record the revenue entries, which could not is one stray entry. All through the case, revenue entries stood in the name of the landlords in the present.
The petitioners herein are claimants, isn't it?
It is actually
They are landlords.
To after the dealing with the legal position as enumerated in the case law which I have which is passed on, then read the written arguments which will summarize, because it's very laborious to go through the entire records. The written arguments filed by the landowner deals with every aspect of the proceedings. It's a 4 pages. Can you bear with me? I will read that. First, I will read the case law, the apex court judgment on the rebuttable nature of the revenue entries. May I take my lord to straight away page number 12 at the bottom, it's para 18. I will read from para 18. There are only 3 paragraphs. A very limited number of paragraphs. Para 18. The present is a case where no relationship of landlord and tenant is mentioned in the revenue record, though required in terms of section 32(2)(a) of the 1950 Act. The apex court was dealing with that situated local enactment, which is in material provision in the Karnataka Land Revenue Act. In the absence of any entry in the revenue record, which is also expected to contain the entry of rent and possession, the tenancy cannot be treated to be in existence only on the basis of oral evidence of the witnesses examined by the defendant. The burden of proving the relationship was on the defendant. Such a burden cannot be said to be reported only by oral evidence. The witnesses may lie, but the documents do not, is a golden rule. The presumption of truth attached to the revenue record can be reported only on the basis of evidence of impeccable integrity and reliability. The oral evidence can always be adduced contrary to the revenue record, but such oral testimony will not be sufficient to hold that statutory presumption stands reported. Then the next para would be para 20. This court in a judgment reported was examined.
So now we will come back to the impugned order, and what is the basis?
My lord, the impugned order is not an order. What I would say that it may not be happily worded in terms of dealing with the evidence, because there also my humble submission is that the land tribunal may be consist of an administrative member, my lord may not look at that impugned order in such a accuracy as a judicially trained mind will output. So the judicially trained mind will have a better language and better appreciation. But the test for applying the land tribunal order, if my lord were to deal with the lower court scenario, the lower court order, my lord will not apply that test.
We will give that concession.
It's not coming from a judicially trained mind.
Yes.
But for the limited purpose of testing the veracity, I am not for a moment suggesting to the Honorable Court that the Honorable Court has to go through the page number 143, 168 of records. No, I am not for a moment, because I am aware of the legal position that so far as. But after a long battle of this, whether the substitution can happen in the hands of the I'm instructed that there is no tribunal constituted, and a substitution of the opinion can happen even if a judicial mind were to look into it. Assume for a moment that the judicial mind will look.
Let us first look at it, then we'll see.
Yes, my lord, I will,
Yes.
before I come to that,
Ah.
may I complete this part,
Yes.
the judgment part, I will conclude that and then take my lord through the relevant written argument.
Yes.
Para 24 may kindly be noted out. Para 24 and 25, I will not trouble my lord with the too many details of that except the relevant.
Para 24 of this judgment.
Yes, ma'am. Put number at the foot 15. Para 24 and 25, and then I conclude so far as my submission on this judgment is concerned. I have nothing to say further. Therefore, para 24. Therefore, we find that the presumption of truth attached to the record of rights can be rebutted only if there is a fraud in the entry or the entry was surreptitiously made or that prescribed procedure was not followed. The Supreme Court says that if the rebuttable presumption doesn't mean that anything and everything, the oral evidence can override the written. In view thereof, we find that the High Court has erred in law in allowing the defendant's appeal relying upon oral evidence to rebut the statutory presumption of truth attached to the revenue record. Now, this is the case law on the point I have and so far as the other judgment, that will cite later. Before I cite the remand, we are in the hands of this honorable court. Power to remand is extensive, but I am only required to convince this honorable court that having regard to the long journey this litigation had, if that power can be not exercised, and if our bona fides are shown.
Let us consider.
Yes.
Yes.
May I take my lord to page number 150, written submissions filed. And this is a 4-page, the 5-page document. I will read it because it will give the entire, the scope of the proceedings are highlighted. 115 at Annexure H. May I read, my lord? ಈ ಮೇಲ್ಕಂಡ ಪ್ರಕರಣದಲ್ಲಿ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಟ್ ಅರ್ಜಿ ಸಂಖ್ಯೆ ದಿನಾಂಕ 4/10/99 ಆದೇಶದ ಮೇಲೆ ಈ ಭೂ ನ್ಯಾಯಮಂಡಳಿ ಹಿಂದಿರುಗಿಸಿ ಪುನಃ ವಿಚಾರಣೆ ಮಾಡಲು ಆದೇಶ ನೀಡಿರುತ್ತದೆ. ಅದರಂತೆ ಈ ಭೂ ನ್ಯಾಯಮಂಡಳಿಯು ಪ್ರಕರಣದ ಉಭಯರಿಗೂ ಸಾಕ್ಷಿ ಮತ್ತು ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಲು ಅವಕಾಶ ಕಲ್ಪಿಸಿ ಪ್ರಕರಣದ ವಿಚಾರಣೆ ನಡೆಸಿರುತ್ತದೆ. ಅದರಂತೆ 2 ಮತ್ತು 3ನೇ ಗೇಣಿ ಅರ್ಜಿದಾರರು ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಸದರಿಯವರ ಕ್ಲೇಮು ಬಗ್ಗೆ ವಿಚಾರಣೆ ದಿನಾಂಕ 6/7/2002 ಸಲ್ಲಿಸುತ್ತಾರೆ ಮತ್ತು ಸದರಿಯವರ ಪರ 26/2002 ಸಾಕ್ಷ್ಯಗಳನ್ನು ಕೊಟ್ಟಿರುತ್ತಾರೆ. ಅಂತೆಯೇ ಎದುರುದಾರರು ಸಹ RW1 ಆಗಿ ಚೆನ್ನಕೇಶವ ಅವರನ್ನು ಸಾಕ್ಷಿ ಒಳಪಡಿಸಿ ನಿಶಾನೆ 6/1 6/12 ದಾಖಲೆಗಳನ್ನು ಹಾಕಿ ನಿಶಾನೆಗಳಾಗಿ ದಿನಾಂಕ 15/2/2000 ಗುರುತಿಸಲಾಗಿದೆ ಮತ್ತು ಇವರ ಪರವಾಗಿ ಸಾಕ್ಷ್ಯ ರಾಮೇಗೌಡ ಎಂಬುವರನ್ನು ದಿನಾಂಕ 15/2/2000 ವಿಚಾರಣೆ ಮಾಡಲಾಗಿದೆ. ಈ ಮೇಲ್ಕಂಡ ಪ್ರಕರಣವು ಚನ್ನಪಟ್ಟಣ ತಾಲೂಕು ವಿರೂಪಾಕ್ಷಪುರ ಹೋಬಳಿ ಬೈರಶೆಟ್ಟಿ ಗ್ರಾಮದ ಸರ್ವ 22/1 22/2 ಜಮೀನನ್ನು ಗೇಣಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿ ಅದರ ಇತ್ಯರ್ಥಕ್ಕಾಗಿ ಈ ಪ್ರಕರಣವು ನಡೆಯುತ್ತಿರುತ್ತದೆ. ಎಲ್ಲಾ ಗೇಣಿ ಅರ್ಜಿಗಳು ಸರ್ವೆ ನಂಬರ್ 22 ಬೈರಶೆಟ್ಟಿ ಗ್ರಾಮದ ಜಮೀನಿಗೆ ಸಲ್ಲಿಸಲಾಗಿದೆ. ಆದರೆ ಸದರಿ ಸರ್ವೆ ನಂಬರ್ 1932ರಲ್ಲಿಯೇ ಇಸ್ಸಾಪೋಡಿಯಾಗಿರುತ್ತದೆ. 1932 the ಇಸ್ಸಾಪೋಡಿ has happened. ಆದರೆ ಗೇಣಿ ಅರ್ಜಿದಾರರು ನಿರ್ದಿಷ್ಟವಾಗಿ ಯಾವ ಜಮೀನಿಗೆ ಗೇಣಿ ಅರ್ಜಿ ಸಲ್ಲಿಸುತ್ತಾರೆ ಎಂಬುದು ಗೊಂದಲಮಯವಾಗಿದೆ ಮತ್ತು ಅವರು ಸಲ್ಲಿಸಿರುವ ಗೇಣಿ ಅರ್ಜಿಯಂತೆ ದಿನಾಂಕ 1/3/74 ಅವಧಿಯ ಪಹಣಿಯನ್ನು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ಮತ್ತೆ ಸರ್ವೆ ನಂಬರ್ 22/1 22/2 ಅಥವಾ ಸರ್ವೆ ನಂಬರ್ 22 ಬೈರಶೆಟ್ಟಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ನ ಪಹಣಿಯನ್ನು ಜಮೀನಿನ ಮಾಲೀಕರು ನಿರ್ದಿಷ್ಟ ಅವಧಿಗೆ ಹಾಜರುಪಡಿಸಿದ್ದು ಸದರಿ ಅವಧಿಯಲ್ಲಿ ಮಾಲೀಕರಾಗಿ ಮತ್ತು ಸಾಗುವಳಿದಾರರಾಗಿ ಮಾಲೀಕರ ಹೆಸರೇ ನಮೂದಾಗಿರುವುದನ್ನು ಘನ ಭೂ ನ್ಯಾಯಮಂಡಳಿ ಸ್ಪಷ್ಟಪಡಿಸಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ನಿಗದಿತ ಅವಧಿಯಲ್ಲಿ ಗೇಣಿದಾರರು ವಿವಾದಿತ ಜಮೀನಿನಲ್ಲಿ ವ್ಯವಸಾಯ ಮಾಡಿದ ಬಗ್ಗೆ ಯಾವುದೇ ಸಾಕ್ಷ್ಯ ಆಧಾರ ಪುರಾವೆ ಇಲ್ಲದೆ ಇರುವುದರಿಂದ ಸದರಿ ಗೇಣಿ ಅರ್ಜಿಗಳನ್ನು ಅಂಗೀಕರಿಸಲು ಪೂರಕ ಅಂಶಗಳಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ವಜಾ ಮಾಡಬೇಕೆಂದು ಪ್ರಾರ್ಥಿಸುತ್ತಾರೆ. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಎದುರುದಾರರಾದ ಶ್ರೀಮತಿ ಪುಟ್ಟಮ್ಮ ಶ್ರೀರಂಗಯ್ಯ ಹಾಲಿ ಎದುರುದಾರರಾಗಿದ್ದು ಪ್ರಕರಣದ ವಿವಾದ ಸ್ವತ್ತಿನ ಸರ್ವೆ ನಂಬರ್ 22/1 22/2 ಬೈರಶೆಟ್ಟಿ ಗ್ರಾಮ ವಿರೂಪಾಕ್ಷಪುರ ಚನ್ನಪಟ್ಟಣ ತಾಲೂಕಿನ ಸ್ವತ್ತು ಮೂಲತಃ ಶ್ರೀರಂಗಯ್ಯನವರ ಸ್ವತ್ತಾಗುತ್ತದೆ. ಹಾಲಿ ಶ್ರೀರಂಗಯ್ಯನವರು ಮುಕ್ತರಾಗಿದ್ದು ಈತನ ಒಬ್ಬಳೇ ಮಗಳಾದ ಶ್ರೀಮತಿ ಪುಟ್ಟಮ್ಮ ಮತ್ತು ಹಾಲಿ ವಿವಾದ ಸ್ವತ್ತಿನ ಮಾಲೀಕರಾಗಿ ಪ್ರಕರಣದಲ್ಲಿ ಭೂ ಮಾಲೀಕರಾಗಿ ಪ್ರತಿನಿಧಿಸುತ್ತಾರೆ. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಅರ್ಜಿದಾರರು ಭೂ ಸುಧಾರಣಾ ಕಾಯ್ದೆ 61ರ ಪ್ರಕಾರ 48 ಮೇರೆಗೆ ಚನ್ನಪಟ್ಟಣ ತಾಲೂಕು ಭೂ ನ್ಯಾಯಮಂಡಳಿಗೆ ನಮೂನೆ 7ರಂತೆ ಅರ್ಜಿ ಸಲ್ಲಿಸುತ್ತಾರೆ. ಅರ್ಜಿಯ ಜೊತೆ ವಿವಾದಿತ ಸ್ವತ್ತಿಗೆ ಸಂಬಂಧಿಸಿದ ಪಹಣಿಯನ್ನು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ಆದರೆ 69/2000 ಈ ಪ್ರಕರಣದ ಎದುರುದಾರರು ಭೂ ಮಾಲೀಕರು ವಿವಾದಿತ ಸ್ವತ್ತಿನ ಪಹಣಿ ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಿದ್ದು ಅವುಗಳನ್ನು ನಿಶಾನೆ 1ರಿಂದ R12 ಎಂದು ನಿಶಾನೆಗಳಾಗಿ ಗುರುತಿಸಲಾಗಿದೆ ಪ್ರತಿವಾದಿಯಾಗಿ ಹಾಗೂ ಸಾಕ್ಷಿ ಹೇಳಿಕೆ ನೀಡಿದ ಚೆನ್ನಕೇಶವ ಅವರಿಂದ ದಿನಾಂಕ 15/2/2001 ಈ ಘನ ನ್ಯಾಯಾಲಯದಿಂದ ಗುರುತಿಸಿಕೊಳ್ಳಲಾಗಿದೆ. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಅರ್ಜಿದಾರರು ಭೂ ಸುಧಾರಣಾ ಕಾನೂನು 61 ಪ್ರಕಾರ ಅರ್ಜಿದಾರರು ಗೇಣಿ ಅರ್ಜಿ ಜೊತೆ ವಿವಾದಿತ ಸುತ್ತಿನ ಪಾಣಿ ನಕಲನ್ನು ಸಲ್ಲಿಸಬೇಕಾಗುತ್ತದೆ ಮತ್ತು ಸದರಿ ಪಾಣಿಯಲ್ಲಿ ಗೇಣಿ ಅರ್ಜಿದಾರರು ಕಲಂ 12/12 ಆತನ ಹೆಸರನ್ನು ವ್ಯವಸಾಯಗಾರ ಕಾಲವನ್ನು ನಮೂದು ಮಾಡಬೇಕಾಗುತ್ತದೆ. ಈ ರೀತಿ ನಮೂದು ಆಗಿರುವ ಪಾಣಿಯನ್ನು ನೀಡುವಲ್ಲಿ ಅರ್ಜಿದಾರರು ವಿಫಲರಾಗಿರುತ್ತಾರೆ. ಇದಕ್ಕೆ ಪ್ರತಿಯಾಗಿ ಎದುರುದಾರರು ಭೂ ಮಾಲೀಕರು 60 ರಿಂದ 2005 ವಿವಾದಿತ ಸುತ್ತಿನ ಪಾಣಿಯನ್ನು ಹಾಜರು ಮಾಡಿ ಸದರಿ ಪಾಣಿಯ ಕಾಲಂ 9 ಮತ್ತು 12 ಭೂ ಮಾಲೀಕರಾಗಿ ಅವರ ಹೆಸರು ನಮೂದು ಆಗಿದ್ದು ಅದರಂತೆ ವ್ಯವಸಾಯ ಕಾಲಂನಲ್ಲಿಯೂ ಸಹ ಸದರಿ ಭೂ ಮಾಲೀಕರ ಹೆಸರು ನಮೂದು ಆಗಿರುವುದು ದಾಖಲೆಗಳು ತಿಳಿದು ಬರುತ್ತೆ. ಆದ್ದರಿಂದ ಭೂ ಸುಧಾರಣಾ ಕಾನೂನು ಅಡಿ ಅಗತ್ಯವಾಗಿ ಮತ್ತು ಅವಶ್ಯಕವಾಗಿ ಸಲ್ಲಿಸಬೇಕಾದ ಪ್ರಾಥಮಿಕ ಅವಶ್ಯಕತೆಗಳನ್ನು ಅರ್ಜಿದಾರರು ಪೂರೈಸದಿರುವುದರಿಂದ ಅರ್ಜಿದಾರ ಮೇಲ್ಕಂಡ ಗೇಣಿ ಅರ್ಜಿಗಳನ್ನು ಭೂ ನ್ಯಾಯಮಂಡಳಿ ವಜಾಗೊಳಿಸಲು ಯೋಗ್ಯವಾಗಿರುತ್ತದೆ. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಎದುರುದಾರರು ಭೂ ಮಾಲೀಕರ ಸಿರಿದ ಕುಟುಂಬ ಇವರ ಮಗ ಚೆನ್ನಕೇಶವ ಈ ಭೂ ನ್ಯಾಯಮಂಡಳಿ ಮುಂದೆ ತನ್ನ ವಿಚಾರಣಾ ಪ್ರಮಾಣ ಪತ್ರ ಸದರಿ ವಿಚಾರಣಾ ಪ್ರಮಾಣ ಪತ್ರ ಜೊತೆ 69 ರಿಂದ 2005 ವಿವಾದಿತ ಸುತ್ತಿನ ಆರ್ಟಿಸಿಗಳನ್ನು ಹಾಜರು ಮಾಡಿ ಎಂದು ಗುರುತಿಸಲ್ಪಟ್ಟಿದೆ. ಅವುಗಳ ಪೈಕಿ ಭೂ ನ್ಯಾಯಮಂಡಳಿ ಪ್ರಮುಖವಾಗಿ ಗಮನಿಸಬೇಕಾದ ಅಂಶವೆಂದರೆ 1/3/73-74 ಸಾಲಿನಲ್ಲಿ ವ್ಯವಸಾಯಗಾರ ಕಾಲದಲ್ಲಿ ಭೂ ಮಾಲೀಕರ ನಮೂದು ಆಗುವಂತೆ ಕಂಡುಬರುತ್ತದೆ. ಸದರಿ ವಿವಾದ ಸರ್ವೆ ನಂಬರ್ ಜಮೀನಲ್ಲಿ ಭೂ ಮಾಲೀಕರ ಕುಟುಂಬದವರು ಬಿಟ್ಟರೆ ಬೇರೆ ಯಾರು ವ್ಯವಸಾಯಗಾರ ಕೃಷಿ ಬೇಸಾಯ ಮಾಡ್ತಿರುವುದು ಯಾವುದೇ ರೀತಿಯ ಸಾಕ್ಷ್ಯ ಪುರಾವೆ ಇರುವುದಿಲ್ಲ ಮತ್ತು ದಾಖಲೆಗಳಿಂದಲೂ ಸಾಧ್ಯತೆ ಬರುವುದಿಲ್ಲ. ಇದಕ್ಕೆ ಪೂರಕವಂತೆ ಘನ ನ್ಯಾಯಮಂಡಳಿಯ ಮುಂದೆ ಎದುರುದಾರರು ಭೂ ಮಾಲೀಕರ ಪರವಾಗಿ RWC ಮುನಿಸಿದ್ದೇಗೌಡ ಶಿವಲಿಂಗಯ್ಯ ಎಂಬುವರು 22/6/2006 ರಾಮೇಗೌಡ ಎಂಬುದು 15/2001 ನ್ಯಾಯಾಲಯದಿಂದ ತಮ್ಮಲ್ಲಿ ವಿಚಾರಣಾ ಪ್ರಮಾಣವನ್ನು ಸಹ ಸಲ್ಲಿಸಿ ವಿವಾದಿತ ಸರ್ವೆ ನಮಗೆ ಭೂ ಮಾಲೀಕರೇ ಖುದ್ದು ಬೇಸಾಯ ಮಾಡುತ್ತಿದೆ ಓರಲ್ ಎವಿಡೆನ್ಸ್ ಇನ್ ಅಡಿಷನ್ ಟು ರಿಟನ್ ಎವಿಡೆನ್ಸ್. ಯಾವತ್ತೂ ಸದರಿ ಸುತ್ತಿನ ಅರ್ಜಿದಾರರಾಗಲಿ ಅಥವಾ ಪೂರ್ವಿಕರಾಗಲಿ ಖುದ್ದು ಬೇಸಾಯ ಮಾಡಿರುವುದಿಲ್ಲ ಎಂದು ಹೇಳಿಕೆ ನೀಡುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಪ್ರಕರಣದ ಅರ್ಜಿದಾರರು ವಿವಾದಿತ ಸ್ವತ್ತುಗಳನ್ನು ಖುದ್ದು ಬೇಸಾಯ ನಿಗದಿತ ಅವಧಿಯಲ್ಲಿ ಮಾಡುವುದಕ್ಕೆ ಪೂರಕ ಸಾಕ್ಷ್ಯಗಳನ್ನು ನೀಡುವಲ್ಲಿ ವಿಫಲರಾಗುತ್ತಾರೆ ಮತ್ತು ಎದುರುದಾರರು ಭೂ ಮಾಲೀಕರು ವಿವಾದಿತ ಜಮೀನು ಭೂ ಸುಧಾರಣಾ ಕಾನೂನು ಪ್ರಕರಣ ಗೇಣಿ ಅರ್ಜಿಗೆ ಒಳಪಡುವುದಿಲ್ಲ ಎಂಬುದು ಸಾಕ್ಷ್ಯ ಮತ್ತು ದಾಖಲೆಗಳ ಸಮೇತ ಘನ ನ್ಯಾಯಾಲಯದಿಂದ ಹಾಜರುಪಡಿಸುತ್ತಾ ಮತ್ತು ಭೂ ಸುಧಾರಣೆ ಕಾಯ್ದೆ ನಿಗದಿತ ಅವಧಿಯಾದ 74ರ ಪಾಣಿಯಲ್ಲಿ ಗೇಣಿ ಅರ್ಜಿದಾರರು ವ್ಯವಸಾಯಗಾರ ಕಾಲದಲ್ಲಿ 3 ದಿನಗಳನ್ನು ರುಜುವಾತುಪಡಿಸುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಈ ಪ್ರಕರಣದ ಗೇಣಿ ಅರ್ಜಿಗಳು ಸುಳ್ಳು ಅರ್ಜಿಗಳನ್ನು ಘನ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಮನವರಿಕೆ ಮಾಡಿರುವುದರಿಂದ ಸದರಿ ಅರ್ಜಿಗಳನ್ನು ವಜಾಗೊಳಿಸಲು ಸಮ್ ರಿಪಿಟೇಷನ್ ದ ಇಂಪಾರ್ಟೆಂಟ್ ಪಾರ್ಟ್ ವಿಲ್ ಕಮ್ ನೌ. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಎದುರುದಾರರು ಭೂ ಮಾಲೀಕರು ಅರ್ಜಿದಾರರ ಪರ 1ನೇ ಅರ್ಜಿದಾರ ಹೇಮಣ್ಣ ಮುಕ್ತನಾಗಿದ್ದು ಈತನ ವಾರಸುದಾರರಿಂದ ಪ್ರಕರಣದ ಅಂತಿಮ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿದ್ದು ಸದರಿ ನೋಟಿಸ್ ಅವರು ನೋಟಿಸ್ ತೆಗೆದುಕೊಳ್ಳಲು ನಿರಾಕರಿಸಿ ಮತ್ತು ಪ್ರಕರಣಕ್ಕೆ ಹಾಜರಾಗಿರುವುದಿಲ್ಲ. ಹಾಗೂ ಭೂ ಮಾಲೀಕರು ಜಮೀನು ಬಿಡಲು ತಯಾರಿರುವುದಾಗಿ ಗ್ರಾಮ ಲೆಕ್ಕಾಧಿಕಾರಿ ಮತ್ತು ಗ್ರಾಮಸ್ಥರನ್ನು ಹೇಳಿ ಹಾಜರುಪಡಿಸಿರುತ್ತಾರೆ. ಆದರೂ ಅದು ಈ ಘನ ನ್ಯಾಯಾಲಯದ NCR ಸಂಖ್ಯೆ ಇರುತ್ತದೆ. ಆದ್ದರಿಂದ ಗ್ರಾಮದಲ್ಲಿ ಒಬ್ಬರಿಗೆ ವೈಷಮ್ಯದಿಂದ ಸುಳ್ಳು ಗೇಣಿ ಅರ್ಜಿ ಸಲ್ಲಿಸುವುದು ಮತ್ತು ಈ ಸುಳ್ಳು ಪ್ರಕರಣ ನಡೆಸುತ್ತಿರುವ ಮೇಲ್ನೋಟಕ್ಕೆ ಈ ಘನ ನ್ಯಾಯಾಲಯಕ್ಕೆ ತಿಳಿಯುವಂತೆ ಎದುರುದಾರರು ಮನವರಿಕೆ ಮಾಡಿಕೊಟ್ಟಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಈ ಸುಳ್ಳು ಗೇಣಿ ಅರ್ಜಿಯನ್ನು ವಜಾ ಮಾಡಲು ಸಾಧಿಸುತ್ತಾರೆ. ಈ ಪ್ರಕರಣ ಎದುರುದಾರರು ಭೂ ಮಾಲೀಕರು ಈ ಭೂ ನ್ಯಾಯಮಂಡಳಿ ಮುಂದೆ ದಿನಾಂಕ 6/7/2002 ಈ ಪ್ರಕರಣದ 2ನೇ ಅರ್ಜಿದಾರ ಹೇಳಿಕೆ ನೀಡಿದ್ದು ಆತನನ್ನು ಎದುರು ಅರ್ಜಿದಾರರು ಪಾಟಿ ಸವಾಲು ಮಾಡಿದೆ. ಸದರಿ ಪಾಟಿ ಸವಾಲಿನಲ್ಲಿ ಅರ್ಜಿದಾರರಿಂದ ಭೂ ಮಾಲೀಕರೇ ದಾವಾ ಸ್ವತ್ತಿನಲ್ಲಿ ಬೇಸಾಯ ಮಾಡುತ್ತಿರುವ ಬಗ್ಗೆ ಅರ್ಜಿದಾರರು ಹೇಳಿರ್ತಾರೆ. ಅಡ್ಮಿಷನ್ ಇಸ್ ಕಮಿಂಗ್ ಅರ್ಜಿದಾರ ಕೇಳಿರುತ್ತಾರೆ. ಮತ್ತೆ ಅರ್ಜಿದಾರರು ವಿವಾದಿತ ಸ್ವತ್ತಿನ ಬಗ್ಗೆ ಗುತ್ತಿಗೆ ಪಡೆದ ಬಗ್ಗೆ ದಾಖಲೆ ಕೇಳಿದ್ದು ಅದರಲ್ಲಿ ಅರ್ಜಿದಾರರ ಯಾವುದೇ ಲಿಖಿತ ದಾಖಲೆ ಇಲ್ಲ ಎಂದು ಒಪ್ಪಿಕೊಂಡಿರುತ್ತಾನೆ. ಗುತ್ತಿಗೆ ಕೊಟ್ಟ ಬಗ್ಗೆಯೂ ಸಹ ದಾಖಲೆ ಇಲ್ಲ ಎಂದು ಒಪ್ಪಿಕೊಂಡಿರುತ್ತಾರೆ ಮತ್ತು ಗೇಣಿ ಸಲ್ಲಿಸಿರುವ ಜಮೀನ ಪಹಣಿ ಪತ್ರ ನ್ಯಾಯಾಲಯದಿಂದ ಹಾಜರುಪಡಿಸಿಲ್ಲ ಎಂದು ಒಪ್ಪಿಕೊಂಡಿರುತ್ತಾರೆ. ಅದರಂತೆ ಗೇಣಿ ಅರ್ಜಿಯ ಸರ್ವೆ ನಂಬರ್ 22/2 ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಆದರೆ ಗೇಣಿ ಅರ್ಜಿಗಳನ್ನು ಸರ್ವೆ ನಂಬರ್ 22 ಬಯಲಶೆಟ್ಟಿ ಗ್ರಾಮ ಎಂದು ಮಾತ್ರ ನಮೂದಾಗಿರುತ್ತದೆ. ಅದು LCR ಅಂತ ಇರುತ್ತದೆ. 2ನೇ ಅರ್ಜಿದಾರನ ಗೇಣಿ LCR ಇದಕ್ಕೆ ಅಂದರೆ ನಮೂನೆ 7ಕ್ಕೆ ಲಗತ್ತಾಗಿ ವಿವಾದ ಸ್ವತ್ತಿನ ಗೇಣಿ ಮಾಡುತ್ತಿರುವುದು ರುಜುವಾತುಪಡಿಸಲು RTC ಲಗತ್ತಿಸಿರುವುದಿಲ್ಲ. ಅದರಂತೆ 3ನೇ ಅರ್ಜಿದಾರ ಶ್ರೀ ಚೆನ್ನೇಗೌಡರು ಇವರ ಪರವಾಗಿ ಅವರ ಮಗ ಶ್ರೀಯುತ ಮಲ್ಲೇಶ್ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಹೇಳಿಕೆ ನೀಡಿದ್ದು ಸದರಿ ಹೇಳಿಕೆಯಲ್ಲಿ ಬಯಲಶೆಟ್ಟಿ ಸರ್ವೆ ನಂಬರ್ 22 ಬಯಲಶೆಟ್ಟಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 22/1 ಮತ್ತು 2ರಲ್ಲಿ 37 ಗುಂಟೆ 11 ಗುಂಟೆ ಬೇಸಾಯ ಮಾಡಿರುತ್ತಾರೆ. ಆದ್ರೆ 3ನೇ ಅರ್ಜಿದಾರರು ಈ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸರ್ವೆ ನಂಬರ್ 22ರಲ್ಲಿ ಮಾತ್ರ ಬಯಲಶೆಟ್ಟಿ ಗ್ರಾಮದ ಜಮೀನಿಗೆ ಗೇಣಿ ಅರ್ಜಿ ಸಲ್ಲಿಸುತ್ತಾರೆ. ಆದ್ರೆ ಇದಕ್ಕೆ ಲಗತ್ತಾಗಿ 1/3/74 ಅವಧಿಯ ಕೇಸ್ ಇವರು ಸಹ ಗುತ್ತಿಗೆ ಪಡೆದ ಬಗ್ಗೆ ಆಗಲಿ ಗುತ್ತಿಗೆ ಕೊಟ್ಟ ಬಗ್ಗೆ ಆಗಲಿ ಯಾವುದೇ ದಾಖಲೆ ಇರಲಿಲ್ಲ ಎಂದು ಒಪ್ಪಿಕೊಂಡಿರುತ್ತಾರೆ. ಮತ್ತು ಎದುರುದಾರರು ವ್ಯವಸಾಯ ಮತ್ತು ವ್ಯವಸಾಯ ಕೆಲಸ ಮಾಡುವ ಬಗ್ಗೆಯೂ ಸಹ ಒಪ್ಪಿಕೊಂಡಿರುತ್ತಾರೆ ಮತ್ತು ಮಾಡುವ ಬಗ್ಗೆಯೂ ಮತ್ತು 3ನೇ ಅರ್ಜಿದಾರರು ಇಲ್ಲಿನ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಹೇಳಿಕೆ ನೀಡುತ್ತಿರುವ ಮಲ್ಲೇಶ ಆದ ನಾನಾಗಲಿ ಗೇಣಿ ಸ್ವತ್ತಿನ ಪಹಣಿಗಳನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ನೀಡಿರುವುದಿಲ್ಲ ಎಂದು ಒಪ್ಪಿಕೊಂಡಿರುತ್ತಾರೆ. ಮತ್ತು ವಿವಾದಿತ ಸ್ವತ್ತುಗಳಲ್ಲಿ ಈ ಪ್ರಕರಣದ 3 ಜನ ಅರ್ಜಿದಾರರ ಹೆಸರುಗಳು ವ್ಯವಸಾಯಗಾರ ಕಾಲಂನಲ್ಲಿ ನಮೂದು ಆಗಿರುವುದಿಲ್ಲ. ಈ ಪ್ರಕರಣದ ಅರ್ಜಿದಾರ ಪರವಾಗಿ ಘನ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಎರಡು ಜವರಾಯಗೌಡ ಬಿನ್ ಲಿಂಗೇಗೌಡ, ಶಂಕರ ಬಿನ್ ಶಿವಲಿಂಗೇಗೌಡ ಎಂಬುದನ್ನು ಸಾಕ್ಷಿ ವಿಚಾರಣೆ ಮಾಡಿದೆ. ಅವರನ್ನು ಪಾಟಿ ಸವಾಲು ಮಾಡಲಾಗಿದೆ. ಸದರಿ ಪಾಟಿ ಸವಾಲಿನ ಗುತ್ತಿಗೆಯನ್ನು ಯಾರು ಯಾರಿಗೆ ಯಾವಾಗ ಗುತ್ತಿಗೆ ಕೊಟ್ಟಿರುವ ಬಗ್ಗೆ ನನ್ನ ಗಮನಕ್ಕೆ ಗೊತ್ತಿಲ್ಲ. ಗುತ್ತಿಗೆಯಾಗಿ 250 ಸೇರ್ ರಾಗಿ ಕೊಟ್ಟ ಬಗ್ಗೆ ದಾಖಲೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಎಂದು ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಒಪ್ಪಿಕೊಂಡಿರುತ್ತಾರೆ. ಮತ್ತು ಗೇಣಿ ಅರ್ಜಿದಾರರು ಮತ್ತು ಸಾಕ್ಷಿದಾರರು ಒಂದೇ ಜನಾಂಗದಲ್ಲಿ ಒಪ್ಪಿಕೊಂಡಿರ್ತಾರೆ. ಮತ್ತು ಇದೇ ಜವರಾಯಗೌಡ ಈ ಹಿಂದೆ ನಡೆದ ಇದೇ ಪ್ರಕರಣದಲ್ಲಿ ಭೂಮಾಲೀಕರ ಪರವಾಗಿ ಸಾಕ್ಷಿ ಹೇಳಿರುತ್ತಾರೆ. ಈಗ ಅದಕ್ಕೆ ವಿರುದ್ಧವಾಗಿ ಅರ್ಜಿದಾರರ ಪರ ಸಾಕ್ಷಿ ಹೇಳಿರುವುದು ಒತ್ತಡ ಮತ್ತು ಶಿಫಾರಸಿನ ಆಧಾರದ ಮೇಲೆ ಎಂಬುದು ಘನ ಭೂ ನ್ಯಾಯಮಂಡಳಿಯ ಮನವರಿಕೆ ಮಾಡಿಕೊಡಬೇಕಾಗುತ್ತದೆ. ಈ ವಿವಾದ ಜಮೀನು ಉತ್ತರದ ಕಡೆ ತಿಮ್ಮೇಗೌಡ ಎಂಬುವರಿಗೆ ಭೂಮಾಲೀಕರು ಸ್ವಲ್ಪ ಭಾಗದ ಭೂಮಿಯನ್ನು ಮಾರಾಟ ಮಾಡಿದ್ದು ಸರಿ ತಿಮ್ಮೇಗೌಡರಿಗೂ ಸಾಕ್ಷಿದಾರ ಜವರಾಯಗೌಡರಿಗೂ ವೈಷಮ್ಯ ಇರುವ ಬಗ್ಗೆ ಒಪ್ಪಿಕೊಂಡಿರುತ್ತಾರೆ. ಮತ್ತು ಇದೇ ರೀತಿ ಅರ್ಜಿದಾರ ಎರಡನೇ ಸಾಕ್ಷಿ ಶ್ರೀಯುತ ಶಂಕರರವರು ಸಹ ತಮ್ಮ ಪಾಟಿ ಸವಾಲಿನಲ್ಲಿ ಹಿಂದೆ ಅವರ ತಂದೆ ಶಿವಲಿಂಗೇಗೌಡರವರು ಪಂಚಾಯಿತಿ ಬೇಡಿಕೆ ತೀರ್ಮಾನಗಳು ವಾಸ್ತವಾಂಶ ಕೂಡಿದೆ ಎಂದು ಒಪ್ಪಿಕೊಂಡಿರುತ್ತಾರೆ. ಈ ಹಿಂದೆ ಇದೇ ಪ್ರಕರಣದಲ್ಲಿ ಇವರ ತಂದೆ ಭೂಮಾಲೀಕರ ಪರವಾಗಿ ಸಾಕ್ಷಿ ನೀಡಿರುತ್ತಾರೆ. ಸದರಿ ಸಾಕ್ಷಿಯಂತೆ ವಿವಾದ ಸುತ್ತಿನ ಮಾಲೀಕರು ಶ್ರೀರಂಗನೆಯವರು ಬೇಸಾಯ ಮಾಡುತ್ತಾ ಖುದ್ದು ಭೂಸ್ವಾಧೀನ ಇರುವುದರ ಬಗ್ಗೆ ಸಾಕ್ಷ್ಯ ನೀಡಿರುತ್ತಾರೆ. ಮತ್ತು ಸದರಿ ಸಾಕ್ಷಿ ಶಂಕರ್ ಅವರು ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಗೇಣಿ ಅರ್ಜಿ ಹಾಕಿದ್ದಾರೆ ಎಂದು ಗೊತ್ತಿಲ್ಲ, ಗುತ್ತಿಗೆ ಹಾಕಿರೋ ವಿಚಾರ ಗೊತ್ತಿಲ್ಲ ಎಂಬುದಾಗಿ ಒಪ್ಪಿಕೊಂಡಿರ್ತಾರೆ. ಮತ್ತು ಇವರು ಸಹ ಗೇಣಿ ಅರ್ಜಿದಾರ ಜನಾಂಗಕ್ಕೆ ಸೇರಿದ್ದಾರೆ ಎಂದು ಒಪ್ಪಿಕೊಂಡಿರ್ತಾರೆ. ಇವರ ಹೆಂಡತಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಸದಸ್ಯರಾಗಿದ್ದು ಈತನ ಅತ್ತಿಗೆ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಸದಸ್ಯರಾಗಿರ್ತಾರೆ. ರಾಜಕೀಯವಾಗಿ ಬೆಳೆಯಲು ಜನಾಂಗದ ಮತ ಪಡೆಯಲು ಘನ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸುಳ್ಳು ಸಾಕ್ಷ್ಯ ನುಡಿಸುತ್ತಿರುವ ಬಗ್ಗೆ ನ್ಯಾಯಮಂಡಳಿಯ ಗಮನವನ್ನು ಎದುರುದಾರರು ಸೆಳೆದಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಈ ಅರ್ಜಿದಾರ ಸಾಕ್ಷಿ ಮತ್ತು ಅರ್ಜಿದಾರರ ಸಾಕ್ಷ್ಯದಾರರ ವಿರುದ್ಧ ಯಾವುದೇ ಉಳಿದಿಲ್ಲ ಮತ್ತು ಸತ್ಯಾಂಶವಿಲ್ಲ ಎಂಬುದು ಎದುರುದಾರರು ಘನ ನ್ಯಾಯಾಲಯಕ್ಕೆ ರುಜುವಾತುಪಡಿಸಿರುತ್ತಾ ಅರ್ಜಿದಾರ ಗೇಣಿ ಅರ್ಜಿಗಳನ್ನು ವಿಚಾರಿಸುವುದು ಯೋಗ್ಯವಿಲ್ಲ ಎಂದು ಘನ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಮನವರಿಕೆ ಮಾಡುವುದು ಎದುರುದಾರರು ಫಲಶ್ರುತಿ ಸಫಲರಾಗಿದ್ದು ಈ ಮೇಲ್ಕಂಡ ಪ್ರಕರಣದಲ್ಲಿ ಒಂದನೇ ಅರ್ಜಿದಾರರು ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಯಾವುದೇ ರೀತಿಯ ಪ್ರಕರಣದಲ್ಲಿ ಭಾಗವಹಿಸಿರುವುದಿಲ್ಲ ಮತ್ತು ಸಾಕ್ಷ್ಯ ದಾಖಲೆ ಮತ್ತು ಇತ್ಯಾದಿ ನೀಡುವುದಿಲ್ಲ. ಬದಲಿಗೆ ಸದರಿಯವರು ಈ ಪ್ರಕರಣದ LCR ಅಂತ ಪ್ರಕರಣದಲ್ಲಿ ಭಾಗವಹಿಸದೇ ಇರುವುದು ಮತ್ತು ವಿವಾದಿತ ಸುತ್ತಿನ ಭೂಮಾಲೀಕರಿಗೆ ಬಿಟ್ಟುಕೊಡುವುದಾಗಿ ಶರಾ ಬರೆಯಿಸಿ ಹಾಜರು ಮಾಡಿಸಿ ಸದರಿ ನೋಟಿಸ್ ಪ್ರತಿ ಘನ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಇರುತ್ತದೆ. ಸದರಿಯವರ ಕ್ಲೇಮ್ ಬಗ್ಗೆ ಯಾವುದೇ ರೀತಿಯ ಪೂರಕ ದಾಖಲೆ ಮತ್ತು ಸಾಕ್ಷಿಗಳು ಘನ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಇರುವುದಿಲ್ಲ. ಇದೇ ಪ್ರಕರಣದಲ್ಲಿ ಈ ಹಿಂದೆ ಸದರಿಯವರು ಒಂದು ಗುತ್ತಿಗೆ ತರ ಸೃಷ್ಟಿ ಮಾಡಿ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರು ಮಾಡಿದ್ದು ಸದರಿ ದಾಖಲೆಯು ಸುಳ್ಳಿಂದ ಕೂಡಿದೆ ಎಂದು ಸದರಿಯವರು ಮನಗೊಂಡು ಘನ ನ್ಯಾಯಾಲಯ ಮುಂದೆ ಹಾಜರು ಆಗದೆ ಇದು ವಿವಾದ ಸ್ವತ್ತಿನ ಮೇಲೆ ಸದರಿಯವರ ಪ್ರತಿಪಾದಿಸಿ ಸಮನ್ವಯವಾಗಿದೆ. ಆದ ಕಾರಣ ಸದರಿ ಗೇಣಿ ಅರ್ಜಿಯನ್ನು ಸುಳ್ಳು ಮಾಹಿತಿಯಿಂದ ಕೂಡಿದೆ ಎಂಬುದನ್ನು ಘನ ನ್ಯಾಯಾಲಯ ಮನಗಾಣಬೇಕೆಂದು ಪ್ರಾರ್ಥಿಸುತ್ತಾರೆ. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಅರ್ಜಿದಾರ 2 ಮತ್ತು 3 ಸಲ್ಲಿಸುವ ತೀರ್ಪು ಸಂಗತಿ ಮತ್ತು ಸನ್ನಿವೇಶವು ಬೇರೆ ಬೇರೆಯಾಗಿದೆ. ಈ ಪ್ರಕರಣಕ್ಕೆ ಸಂಗತಿ ಮತ್ತು ಸನ್ನಿವೇಶವು ಬೇರೆ ಬೇರೆಯಾಗಿದೆ. ಸದರಿ ಆಯ್ಕೆಗಳು ಈ ಪ್ರಕರಣ ವಾಸ್ತವಾಂಶ ಕಡಿಮೆಯಾಗುವುದು ತಿಳಿಯಬಯಸುತ್ತದೆ. ಈ ಮೇಲ್ಕಂಡ ಪ್ರಕರಣ ಎಲ್ಲಾ ಸಂಗತಿಗಳು, ಹೇಳಿಕೆಗಳು, ದಾಖಲೆಗಳು ಇವುಗಳೆಲ್ಲವನ್ನು ಮಾನ್ಯ ಘನ ನ್ಯಾಯಾಲಯ ಪರಿಗಣಿಸಿ ಕರ್ನಾಟಕ ಭೂ ಸುಧಾರಣೆ ಕಾಯ್ದೆ 61 ಕಲಂ 48A ಮೇರೆಗೆ ನಮೂನೆ 7 ಜೊತೆ ಅವರಿಗೆ ಗೇಣಿ ಅರ್ಜಿದಾರರು ವಿವಾದ ಸರ್ವೆ ನಂಬರ್ ಜಮೀನು ಗೇಣಿದಾರರಾಗಿ ಜಮೀನು ಸಾಗುವಳಿ ಮಾಡುವುದನ್ನು ರುಜುವಾತುಪಡಿಸಲು ವಿಫಲರಾಗಿರುವುದರಿಂದ ಈ ಮೇಲ್ಕಂಡ ಪ್ರಕರಣ ಗೇಣಿ ಅರ್ಜಿಗಳನ್ನು ವಜಾ ಮಾಡಬೇಕೆಂದು ಎದುರುದಾರರು ಭೂಮಾಲೀಕರು ಭೂ ನ್ಯಾಯಮಂಡಳಿ ನ್ಯಾಯಾಲಯವನ್ನು ಪ್ರಾರ್ಥಿಸುತ್ತಾರೆ. In my respective submission, this will summarize what material was there before the tribunal. In addition to the stellar material produced by the landlords to show that they are in possession of the land, forgery took place, and the claim is made in despite of knowing the forgery, the claim is made in respect of survey number 20. Thereby, now my lord did ask me to go to the order.
Yes.
These things, they include others. I am aware of that. That's my answer is there. It's not by judicial mind. See, the kind of evidence which is there, which I have, if the other side were to dispute what is stated in the written arguments, it could be different. It could be a difference. The written argument summarizes that there was a stellar material produced in support of the landowner's claim that there was no gaining of any type. And since there was no, the presumption gets brought. The inquiry did take place. And the inquiry, during the inquiry, what comes in chief cannot be relied upon if it is demolished in the cross-examination. Take, for example, the evidences produced by the several witnesses were examined, which are in the form of to show that none node there, only gaining into. Our cross-examination I've gone through the lower court records. Whatever, cross-examination takes away the entire truth and substance of the evidence. And cross-examined, it was shown. In fact, I did not trouble my lord on going through each and every statement of the witness. If the the only thing which I may have to do at this stage is about what is stated, is it reflecting in the tribunal order? The tribunal order, kindly be noted, it is the quasi-judicial mind has expressed its opinion. The chairman of the tribunal like this mind and has said that in view of the documentary evidence which is there, the claimants are not entitled to claim any claims. The pure non-judicial mind members are stated to the contrary. I will not say much whether they are capable of speaking in the what I would say that legal language, whether between the two, the chairman who is a quasi-judicial mind, he has recorded his reasons, the dissent opinion, that's reasons. The purpose of reading that the kindly see the impugned order. I went up in 3 minutes after citing the case law on the remand. Page number 133. ಚನ್ನಪಟ್ಟಣ ತಾಲೂಕು ಭೂನ್ಯಾಯ ಮಂಡಳಿ ದಿನಾಂಕ ಆದೇಶ ತಿಳಿದಾರು ಕೂಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಲಾಗಿರುತ್ತದೆ. ದಿನಾಂಕ 31/12/76 ಚೆನ್ನೇಗೌಡ ಮತ್ತು ಚೌಟಣ್ಣಯ್ಯ ವೆಂಕಟೇಗೌಡ ಕೇಳಿ ಹಕ್ಕು ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಕಡದದಲ್ಲಿ ಲಭ್ಯವಿರುವ ಬೈರಶೆಟ್ಟಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 22ರ ಪಹಣಿಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಶ್ರೀರಂಗಯ್ಯನವರು ಭೂ ಮಾಲೀಕರಾಗಿದ್ದು ಪಹಣಿಯ ಸಾಗುವಳಿದಾರ ಕಾಲಂ 12(2)ರಲ್ಲಿ ಶ್ರೀರಂಗಯ್ಯನವರ ಹೆಸರು ನಮೂದಾಗಿರುತ್ತದೆ. ಆದರೆ ಗೇಣಿ ಹಕ್ಕು ಕೋರಿರುವ ಅರ್ಜಿದಾರರ ಹೆಸರು ನಮೂದಾಗಿರುವುದಿಲ್ಲ. ಈ ಮೇಲ್ಕಂಡ ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಕರ್ನಾಟಕ ಭೂ ಸುಧಾರಣಾ ಕಾಯ್ದೆ ಜಮೀನನ್ನು ಗೇಣಿದಾರ ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರಬೇಕು, which is a material date for our purpose to determine the tendency. ಆದರೆ ಸದರಿ ಪ್ರಕರಣದ ಅರ್ಜಿದಾರರು ಈ ಮೇಲ್ಕಂಡ ದಿನಾಂಕದಂದು ಅವರು ಗೇಣಿ ಹಕ್ಕು ಕೋರಿರುವ ಜಮೀನುಗಳನ್ನು ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವುದು ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ. ಹೀಗಾಗಿ ಕರ್ನಾಟಕ ಭೂ ಸುಧಾರಣೆ ಕಾಯ್ದೆ 61-45 ಅಡಿಯಲ್ಲಿ ಗೇಣಿ ಹಕ್ಕು ಕೋರುವ ಅರ್ಜಿಗಳನ್ನು ವಜಾಗೊಳಿಸುವುದು ಸೂಕ್ತ ಎಂದು ಅಧ್ಯಕ್ಷರು ಅಭಿಪ್ರಾಯ ಪಟ್ಟಿರುತ್ತಾರೆ. ಆದರೆ ಭೂ ನ್ಯಾಯಮಂಡಳಿಯ ಸದಸ್ಯರು ಇದಕ್ಕೆ ಸಹಮತ ವ್ಯಕ್ತಪಡಿಸಿದೆ 3-1 ಬಹುಮತದಿಂದ ಗೇಣಿ ಹಕ್ಕು ಕೋರುವ ಅರ್ಜಿಗಳನ್ನು ಆದಿಭೋಗದಾರರನ್ನು ನೋಂದಾಯಿಸಲು ನಿರ್ಣಯಿಸಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಈ ಕೆಳಕಂಡ ಆದೇಶ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸುವ ಅಂಶದಂತೆ ಚನ್ನಪಟ್ಟಣ ತಾಲೂಕು ವಿರೂಪಾಕ್ಷಪುರ ಹೋಬಳಿ ಬಯಲುಸೆಟ್ಟಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಗೇಣಿ ಹಕ್ಕನ್ನು ಕೋರಿ ನಮೂನೆ 7ರಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸುವ ಶ್ರೀ ಹನ್ಮೇಗೌಡ, ಮರಿಗೌಡ, ಚೆನ್ನೇಗೌಡ ಅವರ ಸ್ವಾಧೀನ ವೃತ್ತಿಗೆ ಅನುಗುಣವಾಗಿ ಕರ್ನಾಟಕ ಭೂ ಸುಧಾರಣಾ ಕಾಯ್ದೆ 61ರ ಕಲಂ 45 ಅಡಿಯಲ್ಲಿ ಅರ್ಜಿದಾರರ ಆದಿಭೋಗಿದಾರರನ್ನು ನೋಂದಾಯಿಸಲು ಭೂ ನ್ಯಾಯಮಂಡಳಿ ಅಧ್ಯಕ್ಷರನ್ನು ಹೊರತುಪಡಿಸಿ ಇತರ ಸದಸ್ಯರು ಬಹುಮತದಂತೆ ನಿರ್ಣಯದಂತೆ ಆದೇಶಿಸಲಾಗಿದೆ. In my respectful submission, the dealing when the chairman is a quasi-judicial, I would say that he carries a quasi-judicial mind. When he has applied the law on the subject and has held that the claimants have not satisfied the threshold criteria and they have not produced any document to show that the the other members who are their version or a stand that it may have to be granted will cut the root of the legal process. The legal process is to be determined by a maybe judicial mind or a quasi-judicial mind. It cannot be left to a layman's mind as such. Great respect to the members who are part of the decision. Now, to sum it up, my lord, the chairman has applied his mind, and this order is dated even post remand. We had a long journey. This order is dated 22/3/2018, 10 years post remand. The tribunal took almost 10 years to this. Kindly be noted for the purpose of the tribunal took 10 years to decide this matter, and after deciding this matter, chairman has come with this. Unless there is a culpable error, irrational approach, illegality, if the same, an otherwise situation, I have perused the papers. The claimants have not made out a case claimants have not made out a case for the purpose of grant of penance. That type of a wording is not here. The wording, the chairman goes through that document, says that maybe depending on overall material, he has not dealt with the oral evidence. You know, by way of substitution, if that oral evidence was to alter the result, the limited inquiry is not for a moment reading between the lines. That oral evidence was arising out of political rivalry. Father gives in evidence saying that no, these claimants never there, these tenants were never there. Son gets in and gives a contra evidence. I have seen them to that KD. Then we say, what was it used? Was there anything to show that KD? No. And the first applicant did not come forward. And looking at the overall material, what emerges is that this is the chairman's order is a just and reasonable order which has been passed, and the chances of it getting reversed upon expression of a better language, in my respective submission, is rather remote. And when it came to the remand, the Supreme Court has said it in page number 7 on the top. Remand power is a very discretionary power. It's a highly discretionary power. I am only emphasizing this paragraph to show that it may be sparingly used. That is the paragraph 10, paragraph 7. Therefore, two questions arise for consideration in this article. The first question is whether the division bench was justified in reversing the order of the learned single judge, setting aside the order of the land tribunal dated, and remanding the matter to the land tribunal. Now, I'm just, that's a question. Now, the paragraph 12, page 9, the first paragraph. It is submitted, there is no documentary evidence before the land tribunal to establish the relationship of tenant and landlord. Page number 9. Page number 9, paragraph, it's a continuation paragraph, paragraph 12. Paragraph 12 starts at page number 8. I'm skipping the submissions, I'm only coming to the main important one. It is submitted that there is no documentary evidence before the land tribunal to establish the relationship of tenant and landlord, which is a prerequisite in section 233 of the Karnataka Land Reforms Act 1961. Then, page 10, paragraph 14. Before considering the above questions, it is necessary to consider the contention and counsel for the party as to the existence or otherwise of the relationship of landlord and tenant between Mariappa. This may not be relevant to what as the sale deed is executed only because I am citing this case law for the purpose of remand. I straight away go, my lord, instead of troubling my lord with other paragraphs which are factual details. I straight away go to page number 22, paragraph 22, paragraph 25. The division bench, without assigning any cogent reasons, not assigning, that is a separate situation. The division bench, without assigning any cogent reasons, has set aside the order of the learned single judge and has remanded the matter to the land tribunal. It is settled law that the order of remand cannot be passed as a matter of course. An order of remand cannot also be passed for the mere purpose of remanding a proceeding to the lower court or the tribunal. An endeavor has to be made by the appellate court to dispose of the case because they were dealing with the division bench order. Here itself. An endeavor has to be made by the appellate court to dispose of the case on marriage, where both the sides have oral and documentary evidence. The appellate court to decide the appeal on marriage instead of remanding the case to the lower court at the tribunal. We are of the view that in the instance where the division bench has remanded the matter without any justification. To sum up my submissions in this regard, that having regard to the material which is there on the record, the remand process may not serve the purpose of meeting the ends of justice and a limited inquiry. This answer will may take up prima facie perusal of the papers. And if my lord finds that this order is not something to the judicial conscience, then in such an event, my lord will not remand the matter. If any further clarification is required on such evaluation, on such limited appraisal of the documents, I'll make my submission later. So in my respective submission, the
order passed by the tribunal is sustainable and therefore it will kindly, the order passed by the tribunal as per the chairman is sustainable and kindly uphold that order and the fruits of litigation, the remand process and its own limitations, and the fruits of the litigation is preferably enjoyed by the generation which approach the court, not by the LRs or LRs of LRs. And we're keeping all these aspects in mind. I pray this honorable court to kindly confirm the order and oblige to it.
Paragraph
Paragraph
20.
Land tribunal has not provided sufficient opportunity to petitioners hearing, which is clear from the order sheet dated 15/9/2016. But to result from order from 15/9/2016, the land tribunal is not producing or only on 22/3/2018 of the draft of 1.5 days, which include not draft. The land tribunal failed to consider the written arguments submitted by the petitioners hearing on 22/9/2016 by directive. The non-consideration of written arguments cannot be state and its knowledge as in fashion. As already stated earlier, the impute order is contrary to the order dated 4/10/2019, but section B, wherein this honorable court clearly directed the land tribunal to consider the claim of the original applicants, which is respondent 4/6 in the right of the evidence on its record earlier to the petition or appeal and subsequent to the remand order. Unfortunately, the land tribunal failed to consider to look into the evidence on the record, and hence the impute order is contrary to the order dated 4/10/2019. 23. The impute order is not a speaking order, as the members of the land tribunal have not assigned the reason for having granted offense in this is the response of the and the land tribunal has not conducted the inquiry in strict compliance of section 48 capital A of the Karnataka Land Reforms Act and also in 17 of the land reform rules. Hence the impute order cannot be sustained. The instant case, this is the third time that the landlord is constrained to approach this on the courts. And two earlier occasions, a detailed inquiry has been held, wherein the earlier land tribunal orders have clearly passed a speaking orders. Kindly go to the earlier orders passed by the land tribunal. They have discussed in detail the crux of the evidence stated by the parties. And there it has been observed that the evidence stated by the claimants has not been rebutted by them. They are not even denied the fact that they were in the occupation of the land and cultivating the land as tenants.
Let us see that.
In fact, these claimants were not performed for very marginal landowners. The tenancy application with respect of only small extent of lands, they are not landholders, they are not educated person. And the lordship is also well aware of the fact that the very object and intent of the legislature in bringing into effect the Karnataka Land Reforms Act is to provide the landless and the persons who are cultivating the land.
ಎಷ್ಟು ಕೇಳಿದ್ದಾರೆ ಅವರು? What is their claim?
The claim is in respect
2 acres 33 gunttas. 2 acres 13 gunttas. ಎರಡೇನಾ?
And these persons, they are uneducated persons, illiterate persons, they have been cultivating the land from.
ಅವ್ರ ಹತ್ರ ಇನ್ನೂ ಬೇರೆ ಜಾಗ ಇದೆಯಾ?
Very ಇದೆ. Very ಇದೆ.
ಎಷ್ಟಿದೆ?
Very 4 ಇದೆ. Very ಇದೆ.
All right. Yes.
And the landlord is.
No, you point out to the previous orders. See, instead of this court looking into the original records, if you are able to point out from the previous orders that these are the evidence that were considered. ಅಲ್ಲ ಅದು ಬೇಡ, ಫ್ರಮ್ ದಿ ಪ್ರೀವಿಯಸ್ ಆರ್ಡರ್ಸ್. ಆಯ್ತು, ಇದ್ರಲ್ಲಿ ಹಾಕಿಲ್ವಾ? ಆಯ್ತು.
Third, others despite service of office. Third petition states that the petitioners are tenant cultivators from the past 15 years. Given Kutikal is the respondent. The respondent here is denying the claim of the petitioner. He states that he was cultivating land originally since 10 years with this cultivated by his grandson Srinivasa. But states that the petitioners have worked on the land as police. The following witnesses were examined by the respondent. Timmegowda, son of Timmegowda, who was the purchaser, was purchased an extent of 2 acres from the land. That he said Rajudha in the south and that the petitioners are working in the land only as police. He also admits that the petitioners are working as police. He states further that the land is in personal cultivation of the respondent and that it is not being cultivated by the grandson. Grandson is from Shivlingegowda. Shivlingegowda, son of Gadegowda, states that he is Vajuda and that the petitioners were working as police. He states that the land is personally cultivated by the respondents and not his grandson. There is stone. The part states that it is the Rajudha of the on the north that the petitioners are only police on the land and that the land is not being cultivated by the respondents along with this grants. It is seen that the statements of the witnesses are contrary to the statements of the respondent. None of them have stated that the respondent's grandson is exclusively cultivating the land. Moreover, all have admitted that petitioners are working on the land, that there is sufficient material to show that the petitioners are tenant cultivators. Hence, it is ordered that the petitioners shall be registered as occupants of land in Circle number 22 as per their enjoyment.
Last portion.
Last portion. It is seen that the statements of the witnesses are contrary to the statements of the respondent. None of them have stated that respondent's grandson is exclusively cultivating the land. Is the case that the original owner's grandson is cultivating, the Sriranga's grandson is cultivating. Moreover, all have admitted that the petitioners are working on the land. Thus, there is sufficient material to show that the petitioners are tenant cultivators. Hence, it is ordered that the petitioners may be registered as occupants of land in Circle number 22 as per their.
All of them have said they are working as coolies.
Yes, sir.
Then how can it be construed as the tenancy?
They were in occupation.
They were working as coolies. That they were working as coolies. For you to establish, see the requirement is that you will have to establish that you are tenant under them. That is the main requirement.
But that's their say, my lord. It's not.
Therefore,
it's not the say of the claimants that they are working as coolies.
correct. Alala, whoever you brought as witnesses.
No.
Huh? But then even what have you done then?
I'm getting my evidence. That's not.
Please. What is that evidence that you have led them?
I'm read that I'm cultivating as a tenant. In fact, that evidence is also.
What evidence is there? What? Yaradu? Who is that? Claimant. Huh? What is the use of your own statement? That statement has to be supported by any other evidence. Very oral evidence. See, that is.
The spot inspection conducted on 1986 by 1986. That's not been disputed by them at all. They participated in the said spot inspection also. Later. 6 by 1986. These in a Bhumyaya Mandali, Virus Shetty now the 7 of the ನಡೆಸಿತ್ತು ಅರ್ಜಿದಾರರು ಮತ್ತು ಪ್ರತಿವಾದಿಗಳು ಮೊದಲೇ ನಿಲ್ಲಿಸಿದಂತೆ ಸ್ಥಳದಲ್ಲಿ ಹಾಜರಿದ್ದರು ಇಬ್ರು ಹಾಜರಿದ್ದರು. ಪ್ರತಿವಾದಿಗಳು ಅರ್ಜಿದಾರರು ಮತ್ತು ಪ್ರತಿವಾದಿಗಳು ಮೊದಲನೇ ದಿವಸದ ಸ್ಥಳದಲ್ಲಿ ಹಾಜರಿದ್ದರು. ಸ್ಥಳ ತನಿಖೆ ಸಮಯದಲ್ಲಿ ಅಕ್ಕಪಕ್ಕದ ಜಮೀನಿನವರು ಮತ್ತು ಊರಿನ ಪ್ರಮುಖರು ಹಾಜರಿದ್ದರು. ವ್ಯಾಜ್ಯದ ಜಮೀನನ್ನು ಅರ್ಜಿದಾರರು ತುಂಬಾ ದಿವಸಗಳಿಂದ ಸ್ವಾಧೀನ ಮಾಡಿ ಗುತ್ತಿಗೆ ನೀಡುತ್ತಿದ್ದುದನ್ನು ನಾವು ನೋಡಿರುತ್ತೇವೆ ಎಂದು ತಿಳಿಸಿದರು. ಅರ್ಜಿದಾರರು ಮೊದಲಿನ ವ್ಯವಸಾಯ ಭೂಮಿ ಸ್ವಾಧೀನ ಹೊಂದಿರುತ್ತಾರೆ ಅಂತ ಸ್ಥಳ ತನಿಖೆಯಿಂದ ದೃಢಪಡುತ್ತದೆ. ಸರ್ವೆ ನಂಬರ್ 22/1 ಸ್ವಂತ ಸ್ವತ್ತನ್ನು ತಿಮ್ಮೇಗೌಡ ಎಂಬುವರಿಗೆ ಪ್ರತಿವಾದಿಗಳು ಮಾರಿರುತ್ತಾರೆ. ಈ ಸ್ಥಳಕ್ಕೆ ಪ್ರತಿವಾದಿಗಳೇ ಹಕ್ಕಿಲ್ಲ. ಅರ್ಜಿದಾರರ ಹೆಸರಿನಲ್ಲಿ ಹಿಂದಿನ ಭೂಮಿಯ ನೋಂದಣಿಯಲ್ಲಿ ಕೇಳಿ ಹಕ್ಕು ನೀಡಿದ ನಂತರ ಮಾರಿರುತ್ತಾರೆ. ಆದರೆ ಸ್ವಾಧೀನ ಬಿಡಿಸಿರುತ್ತಾರೆ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಹಾಲಿ ಜಮೀನು ಅರ್ಜಿದಾರರ ಸ್ವಾಧೀನದಂತೆ ಕೇಳಿ ಹಕ್ಕನ್ನು ಭೂಮಿಯ ಬಿಡಿಸಿರುತ್ತದೆ. This is dated 6/1986. The spot inspection has been conducted with the land tribunal members, which has not been disputed by the.
What is the requirement? You will have to establish that as on the date and immediately prior to that, you are in possession as tenants. Adar ಬಗ್ಗೆ ಏನು ಇಲ್ಲ. 1986.
And they're not even disputed this document. They're not read any rebuttal evidence to either show that this.
No, that may be good for the year 1986, but that is not the requirement of law.
This is prior to this honorable court remanding the matter. Even before this honorable court, they have not disputed this document. Before this document, when the matter was remanded, the sought for remand purely.
The learned senior counsel is therefore relying on this judgment. That is what I said. The judgment, the first judgment that he was relying upon, it says the golden rules. The witnesses may lie, but the documents do not lie is the golden rule. So therefore, it may not be enough if you just have some oral evidence. For their benefit, they have produced the RTCs, which shows their names both in column number 9 and 12.
Then the presumption is rebuttable or made sufficient.
Correct.
And the.
ಅದನ್ನ ಹೇಳ್ತಾರೆ. What is that rebuttable presumption ಅಂದ್ರೆ?
6586 spot inspection which has not been disputed.
86 ಆಗೋದಲ್ಲ ಸರ್.
Even before this honorable court, they have not been that known by law. Even before this honorable court, this present petition, they have not disputed the document.
How can they dispute the document? What do you mean by disputing the document?
Clearly, the spot inspection has been held by issuing notice to them, in which they have also participated and they were present.
Spot inspection for that day.
And also,
that is not the requirement of law. Yes.
Submission to lodge place. Take into consideration the fact that these are 4 persons illiterates, and only because of the fact that their names are not known in the revenue entries, the other evidence cannot be.
That is why I said last time, that may not be the only way to prove your tenancy. There may be other methods also. So what is that method? If you have found out any other method and any other document in that regard or any other evidence in that regard, you please show. That may not be the only way to look into and find out whether there was any tenancy. That argument may not be accepted. Then what else have you brought on record?
4 illiterates, apart from examining their other neighboring landowners.
ಅವರು ಎಲ್ಲರನ್ನು ಕೂಲಿಗಳು ಅಂತಾನೆ ಹೇಳಿದ್ದಾರೆ. No one has stated that you are a tenant. That is ಮತ್ತೆ ನೀವ್ ಯಾರು ಕರ್ಕೊಂಡ್ ಬಂದ್ ನಿಲ್ಸಿದೀರಾ?
That's their case. It's their case. That's the reason why the landowner.
Which means you have not even brought any independent witness also.
They've been brought.
What have they said then? If it is there, please show then. If you had brought any independent witness, if you examined them and they have given a statement in your favor. ಇಲ್ಲ ಇದ್ದಿದೆ ಅಲ್ಲೇ ಹೇಳ್ಬಿಡ್ತಾ ಇದ್ರು ಬಿಡಿ that these witnesses have stated so and so ಅಂತ ಬರ್ಬಿಡ್ತಾ ಇತ್ತು ಅಲ್ಲಿ. In the previous order also it is not there.
Which is
ಇದು ಎವಿಡೆನ್ಸ್ ಹಾಕ್ಬಿಡ್ರಿ.
Section 109. It is exactly in this letter. What I have cited this is Raymond Gupta's page number 10. I will get it at the bottom. Para 16.
ಇದೆಯಾ ಏನಾರು ಇದೆಯಾ?
4586. Revision of the land rent. The evidence has been discussed in detail. Karnataka ಭೂ ಸುಧಾರಣೆ ಕಾಯ್ದೆ ಒಂಬತ್ತರ ಪ್ರಕಾರ 40.8 ಅರ್ಜಿಸಲ್ಲಿಸುತ್ತಾರೆ. ಅರ್ಜಿ ಪ್ರಮುಖತೆ ಇರುತ್ತೆ. ಈ ಬಗ್ಗೆ ಅರ್ಜಿದಾರರಿಗೂ ಜಮೀನಿಗೆ ಸಂಬಂಧಪಟ್ಟವರಿಗೂ ವಲಯರಿಗೂ ಸಂಬಂಧಪಟ್ಟವರಿಗೂ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಲಾಗಿ ಅರ್ಜಿದಾರರು ಸಂಬಂಧಪಟ್ಟ 24/76 ವಿಚಾರಣೆ ಕಾಲಕ್ಕೆ ಹಾಜರಾಗಿ ತಮ್ಮ ಹೇಳಿಕೆ ಕೊಟ್ಟಿರುತ್ತಾರೆ. ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕಲಂ 48(2) ಪ್ರಕಾರ ಅನ್ವಯ ಸಾರ್ವಜನಿಕ ಅವಗಾಹನೆಗಾಗಿ ಗ್ರಾಮದಲ್ಲಿ ತಹಶೀಲ್ದಾರ್ ಕಚೇರಿಯಲ್ಲಿ ನೋಟಿಸ್ಗಳನ್ನು ಪ್ರಚುರಪಡಿಸಲಾಗಿದೆ. ವಿಚಾರಣೆ ನಂತರ ಪ್ರಕರಣವನ್ನು ಹತ್ಯೆಗಾಗಿ ದಿನಾಂಕ 14 ನೀಡಲಾಗಿದೆ. ಅದರಂತೆ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಕೊನೆಯ ತೀರ್ಮಾನವನ್ನು ನೀಡಲಾಗಿದೆ. ಈ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಸಭೆಯನ್ನು 22/3/2022 ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಿಂದ ವಿಚಾರಣೆಗೆ ತಂದಿದ್ದು ಅದರಂತೆ ಮರು ತನಿಖೆ ಮಾಡಿ ತೀರ್ಮಾನ ಕೈಗೊಳ್ಳಲಾಗಿದೆ. ಬಿಡಿಕೆ ಅರ್ಜಿದಾರರಾದ ಮುನಿಮೇಗೌಡ, ಮರಿಗೌಡ, ಚೆನ್ನೇಗೌಡ ಇವರುಗಳು ಭೂನ್ಯಾಯ ಮಂಡಳಿಯ ಅರ್ಜಿ ಸಲ್ಲಿಸಿ ಕೇಳಿಯನ್ನು ಹೇಳಿರುತ್ತಾರೆ. ದಿನಾಂಕ 26/10/2022 ಭೂನ್ಯಾಯ ಮಂಡಳಿ ತನಿಖೆ ಮತ್ತು ಸಾಕ್ಷಿದಾರರ ಹೇಳಿಕೆ ಆಧಾರದ ಮೇಲೆ ಹೇಳಿಯನ್ನು ನೀಡಿದ್ದು ಅದರ ವಿರುದ್ಧ ಪ್ರತಿಪಾದಿಸಿ ಉಚ್ಚ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದರಿಂದ ಹಿಂದಿನ ತೀರ್ಪು ವಜಾ ಮಾಡಿ 17 ಪ್ರಕಾರ ತನಿಖೆ ಮತ್ತು ತೀರ್ಮಾನಿಸುವಂತೆ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ತಿಳಿಸುತ್ತೆ. ಅದರಂತೆ ಮರು ತನಿಖೆ ನಡೆಸಲಾಗಿದೆ. ಅರ್ಜಿದಾರರ ಹೇಳಿಕೆ ದಾಖಲು ಮಾಡಲಾಯಿತು. ಮೊದಲನೆಯದಾಗಿ ಮುನಿಮೇಗೌಡ ಅವರು ರೇವಣ್ಣ ಅವರ ಹೇಳಿಕೆ ದಾಖಲು ಮಾಡಲಾಯಿತು. ತಮ್ಮ ಹೇಳಿಕೆಯಲ್ಲಿ ನಾನು ಸರ್ವೆ ನಂಬರ್ 22 ಮುಂಚೆ ಜಮೀನಿಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸುತ್ತೇನೆ. ಈ ಜಮೀನನ್ನು 20 ವರ್ಷದಿಂದ ಕೃಷಿ ಸಾಗುವಳಿ ಮಾಡುತ್ತಿದ್ದೇನೆ. ರಾಜ್ಯದ ಜಮೀನಿಗೆ 2 ಖಂಡಿಗ 6 ಕೊಡುತ್ತಿದ್ದೇನೆ. ಈಗ ಕೊಟ್ಟಿಲ್ಲ, ಮರಳಿ ಯಾರಿದೆ ಎಂದು ನೋಡಿಕೊಂಡಿಲ್ಲ. ಆ ಜಮೀನನ್ನು ನಾನು ನಾಯಿ ಸಾಗುವಳಿ ಮಾಡುತ್ತಿದ್ದೇನೆ. ಗುತ್ತಿಗೆ ಪತ್ರ ಇದೆ ಎಂದು ತಿಳಿಸುತ್ತಾರೆ. ಪ್ರತಿವಾದಿ ಉತ್ತಮನ ಪಾಟಿಸ್ವಾಮಿಗೆ ನಾನು ಗುತ್ತಿಗೆ ಪಟ್ಟಿದಾರರಿಗೆ ಕೊಡುತ್ತಿದ್ದೆ ಎಂದು ತಿಳಿಸುತ್ತಾರೆ. ಅರ್ಜಿದಾರರಿಗೆ 1969ನೇ ಇಸವಿಯಲ್ಲಿ ಪ್ರತಿವಾದಿ ಶ್ರೀರಂಗಯ್ಯ ಗುತ್ತಿಗೆ ಪತ್ರ ಕೊಟ್ಟ ಸರ್ವೆ 22ರ ಜಮೀನು 2/22 ವಿಸ್ತೀರ್ಣವನ್ನು ಬಿಟ್ಟುಕೊಟ್ಟಿರುತ್ತಾರೆ. ಅದನ್ನು ನಿಶಾನೆ
ಏನೋ ಗುತ್ತಿಗೆ ಪತ್ರ
ಅರ್ಜಿದಾರರಿಗೆ 69ನೇ ಇಸವಿಯಲ್ಲಿ ಪ್ರತಿವಾದಿ ಶ್ರೀರಂಗಯ್ಯ ಗುತ್ತಿಗೆ ಪತ್ರ ಮಾಡಿಕೊಟ್ಟ ಸರ್ವೆ ನಂಬರ್ 22ರ ಜಮೀನು 2/22 ವಿಸ್ತೀರ್ಣವನ್ನು ಬಿಟ್ಟುಕೊಟ್ಟಿರುತ್ತಾರೆ. ಅದನ್ನು P1 ಎಂದು ಗುರುತು ಮಾಡಿದೆ.
ನೋಡಿ ಹಂಗಾರೆ ಇದೆಯಾ ಅದು ಡಾಕ್ಯುಮೆಂಟ್? ಎಕ್ಸಿಬಿಟ್ P1 ಅಂತ ಮಾಡ್ಕೊಂಡು ನೋಡಿ. ಅಲ್ಲಿ ಮೇಲೆ ಇದ್ರ ಮೇಲೆ ಇಟ್ಕೊಳ್ಳಿ, ಆ ಸ್ಟ್ಯಾಂಡ್ ಮೇಲೆ ಇಟ್ಕೊಳ್ಳಿ, ಅಲ್ಲೇ ಇಟ್ಕೊಳ್ಳಿ. but there is a finding that ಗುತ್ತಿಗೆ ಪತ್ರನ ಎಕ್ಸಿಬಿಟ್ P1 ಅಂತ ಮಾರ್ಕ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ. ಗುತ್ತಿಗೆ ಪತ್ರ
ಅರ್ಜಿದಾರರಿಗೆ 69ನೇ ಇಸವಿಯಲ್ಲಿ ಪ್ರತಿಭಾ ಶ್ರೀರಂಗಯ್ಯ ಗುತ್ತಿಗೆ ಪತ್ರ ಮಾಡಿ ಕೊಟ್ಟ ಸರ್ವೆ ನಂಬರ್ 22ರ ಜಮೀನಿನ 2 ಎಕರೆ 22 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣವನ್ನು ಬಿಟ್ಟುಕೊಟ್ಟಿರುತ್ತಾರೆ. ಅದರ ಸೀಮಾ
Is not ಗುತ್ತಿಗೆ ಪತ್ರ. If I really check it.
ಅವ್ರು ನಿಮ್ ಇವ್ರು ಅಲ್ಲೇ ಇದಾರೆ, ಅಡ್ವೊಕೇಟ್ ಆನ್ ರೆಕಾರ್ಡ್. ಏನ್ರಿ ರಾಜು ಅವರೇ, ನೀವು ಒಂದ್ಸರಿ ಓದಿ.
ಅದಿದ್ರು ಸಹಿತ ವಿಟ್ನೆಸಸ್ ಏನ್ ಹೇಳಿದ್ದಾರೆ, ಯಾವುದೇ ಗುತ್ತಿಗೆ ಪತ್ರ ಇಲ್ಲ ಅಂತಾನು ಬಂದಿದೆ.
In the first order, he is reading the first order now. The original first order, ಅದರಲ್ಲಿ ಆ ತರ ಫೈಂಡಿಂಗ್ ಇದೆ.
ಗುತ್ತಿಗೆ ಪತ್ರ ಮಾಡಿ ಕೊಟ್ಟ ಸರ್ವೆ ನಂಬರ್ 22ರ ಜಮೀನು 2 ಎಕರೆ 22 ವಿಸ್ತೀರ್ಣವನ್ನು ಬಿಟ್ಟುಕೊಟ್ಟಿರುತ್ತಾರೆ. ಅದನ್ನು
ಅದೇ ಯಾವ್ದನ್ನ P1 ಅಂತ ಗುರ್ತು ಮಾಡಿದ್ದಾರೆ, ಗುತ್ತಿಗೆ ಪತ್ರನ ಇರ್ಬೇಕು, ಇನ್ನೇನಿದೆ ಅಲ್ಲಿ. ಸೊ therefore ಗುತ್ತಿಗೆ ಪತ್ರ ಇದ್ರೆ ಅಂದ್ರೆ then it is a ಹೌದು. Yes.
Clarify the position. So far as
See, nothing has been said after that. ಈ ತರದ್ದು ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಇವರು ಅಧ್ಯಕ್ಷರು ಹಂಗೆ ಹೇಳಿದ್ರು, ನಾವು 3:1 ವಿ ಆರ್ ಸೇಯಿಂಗ್ ನೋ ದೇ ಆರ್ 10. ಹೆಂಗೆ, ಹೌ ಕ್ಯಾನ್ ಬಿ?
this may require clarification from my side.
Therefore, that cannot be done here now. At a undisputed point of time in the first order, if they are stated that there is a document marked as exhibit P1.
I will see that document. So the limited purpose, what is it? Because
ಅಲ್ಲ, ಅದಕ್ಕೆ ನಾನು ಕೇಳಿದೆ, ಬಟ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಫೌಂಡ್ ದೇರ್ ಅಂತಾರೆ.
document ತಾವು ನೋಡಿದ್ರೆ then
ಇದ್ರೆ ಐ ವಿಲ್ ಗೋ ಥ್ರೂ. ಯು ಪ್ಲೀಸ್ ಸಿ ಇಫ್ ಇಟ್ ಇಸ್ ದೇರ್. ಇಫ್ ಇಟ್ ಇಸ್ ನಾಟ್ ದೇರ್, and what should we do then now?
spending time on looking for papers, maybe if I not to grant the evidence to have it tomorrow.
ನೀವು ಒಂದ್ಸರಿ ನೋಡ್ರಿ, ನೀವು ನೋಡಿ, if it is there, you please mark it and keep it. Exhibit P1 ಅಂದ್ಬಿಟ್ಟು ಗುತ್ತಿಗೆ ಪತ್ರ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಸಿಕ್ಕಿದ್ರೆ you please mark it and keep it.
And definitely they are relevant paper, provided it is there and it is.
ಅಲ್ಲ, ಇಲ್ದೇ ಇದ್ರೆ then how do they record that finding?
That's how an non-judicial.
No, ಅಲ್ಲ ಹಂಗ ಅಷ್ಟು ವಿ ಕಾಂಟ್, ಆ ಎಕ್ಸ್ಟೆಂಟ್ ಗೆ ನಾವು ವಿ ಕೆನಾಟ್ ಪ್ರೆಸ್ಯೂಮ್.
ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಇದ್ರೆ ಅಥವಾ ಡಾಕ್ಯುಮೆಂಟ್ ಇಂಪ್ಯಾಕ್ಟ್ it may be kindly taken up subject to convenience.
ಬರ್ಕೊಳ್ಳಿ.
Another submission to be made by the minister which we have some provision.
Purchaser. So now the land that you have purchased, ಅದನ್ನ ನಾವು it has been occupancy rights have been granted to them. ಅದಲ್ವಾ? All right. The learned senior counsel, Mr. Shankar Narayan Rao, has sought to place reliance on 2 judgments of the Honorable Supreme Court. You please note it down and you please go through that, because they have not given a citation.
ನಾವು ಕಾಪಿ ಕೊಡ್ತೇವೆ.
ಕೊಟ್ಬಿಡಿ, please give a copy to.
Carry sufficient.
Yes.
Is your duty.
In the case of Sri Pratap Singh and others versus Shivram, in civil appeal number 1511 of 2020, dated 20th of February 2020, and Nadakerappa and others versus Pillamma and others, civil appeal number 7657-7658 of 2017, dated 31st of March 2022. Stop. A copy of the same is served on the learned counsel for the contesting respondent. Stop. Next para. While going through the original records, the learned counsel for the contesting respondent has read out a portion of the first order passed by the second order passed by the Land Tribunal on 14/5/1986, wherein it is stated that the lease deed between which is that party? ಅಲ್ಲ ಅದಕ್ಕೆ ಮೇಲೆ you read out that name. ಅದು ಯಾವ್ದು ಹೆಸರು ಓದಿದ್ರಿ ನೀವು? ಅದಕ್ಕಿಂತ ಮುಂಚೆ please read one sentence before that. ಹನುಮೇಗೌಡ ಯಾರ ಹೇಳಿಕೆ? he is also an applicant. ಹಂಗಾದ್ರೆ ಅವ್ರದ್ದು ಪ್ಲೀಸ್ ಡಿಟ್ ಯಾರು? ಹನುಮೇಗೌಡ ಏನ್ ಹೇಳಿದೆ?
Going through the original records, the learned counsel for the contesting respondent has read out a portion of the second order passed by the Land Tribunal on 14/5/1986, wherein it is stated that the lease deed between
the one of the claimants, Hanumegowda, and ಆಯ್ತು, there is some document and the landlord is marked as exhibit P1. So, however, the learned counsels are unable to point out to the said documents from the original records. Full stop. The learned HCGP is directed to go through the original records thoroughly and mark if such a document is marked as exhibit P1. Full stop. Release this matter. Have day after tomorrow on 22nd at 2:30 p.m.
A special bench matter on 22nd, the PDA matter, maybe I will, if possible, if it could be accommodated on some other day. If possible.
27th. 27th. Finally, a reach time is granted to the petitioner. Take steps for service of notice on respondent number 1. ಅದ್ ನೋಡ್ರಿ ಯಾರು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಯಾರು ನೋಡ್ರಿ ಅದ್ರಲ್ಲಿ ಆ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ? ಪ್ರೈವೇಟ್ ಪರ್ಸನ್? ಸರಿ ಆಯ್ತು. Same order in respect of R3A. Same order in respect of respondent number 7.
Where is 14?
Same order in respect of respond number 3.
5, 7 yes. 13.
In respect of R3, 4, 5, 7, 8, 16 and 19. Unserved response ಅಂತ ಹಾಕೊಂಡಿದ್ದೀನಿ. Yes.
6. Sanjay Kumar. 4, 13.
Respond number 4.
Group Akshaya, 8. R2. R2 to 4.
Huh? You have taken steps. Yavaga. Learned counsel for the petitioner submits that the steps have been taken for service of notice on response number 2 to 4 this morning. Full stop. Office to verify and issue notice. Respect of R4, 5 and 7. In respect of respond number 6, 6 to 8. Yes.
Number 1. Order. 24. Tisha Paliga, 8. Allotment.
Regarding the condition of non-alienation for a period of 25 years.
But that circular may not be applicable to these facts because it was under a separate rules. South Canara district lease of land of cashew nut cultivation rules 1957. Huh? Huh. ಅಲ್ಲ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಯಾಕೆಂದ್ರೆ ಆಫ್ಟರ್ 30 years of lease
importance of this giving particular land for purpose of cattle cultivation. Once they complete the development and we give a permanent right over the property. Even they photo that they have to continue with cultivation and cattle cultivation. ಅದಕ್ಕೆ ಈ section this condition of non-alienation the time of granting the certificate permanent certificate. The land will be granted permanently for you, but you have to involve in cattle cultivation. ಅದಕ್ಕೆ ಈ condition ಆಗುತ್ತೆ.
I don't think such kind of a executive order can be made contrary to the rules. On the previous occasion, this court had directed the learned AGA to secure instructions having regard to the fact that the rules, the relevant rules, 1957, under which lease was granted in favor of the petitioner, do not provide for a subsequent imposition of non-alienation period of 25 years. And therefore, the circular dated 23/4/2005 seen in condition number 2 may not be relevant to the facts of this case. So, learned AGA seeks for some more time to secure a copy of the circular dated 23/4/2005 and make submissions. Full stop. Release this matter on 27th of February.
On amendment.
Take a 3 days time and then the petition will be filed.
Finally, a week's time is granted at the request of learned counsel for petitioner for compliance of the orders dated 27/2022. You will have to furnish amended cost title and amend this. Please do it tomorrow itself.
Amendment.
Waiting for.
Amendment of WP.
Amended petition, I am told, my lord, is filed. They will have to carry out physically, my lord, if they order in the original file. Amended petition is already filed. It cost it.
Petition amend ಆಯ್ತಾ? Learned senior counsel appearing for the petitioner submits that the amended writ petition has been filed on 12th of December 2023. But amendment has not been carried out in the cost title. So, learned counsel shall it may not be possible to carry out the amendment in the writ petition because
Cross permits, they will carry out the amendment.
Allah, what is that amendment?
Cost it.
Very cost title.
Cost it.
Very cost title.
R5 is dead, my lord. Their legal representatives are already on record.
ಏನಲ್ದೆ?
Senate Penal Council appearing for the petitioner submits the amended petition has been filed on 12/12/2023 to but amendment has not been carried out in the cost title.
Stop. The learned counsel on record may carry out the amendment in the cost title. On 17 matter. Tagalla, sir. We will we will fix a date. You please come. Is this matter for final hearing? It should come in B group. B group bandila in. Is this matter for final disposal on 26th of February, Monday?
Yes.
Yes.
My lords, I appear for the petitioner, my lords. In this matter, we have filed a LR application, my lords. The compliance is that we have not served the copy to the respondents. Notice has to go in this matter, my lords.
This is respondent number 5.
Please, my lords. Respondent number 5.
Advocate is not on record.
My lords will rectify, will verify it, my lords. A week's time may be granted, my lords.
Who has filed this application?
My lords, it has been filed in the name of Akash Kumar Gowda, my lords. Senior counsel R.S. Ravi was designated And invariably, my lords, the wakalat has been transferred to the next junior. He has left the office, my lords. That's why it has been filed under Akash Kumar Gowda's name. We'll verify, my lords. We'll file another wakalat, my lords. We'll verify it.
A week's time is granted at the request of learned counsel for petitioner for compliance of the office objections raised on IA number 1 of 2023.
Please, my lords.
Yes. The only petitioner number 2 has filed, is it? The petitioners and learned counsel for petitioners have filed a memo dated 7/2/2024 stating that as per the undertaking given by the petitioners in OS number 236 of 2008, the matter has been compromised between the parties. Therefore, the petitioners are seeking leave of this court to withdraw the writ petition as not pressed. Full stop. Next para. The memo is taken on record subject to all just exceptions. Accordingly, the writ petition stands dismissed as not pressed. Rectification. ಏನು office objections? Copy not served or no? You have filed the applications, isn't it? Huh? Petitioner number. So I will purple. WP number 14347 of 2020. What is file? Order on IA number 1 of 2023. This application is filed. By the applicant. Come on record as the legal representative of deceased petitioner number 2, Sri M. Venkataswamy. In the Laurdo. Stop. It is stated in the affidavit accompanying the application that the second petitioner, Sri M. Venkataswamy, ಏನ್ರಿ ಎಲ್ಲ ಏನನ್ನ ಬದಿದ್ರಾ to come on record 13 pages ಬರ್ದಿದ್ದೀರಾ died on 15/10/2023 and the application is filed within time. Stop. The application is allowed and the proposed petitioner is permitted to be brought on record as the legal representative of deceased petitioner number 2. Have you stated that you are the only legal representative? Huh? The counsel for the petitioner shall carry out the amendment in the cost title and furnish amended cost title within a period of 1 week from today. What about this one? Our application. Being LRs of respond number 9. Who was appearing for respond number 9? Our petitioner, who is respond number 9? Venkat Swami. Huh? Then you please take notice on that IA and we will allow the application. First petition orders on IA number 1 to 3. 2 to 6 of 2023. Nimmaluno IA number 1 to 3 to bring on record LRs of petitioner number 6. Adu ide. First adhan barkale. Orders on IA number 1 to 3 of 2023. These applications are filed to bring on record the legal representatives of deceased petitioner number 6. Only 6. There is a delay of 325 days in filing the application. Stop. Being satisfied with the explanation offered in the application seeking condonation of delay, the applications are allowed while setting aside, while condoning delay and setting aside abatement. Full stop. Consequently, all the 3 applications are allowed while permitting the legal representatives of deceased petitioner number 6 to come on record. Orders on IA number 4 to 6 of 2023. Nine Venkat Swami. These applications are filed to bring on record the legal representatives of deceased respond number 9, while seeking condonation of delay. Aurena? You 1 of 2020 ನೋಡ್ತಾ ಇದ್ರೆ ಅದಲ್ಲ ಅದಾಯ್ತು 4 to 6 ನೋಡಿ 4 to 6 ಯಾರು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 9 ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಹಾಕಿರ್ತಾರೆ ನೋಡಿ ಅವರೇನಾ ಎಂ ವೆಂಕಟ ಸ್ವಾಮಿ ದಿ ಲೀಗಲ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ ಇದು ಡಿಲೇ ಎಷ್ಟಿದೆ and to set aside abatement. Stop. In the connected writ petition, respond number 9 herein is the petitioner, and by an order of event date, the legal representative of late Sri Venkat Swami was permitted to be brought on record. Full stop. Learned counsels for the contesting respondents submit that the application may be allowed. Full stop. Accordingly, the application is allowed while condoning delay and setting aside abatement. Next para. Learned counsel for petitioner shall carry out the amendment in the cost title and furnish amended cost title within a period of 1 week from today. Yes. Yeah. ಆಯ್ತಲ್ರಿ ಅದನ್ನೇ ಫಸ್ಟ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದು ಕನೆಕ್ಟೆಡ್ ರಿಪಿಟೇಷನ್ ಅಲ್ಲಿ. ವಾಟ್ ಸರ್ 2020 ಮ್ಯಾಟ್ರ್. ಇದೇನಾ ಅವಾಗ್ಲೇ
Yes, my lord. So it's unconditional apology, my lord. We are our duty bounded. Lordship direction has to be implemented, my lord. And concerned department, we have brought to the notice also about the directions of the civil court, my lord. The chief secretary is involved in the budget sessions. My lordship is aware that the process of the budget session, that is a delay, my lord. And in the few days, my lord, granted the time and we will submit the my lord.
ಅಲ್ಲ ಡಿಲೇ ಇವಾಗಲ್ಲ. That order was passed when?
It is in 2023, my lord. The directions of the honorable court, my lord.
31/8/2023.
Immediately
giving you time for about 3 months. 3 months.
Please, my lord. We are agreed, my lord. We are agreed and we are bound to be do it. It's our bounded duty.
No.
So we will the few days, my lord. We are going to be give us the what is the development have been taken in this case. One few days time, the next week by this same day.
Technically,
my
the
lord,
chief secretary should have filed necessary application or at least a memo
please, my lord.
seeking extension of time.
Please, my lord. I agreed, my lord.
No. If no action has been taken prior to expiry of that date, you should have filed one application or at least a memo seeking extension of time. ಏನು ಮಾಡಿಲ್ಲ ನೀವು. You do not know what you have done.
Next week, I will communicate to my lord, the concerned officer. I will get the information. I will submit to your lordship, my lord. Next week, to
things are taken so lightly, it is very difficult.
No, my lord. We have taken the step. That's what I personally apologizing to this honorable court, my lord.
Very fact that this court has come down heavily on the deputy commissioner and sought action against the deputy commissioner, you should have become very alert.
We have communicated, my lord. Then at the moment of the order of this honorable court, the next
You
day,
have not placed anything on record.
My lord, 1 week time, my lord.
From the past 2 times you have taken adjournment, you have not even stated what you have done till now.
I agreed, my lord. My colleagues, I mean, I have taken the time, my lord. And next week, we will represent the matter with the papers, my lord.
No.
My humble prayer, my lord. The unconditional apology. It's a mandatory duty for us to be.
I will refer the matter for contempt before the division bench. Let it go before the division bench.
One week time, my lord. 1 week time, my lord. Within 1 week time, my lord, we will.
So even today, there is nothing coming from the side of the government to show what is the action. ಎಲ್ಲವರೆಗೂ ಬಂದಿದ್ದೀರಾ ಅಂತ ತೋರ್ಸಕ್ಕೂ ಏನು ತರ್ತಾ ಇಲ್ಲ ನೀವು.
I unconditional apology, madam. I'm stuck in the Gulbarga, my lord.
There is nothing except saying no. We need some more time. You have not brought even today any information.
We got the unconditional apology, madam. The situation because I stuck with the nice road matter only in the Supreme Court today, my lord. I'm unable to communicate also. My humble permission. So next week, my lord, we will whatever the my lord will submit it personally, my lord. Will come and submit.
Go and submit before the division bench in the contempt.
My humble submission, my lord. My humble submission, a week's time will be granted, my lord. The unconditional apology for not communicating. This is unconditional apology, my lord. The situation, and we will personally represent the matter. It is our bounden duty to be comply the directions of this honorable court, my lord. We will communicate, my lord. Humble submission, my lord. Week's time may be granted, my lord. Next week only we will personally represent the matter before our lordship. Finally, one chance may be, please.
In spite of this court adjourning the matter twice, calling upon the Chief Secretary, Government of Karnataka to state as to what action was taken against the Deputy Commissioner consequent to the orders passed by this court. Nothing is forthcoming till date. Full stop. On the other hand, the learned additional Advocate General would request that due to the ongoing budget session, the learned additional advocate general was not able to secure instructions. Full stop. Next para. As noticed earlier, order was passed on 31/8/2023, granting 3 months time to the state to take action against the deputy commissioner and file a report. Full stop. That period expired on the last date of November 2023. So, no application has been filed from the state seeking extension of time. No information is made available as to the present stage of action initiated against the deputy commissioner. Full stop. This court is of the considered opinion that contempt proceedings have to be initiated against the chief secretary, government of Karnataka.
Weeks time, full prayer, weeks time, please.
For
Next week, if it is not submitted,
court. Stop. Nevertheless, at the request of the learned additional advocate general, released this matter on 26th of February 2024. No further adjournments will be granted at any cost.
Please, my lord. Grateful, my lordship.
Huh? Huh? ನಿಮ್ದೇನಿದೆ ಇದರಲ್ಲಿ? Matter has been disposed of. It is only for finding out what action has been taken by the state. ನಿಮ್ದು ಏನು ಇಲ್ಲ, ರೋಲ್ ಇಲ್ಲ. Yes.
As far as the postal tracking on the website of this honorable court, respond number 67 on 38th August 23 minutes.
Huh?
38th August 23. Respond number 67 minutes. I produced the memo on 27/1/24. Producing the postal track. It's only year nominee. Assistant commissioner is made as the party person as respond number 6, respond number 3.
ಯಾವ ಮೆಮೊ ಬಂದಿಲ್ಲ ಇಲ್ಲಿ?
27/1/24 I signed a memo.
Yeah. Assistant commissioner.
Year nominee. He has made a year nominee. Respond number 6. Next page, 5 number 8. Karnataka. We have the 23 items delivered.
Learned counsel for the petitioners has filed a memo dated 27/1/2024 along with the postal tract to show that the notice sent to respond number 6, the assistant commissioner, Bangalore North Taluk, have been delivered on 4/9/2023. Full stop. Therefore, the notice sent to respond number 6 is taken as sufficient.
minutes, that application minutes may be permitted. Some corrections will not be prior as to ranking of respondents. File of rules, design,
ಎಲ್ಲಿದೆ IA3?
ಇಲ್ಲಿ put up ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಹಾ?
ಮಾಡಿಲ್ಲ, ಇಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ? ಎಲ್ಲಿದ್ದಾರೆ IA3? ಅಲ್ಲಿ ಹೆಂಗೆ ಯಾಕೆ ಸಾಧ್ಯ? To rectify the respondent's number.
where we exceed ranking of the respondent.
Order on IA number 3 of 2023. This application is filed by the petitioner seeking to rectify some of the typographical errors that have occurred in the prayer column. So the designated number of the respondents have been wrongly shown in the prayer column. Full stop. Next para. The application is allowed, permitting the petitioner to carry out the amendment in the prayer column. Full stop. Yes. Interim order granted earlier. Till next date. Non-filing of acknowledgement. Ah. Then AG submits that he has received copy of the writ petition. Interim order granted earlier stands extended to the next date of hearing. Same order. ಅಲ್ಲಿ ಇನ್ನೊಂದು ಸೇರಿಸ್ಕೊಂಡ್ಬಿಡಿ. Learned counsel for the petitioner submits that he has also served a copy on learned counsel Sri PS Malipati. Yes. Yes. Huh?
There are inquiry details and there is no such inquiries continued. The inquiry related to the grant was held from 2015 to 2018. So far as the grant is concerned with in favor of the petitioner, no such inquiry is pending. And there is a confusion between the authorities who has.
You are required to file affidavit. Huh?
I inquired his officials also.
At the request of the learned AGA, released this matter on 27th of February 2024 to enable filing of necessary affidavit as directed on 6/2/2024. We will see all other matters next week.